Hey, what's up, guys? Welcome to Lost Planning the Interwebs. I am your late host, Nick Ricada of Ricada Law, a small law firm in central Minnesota. I hope you guys are doing well today. We've got a guest with us already. Welcome to the show, Mr. Andrew Bronca.
Happy to be here. Just here to explain what the white pages are.
That was the oldest thing that could have been said yesterday. Oh my goodness. So how's it going, man?
Well, they're tearing my house apart because of the flooding we've previously discussed, but otherwise it's going great.
Good, good. What's your impression of the trial so far? Because we're now a couple days in. We've had some drama at the end of yesterday's show, I guess. And yeah, so
I felt at the end of yesterday, frankly, like the defense got kind of bamboozled by the state over the course of the day with this whole. They spent the day obviously on evidence that's irrelevant to the actual criminal charge. The defense objected throughout the day that it was cumulative and relevance, and but the judge appears to be something of a pushover and for the state, and not constraining the state very much. And of course, when you have, let's face it, you want to give both parties the opportunity to explain their theory of the case. You don't want to act as a brake on their storytelling unnecessarily. So I get it. It's normally kind of presumed that what the state or either party will be presenting will ultimately bear some relevance to what's actually at issue in the case. Of course, that never seemed to happen. I mean, they spent the whole day talking about a traffic accident that occurred after the reported reckless conduct. And then at the end, the state justifies all this by saying that, well, it is relevant, Your Honor, but not to the criminal charge, but to the Blakely factors. The sentencing enhancement we'll be looking for after this defendant is found guilty, which really struck me as completely pretextual. You don't need a full day of evidence on Blakely factors, which only would be relevant anyway if the defendant's already proven guilty. So
yeah, and it seems those Blakely factors could be done at a sentencing hearing post verdict,
and that's normally how it's done. It's normally done with a motion is made to the court, and the judge, in theory, the defendant could have a separate jury finding on that, but nobody does that because it's only relevant if you've just been found guilty by the jury. So a jury that just found you guilty of the crime is unlikely to be sympathetic on the Blakely factors. So normally you want a legal technician to address the Blakely factors if the jury's already gone against you. So you have the judge do it. And normally it's just done by motion. I mean, that's how they did it with Derek Chauvin. They hit him with a sentencing enhancement, Blakely factors too. But it was never argued in front of the jury. I think it's being argued here in front of the jury because, let's face it, what does the state have to talk about? I mean, the actual issue in this case is it should be like a 5-minute trial, right? The real question is, we all know what the conduct was. We all know the circumstances. You watch 1 minute of video when you know everything there is to know about this case, really. The question is, well, does that amount to recklessness, to criminal conduct, to culpability, to manslaughter? And that's really a legal question. I mean, I don't actually see the facts, the relevant facts, in dispute in this case. And I think it's really a travesty that the judge is not defining the legal question, because once it's defined, you effectively have your answer.
Right. It was interesting to see them go through the entire day. and the chat's picking up on it. They're like, what's the relevance here? And it's it's, well, I guess they're trying to maybe establish that there was reckless conduct because it did cause injury to someone else in some sort of attenuated fashion with this. Well, she shot him and that caused him to go driving into someone else. And so therefore, I mean, it's not legal evidence of recklessness, but that's what the state seems to be trying. And the other thing was, of course, let's play every body cam footage that we can possibly muster of this guy dying or being dead.
Yes, right. So show it again and again and again and again and again, his body getting dragged out of the car. And surely she has to be guilty of something, right? I mean, this is a trick we see these prosecutors use all the time. They take one piece of evidence and they multiply it into 100 pieces of evidence, right? We saw it in Rittenhouse with the drone video. Suddenly the drone video was available in 50 different forms, slowed down, sped up, zoomed in, zoomed out, enhanced, not enhanced, then the still photo versions of all of those. And we're seeing that here with the police body cams, right? Not only one guy's body cam, but also his dash cam, and then a composite of both, and then a mix of that with the security camera from the neighbor across the street, and it's all the same stuff. I mean, the neighbor's camera in particular was ridiculous. You're looking at a big tree, and I guess there's a car accident on the other side of the tree that you can't see.
Yeah,
and,
all you can kind of see the white car like roll out after the accident. I love that question. How did you know that there was a collision? It's like,
how did you know there was a car crash? The crashed cars.
Cars aren't usually on the yard.
Not on the sidewalk in pieces, so completely crumpled.
So the it culminates though with the defense yesterday making a motion for mistrial, which they were going to lose that motion. The judge, I think, like Rittenhouse, the judge is going to be doing about everything that they can to let this go to jury, because I think the judge knows the political nature of the charge.
I mean, mistrial really can't happen in the sense that a judge that would be inclined to grant a mistrial under these conditions would never have allowed this to go this far. Right. They would have told the state long ago, listen, you either need to explain to me where you're going with this, or it is just cumulative evidence, and you stop. By the time you get to the third police officer and more, another 40 minutes of body camera footage of the same event, it's enough.
Yeah. So I'm curious how the state's going to react today, if they're going to keep on with that approach. I don't know what their witness list looks like, but it seems like they probably had, another pool of 10 more officers and 5 more EMTs at least that they could ask the same questions to if they're going to keep going.
Well, listen, I think what the state is doing is despicable here, but if I were the state, I would just keep rolling out officers until someone told me to stop. I mean, I'm in the game to win, right? So until the judge says no. I mean, just yesterday, Eldridge, they clearly had a sidebar, or maybe they even went into chambers, and the judge clearly told them, listen, this is getting cumulative. I only want verbal testimony on stuff that would otherwise be cumulative. No more, no more of this stuff. And Eldridge comes out immediately and starts offering photographs, screen captures from the video, and then goes, oh, Your Honor, I misunderstood. I thought you didn't want video cumulative evidence, but I thought photographic cumulative evidence would be fine. I mean, they're just going to keep pushing until, they're definitively told to stop.
Right. And so that's what I'm wondering, if they'll do it, if the judge will stop it, or if we're going to have another 8 hours 7 hours stay. We're truncated by an hour. But if we'll have 7 hours of nonsense.
Again, what else do they have to talk about? I mean, I think that's really the issue. I guess, are they going to call Sergeant Johnson to testify? I mean, he's obviously a firsthand witness. I guess he would have something to say.
Yeah, it's surprising that he hasn't been called in. They have an expert. So they could call their expert if they feel like it, I suppose. but yeah, it's I was shocked at how many witnesses they were calling in the first place, because the actual firsthand witnesses to this event are Passenger, Kim Potter, Johnson, Lucky, and that's it.
That's it.
But they managed to pad that out. Bringing the daughter of the other driver was pretty egregious. What does this person have to add to the factual basis? She received a voicemail after the fact that she didn't listen to, and then went to her mom's house at night after she and her dad were going to sleep.
I mean, I could imagine if there was some foundation, you had a doctor come in and say, oh yes, this car accident caused his mental issues. And then you might have the daughter come in to testify as to the extent of the, mental disability that's resulted from her personal knowledge of that. But there was never any foundation at this accident. This guy was apparently having, I mean, let's face it, some people get to a certain age and their cognitive function declines rather abruptly. Yeah, that appears to be this guy's situation. I've seen no evidence that the accident, accelerated that or triggered that, or we're just supposed to assume that's the case, right?
Right. And oftentimes what you'll find is that what I've seen, I guess, happen is the cognitive decline was already there, but everybody around was in denial of the decline until an accident makes them physically infirm for a little bit. And then it kind of,
they're looking for things then.
Right. It breaks the reality for them, or the illusion for them that they're okay. And suddenly it's like, oh yeah, they're not able to hide their mental infirmity by just walking in another room.
And they can blame it on something else, right? It's
Right.
not my loved one suddenly degrading in a tragic way. It's the car accident did it.
Exactly. So what do you think about this whole the state's going with the taser in the car argument is bad. If they use a taser on the driving victim, then that is way outside the bounds. That's the state's theory. Of course, when they asked Officer Lucky if he would have deployed his taser, he said, yeah, if I could have.
Sure. And I presume the defense will bring a use of force expert in to talk about these things. I think the state's making a lot of very weak arguments because they don't have a strong argument to make on this. When she makes the decision to use the taser, when she tases him, what really matters is not the circumstances at the moment the probes strike him. What matters is what were the circumstances at the moment, half a second before, when she made the decision, and the car was not moving then. So he was fighting for control, the ability to operate the vehicle, but he wasn't yet operating it.
Right.
It's a different circumstance than if the guy's in the seat, the car's in gear, his foot's on the brake, holding the car in place, and she just decides to tase him because he's mouthing off, and then his foot rolls off the brake, the car rolls away, and that's not what happened here. There were imperatives, apparently, she would say, I guess, when she testifies, that led her to believe a taser was an appropriate use of force under these circumstances, and I think a taser almost certainly would have been.
Yeah.
Of course, the tragedy is we heard a bang instead of a zap.
At the time she tases him, tases him with a bullet.
Right.
At the time she does that, his left foot is still up halfway out the car, I believe. Like, he's crunched up. That's the whole thing. The other thing that annoys me about their taser argument, and by the way, what's up, Kurt? Welcome to the show.
Hey, good morning. I see we're still slicing time really thin over here on the channel, so that's fine.
Well, the other thing that gets me is, so they say that they're making a big deal out of the fact that he was shot in the chest because you shouldn't tase someone in the chest. But when you look at the circumstances, she looks like she's aiming center mass, but the guy he's just crunched up into this weird shape. And they're going to try and make it out like, oh, she totally tried to tase him in the chest. If she could have, she would have tased him in the genitals. Right. Like that's
I hate to put it this way, but those are really best understood as guidelines. I mean, those are target areas that you try for if you have the luxury. A lot of taser use is very slow paced events. There's guys just not being cooperative with an arrest, standing 10 or 15 feet away, maybe with a knife in their hand. The cops don't want to get too close, but they can't leave that guy where he is because there's a park or whatever. And so they're trying to talk him down, and eventually everyone starts getting tired and they decide they're going to tase him. There'll be a cop with a taser. Next to the cop with the taser, there'll be a cop with his gun out for when the taser doesn't work, because they often don't work, folks. Very often, especially if the person you're trying to use it against knows the techniques to make it not work. It's not that complicated.
Or wearing
and then
loose clothing.
The cop with the taser has the luxury of saying, all right, I'm going to aim here or aim there, use the laser guided sight that's projected from the front of the taser. But in a fast moving, violent event, you don't have the luxury of that. You use the taser as best you can under the circumstances, given the target areas available to you.
Right. And he was wearing a denim jacket and a t-shirt of some sort. If those prongs hit that denim jacket, that taser is not going to work. If one of those prongs hits the denim jacket, it likely will not penetrate into his skin, and therefore it'd be completely useless.
Right.
So it's a weird situation. I think what the defense did, they did this on the first day with Officer Lucky. They established the two things. The defense has established the two things that they need for closing argument already. That Officer Lucky would have deployed the taser. Therefore, Potter is presumed to be justified in deploying the taser because another person who would use force and has sufficient training would have done the same thing. And then they established that Officer Lucky and Officer Johnson were in the vehicle at the time of the shot, and that that would presumably give justification for the deadly force if she had intended to use deadly force. And they
Right.
can make that argument before the jury in their closing just based off of Officer Lucky's testimony. So all they need now is an expert to go ahead and verify those things as proper uses of force. And then they've got, the defense already has all they need at that point for close. It's just a matter of getting the jury on their side.
Yeah. So the state's really making so it's a big stretch here, right? When we think about recklessness with a firearm, there's kind of a spectrum of conduct that could qualify. And one would be where you actually intentionally fire the gun, right? You fire, say, a warning shot into the air and the bullet ends up killing somebody. So you fire that shot intentionally, you're intentionally creating a risk. The bullet's going to keep going until something stops it. If that turns out to be a human being, created a risk of death to human life, ignored that risk when you fired the shot, clearly reckless use of a firearm. Then we have this Engel case in the state from the state Supreme Court saying, well, it can be reckless handling of a firearm even if you don't intend to fire it. And the facts of that case were a security officer had his gun in hand and then began fighting to extract someone from a car and unintentionally discharged the gun, paralyzing the suspect. And that was found to be reckless handling of a firearm, even though everybody stipulated that he never intended to fire the gun. It just happened in the course of the struggle. But this is a much further reach than that. At least in the Engel case, the guy deliberately had a gun in his hand. He knew he had a gun in his hand when he engaged in this struggle. In Potter's case, I think everyone agrees she didn't know she had a gun in her hand. And the argument might be, well, she should have known. But that's clearly distinguishable from this Engel case that the state is putting such reliance on.
Yeah. I got in a mild argument with a DUI or DWI lawyer down in Texas because they were arguing that basically none of this matters because she engaged in the behavior and therefore it's reckless because she shot. And it's like, wait, but recklessness in Minnesota under the second-degree manslaughter charge requires conscious disregard of the risk,
right,
which means that you have to have awareness of the risk to
right,
then disregard it. And if she's only aware of theoretically aware of the risk of tasing, that's the risk that she's aware
right.
of. She's not aware that she could shoot this guy because she doesn't know she has a gun in her hand, unless we disbelieve that she didn't know. But I don't
think even the state is arguing that, right?
Right. Not that we've seen so far.
Yeah. I mean, it would be different if she had the taser in one hand, the gun in the other, and then used the wrong hand. I mean, that would be a different fact situation. But here I think it's pretty clear both from her conduct before and immediately after the shot is fired that in her mind, that was a taser in her hand.
Yeah. That, and to me, I don't see how, and I mean, I know legal arguments and juries don't mix very well, but the theory of proving out these elements on jury instructions of you must find that she consciously created the risk and then disregarded the risk. Then it's up to the defense to say she couldn't have consciously created this risk because she didn't consciously grab the gun. She consciously tried to grab her taser and made a mistake. That's not creation of the risk. And so if they argue that successfully, they should win. And if they don't argue it successfully, they could maybe attempt a JNOV with an appeal, but it'd be that and
losers.
It is for losers.
Literally, yes.
Appeals are for losers. Yeah.
But it's
I was curious if you guys have talked, and if you don't want to talk about this right now, that's fine. But I was curious if you guys have talked at all about the Jesse Smollett verdict yesterday and the difference therein. And I'm sorry for switching topics, but I was just curious. And we can go back to it or whatever. I don't care.
I have not, but hit it, Kurt.
No, I was just really interested in the finer points of the details of the jury verdict because it was interesting, and maybe between that and the other with the McMillans and the Rodney Bryant verdict, which also had some interesting splits in terms of guilty, not guilty. Maybe it suggests that jurors are paying more attention to these instructions than maybe we've given them credit for in the past, or considering things more carefully than we have in the past. So I don't know to the degree to which, if any, that should be a white pill or a sign of hope. But it was interesting as we were discussing when I was listening to Nick just now talking about jury instructions not working well. I was wondering, well, maybe we should be giving them some more credit, but I don't know if that's too optimistic.
Well, I think the credit on jury instructions is for example, in Rittenhouse, the one of the big criticisms for both sides was that they didn't actually explain to the jury how those jury instructions worked, right? Like they didn't take the time to say, this is what this jury instruction means. This is how
We
it
still don't
goes.
know, by the way. I mean, for all we know, the jury convicted in the Arbery case because they believe the jury instruction means they had to have been present when some crime was committed, because that's one way to understand that jury instruction, the way it was read to the jury. And I don't believe that's the correct reading of that jury instruction, not when you're dealing with a felon in flight scenario, which is what they were dealing with, but that was not explained to them.
Right.
And if that's how they arrived, and we'll never know how they arrived at their conclusion because they don't tell us.
Yeah.
They don't have to tell us. But that may be how they arrived at their decision. And if that's the case, then it was an unjust verdict on those grounds. Now, maybe they get convicted on other grounds that would be just, but we can't know that because the actual jury instruction was never clarified. And so far, the relevant jury instruction here on recklessness is not clarified. The judge has not explicitly said whether or not this Engel, at least he had a gun in his hand and knew it, should apply to a circumstance where the officer clearly did not know she had a gun in her hand. And that's, to my mind, that's really the only issue in the case.
Yeah. And the point I was getting to is I think it's really going to heavily depend on the prosecution and the defense arguing over what that recklessness means and who's more effective in convincing the jury how to define recklessness.
And what's disturbing is they already brought it up Monday morning. They brought it up before the jury was in the courtroom, and quite explicitly in the end of that 15 or 20 minutes conversation they had before the jury came in. The defense said, hey, we're anticipating the state's going to make this argument. We think that's not a legitimate argument. The state said, well, yeah, we think that is a legitimate argument. And the judge said, well, we'll talk about it later. I mean, that's the whole trial.
Yeah, I assume that they'll talk about it, when they argue jury instructions at the end of the case, and that's what the judge is thinking. But it's
wrong. That's wrong.
It should be dealt with earlier,
right? Because it is the critical issue in the case. I mean, there's always facets of a jury instruction that you'll kind of fine tune at the end of the trial when you've heard what the actual evidence is that was introduced. That's totally fine. You kind of fine tune things around the edges. But when it's the critical issue in the case, the lawyers want to be able to argue to the key issue in the case, and they can't effectively do that when the judge has not told them how that's defined. And I know why the judge doesn't want to do it, because she's hoping maybe she won't have to, like we had in the Arbery case, or the Rittenhouse case as well. And of course, if she makes a definitive ruling on this, well, then that's something definitive that an appellate court could reverse on. And maybe she doesn't want to make herself subject to that. If everything's left kind of loosey-goosey, you can't really say she made a bad decision because she didn't make a decision. But that's not justice as I would define justice.
Real quick, Kurt, there's an update on a case that we talked about.
Ooh, is it the Mignogna case?
No.
Oh, okay. I was about to get really excited.
No, those judges will never ever rule on that.
No, I know that. I know that.
They're just gonna leave it. Now look at this. So the Supreme Court has decided not to stop the Texas abortion ban, but they're going to allow the clinics to sue over it.
That's interesting that they decided that issue. I would have, if you had asked me, I would have thought that they were going to, at least issue that at the same time as the Texas decision, at the same time as the Mississippi decision, since they're all, since they're all dealing with the same subject matter.
Right.
If, you'd want to the extent you're going to send it back, you'd want it sent back with any instructions that are going to come from the other case, which, is obviously going to have something to do with it. So it's like, yeah, okay. So that's also, it's interesting that they thought that there was sufficient standing. So that will be really, really interesting for me to cover. I have still yet to cover that. I'm supposed to cover that actually tonight with Legal Mindset. We're supposed to do oral arguments for this case. So maybe after we do oral arguments, I guess we'll do the decision on the case too.
they bring out this very nice paragraph. I love. The outcome is at best only a partial victory for abortion providers. The same federal judge who has already once blocked the law almost certainly will be asked to do so again, but then his decision will be reviewed by the Fifth Circuit, which has twice voted to allow enforcement of the ban. It's gonna shoot right back down to the same judges. The case could return to the justices, and so far there have not been 5 votes of the 9-member court to put the law on hold while the legal fight plays out. So that's they're really scared of what's going to happen in Mississippi. And by they, I mean media people who tend to be pro what the hell? I don't want that. Who tend to be the media seems to be in favor of Roe. That's just seems to be.
You picked up that?
Yeah. I don't know how to say that without saying they, because it's obvious, but yeah, it's the fact that they're all of them seem to be doom pilled, and I'm glad somebody else is doom pilled other than me right now on some issue, and so they're all on depression watch over what the Supreme Court's going to do in that Mississippi case. That makes me very happy.
I saw that the state of California, in its infinite wisdom, is floating the idea of paying for people's hotel bills and medical care who want to come to the great state of California for the purpose of ending a pregnancy. So they will be a refuge to the world. Joy.
Well, they're going to have that high-speed rail, right? Eventually.
Musk. Are they ever building the Musk tube? Whatever happened with the Musk tube? Remember the hyperlink or whatever?
Yeah, it doesn't make really any sense, but that's okay. We'll just. I think they finally gave up on that, but yeah,
it was like the biggest news for so long. You're like, oh, they're gonna do this 30 minutes LA to San Francisco.
No, they're
it's
not.
Gonna be the greatest system ever. Here's it's gonna cost $5 billion, and they're gonna make it. It's like, we'll make it then. Let's see it happen.
Yeah. Well, it reminds me of that Onion article, which I guess may be coming true, about the abortion megaplex with the movie theater. Do you remember that Onion article from like 15 years ago? It's like that people thought was real for a second. It's like Planned Parenthood announces abortion megaplex movie theaters and everything. That's huge. You know, I think they said it would cost like $3 billion or something ridiculous.
It's like a retirement community, but instead of retiring, you go have abortions there.
Yeah, so maybe that will finally become true if abortion is the last place standing. So yeah, you'll have the smoothie station, and yeah,
please don't call it a smoothie station.
there was some deliberation in my word choice.
So yeah, the Smollett trial, of course, you brought up is interesting because there was a distinction there. It was 5 out of 6 counts he's guilty on. We were contemplating yesterday how much, would he be punished at all? Would he be sentenced? I was contacted by a Chicago attorney last night and said there's no way he spends a day in jail. He says class 4 felony in Chicago. Nobody spends a day in jail
with the perjury, though.
That's what he said. I'm just going by that because I went through, what would happen on my stream last night in Minnesota if you did this, and if you sentencing guideline in Minnesota, if you have 5 felonies, even the lowest level felony, which would be like a possession charge of a controlled substance at the lowest level, if you have 5 of those in a row, you're going to prison for 17 to 22 months. That's the presumptive guideline when you have 5 charges convicted. So that's how we do it here. He would presumptively be going here, and they would have to have mitigating factors clearly articulated by the judge to keep him away from prison. But and maybe he would get actually aggravated because of the perjury and the nature of his celebrity status and all of that stuff.
Well, forget the nature of the celebrity status. How about the nature of trying to start a racial holy war in the middle of the height of BLM, and to the point where the sitting vice president and they will eventually be vice president, and like everyone else is commenting about how this is a modern day lynching and all the rest of it, and trying to start a holy war on race or something. How about that? as an aggravating factor.
I think it would certainly be considered it would be considered as an aggravating factor if the judge chose to utilize it in Minnesota. That would be up to the judge. They have a lot of discretion, but it would. I was, looking at it, and he could easily have his sentence doubled in Minnesota, or even tripled if the aggravate. All you need is one aggravating factor. Chauvin, they found 4. But one is sufficient and presumptively sufficient. The appeals court is going to uphold that if you have even one aggravating factor, and the judge determines to double the sentence.
Yeah, the Chicago lawyer you spoke to is almost certainly right in reality, but nevertheless, I'm going to hold on to hope that that in the face of the two factors for me that are driving this are: one, you try to start a racial war and almost kind of succeeded a little bit too. And 2, you got on the stand and obviously perjured yourself because the jury disbelieves you or believes you're guilty beyond a reasonable doubt, which must necessarily mean you lied on the stand. So therefore you perjured yourself. And in the face of these 2 factors, and the face that it happened 5 times, I'm going to hold out hope that he's going to get some jail time or some prison time. But the Chicago lawyer is almost certain he's blackpilling me and bringing me down. But atypically, I'm going to be the white pill voice and say, Krusty is coming. Krusty is coming.
I mean, listen, if this were good for a 10-year sentence, I wouldn't feel that was inappropriate at all. I mean, the amount of damage this guy tried to do is incalculable. But sentence is a weird thing. I mean, like even with the Alec Baldwin case, even if the worst happens to him and he were to be, well, not the worst, I guess, but convicted of reckless manslaughter in New Mexico, that's 18 months. So, and a fine of $7,500, which is not what manslaughter is in most states, but
he could, I don't know how New Mexico sentencing works, but could he get a downward departure to probation based on the fact that he relied on the expert that they hired to handle this for, so it would mitigate some of the, the recklessness? I mean,
I don't know, but there's nothing in the sentencing portion of the statute that suggests in any way it's a mandatory minimum.
Sure.
So I assume they're amenable to, not 18 months. And, it's Alec Baldwin. They'll say community service and teach a local theater group or something. And,
when
that's how it happens, right?
When I was in law school and we were taking our criminal class, the joke was if you ever see a celebrity on Sesame Street or any other public access show, what you have to ask is what they pled out of.
Right.
That was what they were up to. The more you know. Listen, kids, we've had a lot of fun here today, but I'm Alec Baldwin. I'm here to tell you about gun safety. Guns are bad. They're dangerous. Don't use them. Can you imagine? Oh man, I want the Alec Baldwin DVD box set on gun safety, where every single spot that he would have to do, and every single thing. I would probably just email him clips all day.
Imagine if you had to make it for the NRA.
Oh my goodness. That would be
the NRA's troubles keep continuing. They lost their bankruptcy thing, and so they're continuing to be sued by the state of New York, and
a badly dysfunctional organization. I say that as a life member. I have been since I was in my 20s, but it's not the organization today. It was then for sure.
No, I always thought that that Wayne LaPierre really wasn't the guy. I always kind of liked Chris Cox, who used to be the head of the Institute for Legislative Action, as a better leader for the organization.
I thoroughly dislike Wayne LaPierre, and the reason I dislike Wayne is because if the idea, which I believe is true, is that a gun doesn't kill someone, just the mere presence or even ownership or possession of a gun does not subconsciously drive them to kill or make them predisposed to kill, then I don't think you can credibly argue that video games or TV violence do. And that is what Wayne LaPierre did. And that, to me, like, that was the last straw on the NRA under his leadership, is like, if you're going to try and mitigate what happens on guns by throwing various media under the bus, I want nothing to do with you. I think that's we need to realize that people make these choices. 1 billion people a day watch violent movies or play violent video games, and no one's going out in any significant number and murdering someone.
No, I did love that moment in the Rittenhouse trial, and I think I made the joke at the time. It's like, are we bringing back Jack Thompson again?
Yes, yes.
Like,
but
it's kind of old school.
Did you hear him say on the one interview, I played Call of Duty every night of that trial?
I did hear it. That was nice. Yeah, what bigger to know?
Well, I've met Wayne LaPierre a number of times at various NRA events, and he comes across in person just about as you would expect. Nice suits.
Yes, that the membership is paying for, among other things.
I was gonna look up this case. I don't know if the
but yeah, people in the chat are right. Gun Owners of America is great. The Citizens Committee for Right to Keep and Bear Arms is also very, very good. Yeah. Second Amendment Foundation, they do some really, really nice work in litigation.
Life
SAF.
member there too.
I'm a life member of SAF too. Yeah.
Andrew, have you ever talked with John Black? Or not John Black? Is Black the guy's last name? He's the Second Amendment Foundation lawyer. He's the professor down at U of H. He argued the 3D printed guns case.
John Black doesn't ring a bell to me.
John Black, I'm mixing up. That was from the
that was the use of force
Rittenhouse
expert from Rittenhouse.
Yeah.
But so I've been to a number of their meetings, the SAF meetings. I'm a life member there. I'm a Second Amendment absolutist, but I don't really do gun law or Second Amendment law myself. So I'm kind of an observer from the sidelines and all that stuff.
Joshua Blackman.
Oh, Blackman. Yeah. Well, have I met him? If I did, it was at one of these events, just in passing. I mean, I've never had a substantive conversation with him for sure.
Okay. He seems like an interesting fella.
But every couple of years, I go to one of their annual meetings in Houston or wherever they have it that year and hang out and listen to the talks. And it's always a good time, but they don't really do use of force law, and I don't really do Second Amendment law. So it's more like we look affectionately across the ballroom at each other.
Oh no. So I'm looking at the case here. They have 2 more witness contact forms were served yesterday by the state on the defense. Doesn't say.
So is this their version of the video, the drone video?
I don't know. The above named defendant's counsel. Supplemental disclosure page consisting of pages 9917, 9918. So there's 9,917, 9,920 now pages of discovery in this case.
For an event that took about a minute.
I think the 22 seconds is the from the time that she enters the scene. Yeah. And it's just crazy. I'm trying to find if there is a witness list. That's what I'm looking for. Okay, the witness list from November 12th. Who do we have here? That's defendant's witness list. State's witness list. All right, I'll pull this up. Oh my gosh, this is a long witness list. Here we go. So this is the state's witness list. Carrie Blansky, Katie Bryant, Aaron Longton, Kenneth Lundgren, Patricia Lundgren, Denise Wells, Aubrey Wright, Dallas Bryant, Elena Albrecht Payton. We've seen some of these people, right? We've seen her. We've seen Patricia Lundgren. I don't know. Kenneth, I don't think is going to come in. That's the guy with the mental issues.
Denise Wells is the daughter.
Right. I don't know who Aaron Longton is.
Yeah.
I feel like we saw Carrie Blansky.
Yes, that's the neighbor in front of whose house the car crash occurred.
And Katie Bryant was his mom, right?
Right. Yep.
Okay, so and Aubrey Wright's his dad, who has not testified yet. So then we've got the Commander Garrett Fleshland, Sarah Fry, Police Department, Police Department, Police Department, Police Department, Police Department, Police Department. A lot more cops, cops from other police departments, sheriffs, more police. I mean,
Those are all going to be body cameras. So those will be the 15 cops who showed up at the crash site, after the shooting event occurred, and they all have body cam and dash cam and verbal testimony, and it's all good. It's all going to be cumulative. I mean, it's all the same thing.
yep.
Yeah.
All these people from Bureau of Criminal Apprehension. They've got 2 forensic scientists, three forensic scientists from BCA, because I guess we need 3 of them, and a Hennepin County medical examiner. Jeez. So that's the list. If they run through all these people, I might be asking Jussie Smollett where I can buy a noose. Holy cats.
Apparently, your local hardware store.
I still am wondering why
BLM came out with a statement of support, which seems ridiculous.
I mean, but they're a ridiculous organization, right? Like, at whatever you think about BLM, and there's some of their points I agree with on various things. Like when they had that like 13-point manifesto, I could get behind several of them and say, yeah, this is reasonable. But then you get to those like last 3 and you're like, well, nope, now we're crazy communist. Okay. I can't do that. So whatever you think about them though, at this point, we have to acknowledge they're a ridiculous organization or disorganization, as it may be.
Yeah. Well, when their leadership is complaining about the inequality in the system, and their leader is also buying their 5th multi-million-dollar house, but it's okay because they're one of the special people.
Well, that's how communism works.
Yes. All the animals are equal, except some of the animals are more equal than others.
Yeah.
Indeed.
Well,
Every
it's
time.
the Hassan Piker problem. Same thing. That's the same thing as BLM. It's like, so that lady collects all her fee, or collects all of her payment, buys 4 properties, her most recent one being $1.5 million, and then just pieces out of the organization. Well, I've done my advocacy. I'm
or
good.
Bernie
for
girl, who I don't know her real name, but she
Nicolo,
bought she bought like a $2.3 million apartment, I think, and it's okay though for her.
It's such a pitiful apartment too.
Yeah, she didn't seem to get good value for her money. Which seemed,
for money management by a communist. I can't believe it.
Well, what I did, so she's in the Dallas area, and so I just looked up properties for $2 million in Dallas, and it's like, here's what you could have gotten. It's all these like 8,000 square foot house with a giant pool, and like 10 minutes from downtown. It's like, what are you doing? Why would you live in this stupid apartment? It's not even well furnished. Oh my gosh. I mean, it doesn't have an Xbox fridge, but I do. Let's see. I was going to hit some of these early super chats real quick. I think that's...
I do appreciate that there's usually at least one person in chat who gets my references. That's always helpful. And then a whole bunch of other people will be like, what is he talking about?
This chat tends to, they tend to be on top of it somewhere at least. Renal Ryan says, let Nick and Legal Eagle spoon as long as they want. If that's why Nick is so late, I say let him be late. Lewis Griffin says, was it trimming your nose hair that made you so late? No, my lawnmower broke. I can't do that. Wanted Samurai says, question relating to copyright from days ago. What's the difference between a Weird Al parody being fair use, but a situation like the Verve's Bittersweet Symphony versus the Rolling Stones? Is a new song not transformative enough?
I mean, the easiest answer to that is Weird Al always got permission to parody all of his songs.
Right.
He did, but I don't think it would be necessary. Well, because the thing with Weird Al is his songs are clearly parody, whereas doing just taking the music right from another song and putting it, what the hell? Okay, Long Crime just ended their stream.
How rude.
That was awkward.
Was it us, Long Crime? We're sorry, baby, come back.
Yeah, I mean the trial's not supposed to start for another 12 minutes, or the hearing's not supposed to start for another 12 minutes.
Yeah, I've got that Care Kare 11
Yeah.
feed up, and it's I mean it's on it's on a countdown, so it's not showing anything substantive at the moment, but it looks like it's still counting.
But yeah, there's a distinct difference between utilizing music to make a song without accreditation or permission for the music, and then parodying a song that's a specific thing about the song that it's a reference directly to it, and it's commentary, criticism, or parody of that song. It is to transform the work, not to steal the work, if that makes sense.
Yeah, so I'm going to try to say exactly what he just said in different words, and then I'm going to make myself sound better by doing it. But yeah, so when you're parodying something, you have to make fun at the thing itself. So so a good example, in my view, is like the song "Barbie Girl" by Aqua, which actually did go to court for some reason, and the Ninth Circuit, famously in their last line in that decision, told the parties are advised to chill, which was kind of hilarious. But in any case, that song is making fun of Barbie. The whole point of the song is to be like, yeah, this is what Barbie holds herself out to be, and this is what she really is. So that's a good example of a parody. Like a satire, you're just making fun of something else, and that doesn't work for copyright purposes. So hopefully that was helpful.
Thanks for bringing case law into it and making me look like a jerk. Billy Witch Doctor says, do you think Russell Greer will also hire lawyers for his lawsuit against America's Got Talent? Well, to be very clear, Russell did not hire these lawyers. They reached out to him to work pro bono because they want to destroy fair use very specifically. That's what they want. Kurt, you should look into that case.
What's that?
So it's the case of Russell Greer versus Joshua Moon and the Kiwi Farms. For contributory copyright infringement, based on a user on Kiwi Farms uploaded Russell Greer's song, which has a registered copyright, to the forum. And so he argues that Joshua Moon induced the upload by making the forum available to do an upload, which was, the judge shot it down, right?
No, yeah, you're gonna need something more than that.
But he has appealed it, and the some nonprofit law firm opposed to digital rights, I guess. They say they're for digital rights, but they're not fair use, though.
Which rights, right? Yeah.
They have taken up the case and on appeal. And so it's
now, yeah, the inducement argument is an exception to Section 230, by the way. So, as I'm sure many of you know, if you are a platform and you allow other people to make content on your thing, you're not liable. But there are some exceptions, and one of them is inducement. Like, you specifically ask people to contribute to specific things that are specifically a problem. And a good example of that, incidentally, was the shitty media men case. So there was a list of there was an Excel document or similar, I think it was Google Sheets, but same idea, where people were asked specifically, this was part of the court holding, were asked to contribute names of people that were shitty media men, people in media who have done, various bad things to various degrees of bad, right? And so the people behind that were sued for defamation by some of the people on the list, as you might expect. And then so they tried to claim Section 230, and the court found quite correctly, I think, in my view, that they specifically induced that specific content. It's like, please give us the names of the shitty media men and the shitty things they've specifically done. Please tell us that specific information. And so it's like, okay, now inducement. So yeah, Section 230 is not going to save you. Go away. So how about that? Some more case law to describe things.
Yeah, but 230 doesn't apply to copyright. You have to use the copyright safe harbor law.
This is true as well. It doesn't apply to intellectual property. That's a fair point as well. But there's still the aspect of there's still some aspects there that are relevant when it comes to inducement, particularly for the aspects of contributory or vicarious liability. So hey, fun.
I just wanted to bring up something to counter
you just want to try to shame me. I'll shame you back.
That's
I'll
right.
use up bigger words.
C Goody 564 says, "Can I get a toast for my grandfather if you'll be drinking today? Passed away at 1 a.m. this morning. R.I.P. to Bebop." Yeah, brother.
Sorry to hear that.
I'm not going to advise anyone else to drink at 10 in the morning, but I'm a professional. So let me pour a little shot of whiskey here, and I'll offer a toast to See Goody's grandfather. May he rest in peace. May he be free from any pain that was remaining in his life, and may his memories in his family members and loved ones persist on for the good things that he did and the man that he was. Cheers.
And forever be a blessing.
Amen. Brian Miller says, so with Jussie being found guilty, do you think they will go after Bubba Wallace now for the same thing with the noose in Talladega?
No, that's a completely different thing. That might just be someone being a complete idiot.
Right. And it came across that way too. It didn't.
I mean, no one said Bubba hung the noose in the noose.
Right.
And the pull handle in the garage. Right. I mean,
no, that's just someone being a moron. I saw something that looked like a noose. Okay. It's just the work.
By the way, folks, as someone who used to work as a diesel mechanic, you see those pull ropes on every garage door in every garage in America, probably the entire world. It's the most common sight you could possibly see.
Yeah.
The fact that it was mischaracterized that way is ridiculous, but it does appear that it was a mischaracterization, not some intentional.
Still didn't stop people from having a moment of silence in a march and, you know, a drive to end racism because people are morons.
You know what? I can't believe this hasn't been done. I cannot believe, and Jussie was the dude to do it. The novelty protest noose necktie, right? Where you have the noose and the wound down thing, and you wear it on your suit in protest. You can make it, you know, the colors for Black Lives Matter or something like that. I'm surprised that no one has done this.
At least a breast cancer awareness pin, right? Except noose shaped.
Yeah. Like if I could make that without being banned from somewhere and grift by selling it to BLM or whatever to wear it. To me, it seems like a good idea. Like I'm not.
Now, is this a necktie that has like a picture or a pattern of a noose, or is it a necktie that's actually kind of noose-ish?
It's noose-ish, but you what you have to do is you have to make it like a ridiculous color, right? So like it stands out. It makes a statement. It's not just a piece of rope hanging there, because that would probably not go over as well. But you pick the colors.
You just put a piece of metal in there and you got a bolo tie, man. Yeah.
But I'm surprised that no one's actually done that. And you know, when you're making like ridiculous things, these are people, remember how communists work, right? Like there are women who will bleed all over their pants to show women's rights. Like that's what they will do. They'll wear it, or the when 4chan really gets into it and convinces people to like shave their heads for a cause, or soil themselves for the rights of sexual assault victims or something. It's like they just got you to urinate in your pants in public to make a statement by trolling you on the internet. That was brilliant. I'm just surprised that no one has actually sold the noose tie for BLM. But
hey, Nick, I do see one comment here directed at me. If I could answer that before the court kicks in. Someone's asking about that concealed carry insurance. I recommend the one I recommend is CCW Safe. You can find that at lawselfdefense.com/CCW Safe. It's really the only one I recommend. Full disclosure, I do have a partnering relationship with them. But that's the one I'm personally a member of. That's the one my wife is personally a member of.
Also, tell us about the course you're offering soon, because I also want to sign up for it.
Do you?
Yes.
All right. Well, that's our lawofselfdefense.com/advanced, as you see in the little picture there. January 8th. It's a Saturday, full day. It's our full day course on use of force law. Covers all 50 states. It's the equivalent of a law school seminar, a semester-long law school seminar on use of force law. If any law schools taught this stuff at that depth, which to my knowledge, none of them do, unfortunately. And it's all in plain English, so you don't need to be a lawyer to understand it. Although we do also teach that course as CLE all over the country, or when I was traveling to teach, we used to. So CLE meaning continuing legal education. So this is where lawyers, judges were coming to learn the use of force law. They're not taught in law school. And it's we still have some seats available. It is taught live. It's unfortunately it's all day sitting at your computer on a Zoom screen. I'm doing it too. But because it's live, there's plenty of opportunity for live Q&A. So there's, I'll stay as long as people have questions. up to an hour. And so you should walk away with a real mastery of use of force law. And again, that's at lawselfdefense.com/advanced. If anyone's a lawyer watching and you're wondering if you can get CLE for this, we don't accredit it beforehand for CLE in all 50 states because that's a nightmare of a process. But a lot of jurisdictions will allow you to self-report CLE. If yours does, we're happy to provide you with a syllabus that you can use in support of that submission.
And that can be found right there, lawselfdefense.com.
Look at Nick.
Advanced. Check it out, guys. If you're interested in learning the depths of self-defense.
Also,
law.
I ordered my book from you. I'm still waiting for it to arrive, but I'm looking forward to it.
We have our warehouse people show up to work every day in tears, shipping out books. So we'll get you, I promise.
Britt Cormeyer says, how about you make Juicy pay for all the state/federal time investigation in the trial? Make people stroke a big enough check and it will get others' attention.
Very common in fraudulent crime reporting, actually, to make the convicted defendant pay for those expenses.
Juan says BLM, NAN, which is Al Sharpton's group, and the like lavish in the problems of minorities so they can keep making money. They don't really want the problems to go away.
No, it's a grift.
Did you see Ben Crump's face when Arbery's dad made his statements outside the courthouse after the verdict?
I did not.
Oh, because Arbery's dad went on a tear and started talking about how it wasn't it's not about race because all lives matter.
Mm-hmm.
And like Crump and Sharpton, they're like, yeah, everything he's saying, and then he's like, because all lives matter, and they're like, yeah.
So did you catch during the testimony of the girlfriend in quotes? I guess they weren't dating long enough for her to be a fiance, which is how they're normally characterized in these cases. But at one point, the girlfriend's testifying, oh, yeah, Dante was on the phone with his mother, and his mother was asking him about, did he have any warrants? And Eldridge goes, I'll stop you right there.
Yep. Oh, yeah.
So the mother, presenting this angel of his son, is asking the son on the phone whether or not, hey, maybe you're getting, pulled over because you got open warrants. Is that possible?
Why would she think that?
Why?
That's what my parents think every time. I'm like, oh yeah, I got pulled over today while I was driving around. They're like, oh, do you have any warrants out? Like, yeah, first question every time. So how did you? What was I gonna say? So there's an interesting objection that happened that was granted in part and denied in part after sidebar, and it was the question of what you were doing in the morning. Do you think the judge was trying to exclude evidence that they were sexually active?
Yeah, or maybe the prosecution was just concerned they were going to go that way, or maybe there was going to be more drug talk, or I don't know. There was something. I hate these sidebar discussions because we don't know what's being argued, right? And the judge just comes back and says, "Well, denied in part, granted." Well, which parts? I mean, and why?
Right.
That would kind of matter.
Trying to get a legal education over here, damn it.
Yeah.
And you got to wonder if those sidebars are preserved for the record. I mean, they are on the court. There is an audio system that's happening. The question is whether or not it's recorded.
So, because most often they come back and make some kind of brief record of very superficial record.
That one, it's like the objection was denied in part and granted in part, and it's like, well, how do we appeal this? Like, how do you, like, functionally, you're typically not going to win on an evidentiary issue decided by a trial court, but unless there's clear error. But how do you even argue clear error when there's nothing in the record as to what the objection even is, and then what the judge decided? I guess you would have to ask. You'd have to ask to make a record of it.
Yeah, and of course, this judge, there's no speaking objections, so which I understand. You don't want arguments to be occurring constantly in front of the jury, but then there's only in the record. There's only the one word, right? Yeah. Objection relevance, objection cumulative, and you don't really get the argument fleshed out.
I'm glad the defense is ignoring her no speaking objections order, actually.
Yeah.
because a lot of their objections require more than one word, and they're keeping it limited. It's a phrase or a sentence.
Yep.
But it's like so their objections aren't as clear. It's not like objection hearsay, which would work for a lot of things, but it's objection, Your Honor, this is vague and asked and answered. I mean, what are we talking about?
Right.
And Yes, the cumulative evidence has become really tedious.
Young Master Joshua Larson, Esquire, certainly took offense to the speaking objections at one point. It's like, Your Honor, you already told them not to do that.
Yeah, thank you, Your Honor. Thank you. To the chat, I said that the guy looked really familiar. And it turns out he went to the same law school I did, but he graduated several years before I did.
Oh, no kidding.
So I probably don't know him from law school, but I swear I've seen that guy before, like somewhere at something, which is entirely possible. But yeah, I was trying to find out. Someone said he went to your law school. I was like, when did he graduate? He graduated, I think, 07 or something. And I think I graduated 2015, something. I went to law school late. God, they still have this guy on Fox just yakking. They have some attorney on Fox yakking about the trial. Who would watch an attorney talk about trials?
And I saw another question here directed at me about making gun modifications and the legal risks of doing that. And folks, I'll just say, I don't want to dive into the whole subject because it's off track here, but if after watching these trials, you don't understand that a prosecutor will use anything against you.
Oh yeah.
And then you just don't understand what this arena is like.
You can't win because everything is bad. You know, you used Full Metal Jacket. It's bad because it overpenetrates, and it used jacketed hollow point. It's bad because it causes more damage. You use off the shelf ammo. It's bad because you're just showing cavalier attitude. You reload your ammo. It's bad because it shows a deliberation with intent to kill. That used to actually be more of a thing back in the day, but definitely some people are in jail because of that one. You can't win.
Now. Yeah.
Well, the one thing to remember, if you need any further evidence of it than just our word, in this trial, the issue that the department issued hollow points used by Kim Potter
blew up his heart.
Yes, a prosecutor. Kim Potter doesn't have a choice over what ammo she's loading into that weapon. I don't think think she could say, no, you know what? I want Full Metal Jacket rounds or pest control rounds in my sidearm today. They're issuing hollow points.
You have a big scary black gun. It's going to be against you. If you put a vinyl wrap on there, which I was putting a link to my channel in the community tab, you can vinyl wrap your gun in all sorts of fun and interesting colors. You do that, it's bad.
It looks like the judges in the courtroom.
I'm pulling it up right now.
And unlike the comments, I'm not lying about it.
Chat got told.
House Judge Regina Chu presiding here in the case. Let's join in now.
Thank you, Fox announcer, for that. That was very helpful.
Counsel? Okay.
Okay. All right, counsel.
You just can't tear yourself away. Well, I did feel kind of like the defense got a bit ambushed by this whole Blakely explanation at the end of the day. They really should have been thinking of that throughout the entire day. And I had the sense it was not being discussed in sidebar, that the first time they heard Blakely was when they made that motion for a mistrial.
They raised Blakely, didn't they?
Who did?
The defense.
No, I think it was the prosecution.
I thought Paul Lang mentioned Blakely.
Okay. All right. Thank you, Deputy.
I could be wrong. I don't fully remember. All right. Chanji says there's a company in Africa that makes the noose tie you were talking about. They claim it's not for making a message; it's just a look. Okay, I wouldn't go with that one. I would make it about a message for a movement, or like a, like for a particular event or something like that to get everybody wearing it. But like, why haven't they made that for white people? Like specifically, because they do all the other stuff. Like you have to, like kneel in public or whatever. They do those. That was one of the weird things after Floyd, that whole church like kneeling in front of the black people. It's like, what are you doing? This is weird.
It's the end of times.
All right, please be seated.
I would feel really weird as a black member of that congregation having all the white
Good
people kneel in
morning,
front
members
of me.
of the jury. I know everybody's thinking about the snowstorm that is supposed to be starting shortly and going into this afternoon. I don't think it has started yet. I want you to know I'm going to continue to assess the
You get snowed
situation.
into the court. That'd be great.
At noon, we should have a better idea of how bad it's going to be. So I will continue to monitor that. And if it looks like it'll be a driving issue, we may terminate today early. Okay. Just
God willing.
I'm thinking about it. All right. Is the state ready to call its next witness?
We are, Your Honor. The state would call Michael Johnson to the stand.
There we go. Will be the police sergeant who was on
Okay,
scene.
please come forward and stand behind the witness chair.
I love this chat. KV in chat says, "Terminate me, mommy."
Truthfully testify in connection with this cause.
Yes, I do.
Please have a seat. You may remove your mask and state your full name and spell it.
Michael Johnson, MyChalJohnson.
All right, officer, a couple things to keep in mind when you're testifying. Yes or no answers, please. Don't shake your head. Don't say uh-huh or uh-uh. If you don't understand a question, ask for clarification. If an objection is made, stop talking immediately. Do not answer unless I tell you to. And remember to wait until the question is finished before you answer, because the court reporter is taking down what's being said. Okay?
Yes, ma'am.
Counsel?
Thank you, Your Honor. Good morning. Good morning. And I think the court referred to you as officer. You're obviously in a suit, not what we think of as a police uniform. Can you tell us why you're dressed in civilian clothes today?
I'm currently assigned as a patrol major.
And so you don't wear a uniform typically in your job nowadays.
Not right now.
We will get back to that in a moment, but I'm going to go back and start over. You are currently a peace officer in the state of Minnesota,
Correct.
and you have a license as a peace officer.
Yes, I do.
When did you obtain that license?
In 2005.
And if you could, since then, have you done everything required by the state to maintain your license?
Yes, I have.
And can you tell the jurors, please, your educational background to be a police officer?
I've got a bachelor's degree in criminal justice, followed up by a skills certificate that allowed me to be licensed by the state of Minnesota.
And when did you get your bachelor's degree?
In 2002.
And the skills program, when did you finish that?
In 2002.
And so at some point, did you become a police officer with the city of Brooklyn Center?
Yes.
And that was when?
May 31st, 2005.
And so from getting your skills done to that date, did you work at any other law enforcement agencies?
Not as a licensed peace officer.
Okay, explain that to us, please.
I worked as a non-licensed community service officer.
Which jurisdiction was that for?
City of Cottage Grove.
And, when I asked when you started, you said May 31st. You remember the date pretty
Sure.
specifically.
Yes.
Why do you remember it so well?
It's everything in the department goes back to that one single date as a start date.
And when you started that date, did you get sworn in
Yes.
and take an oath, that kind of thing?
Yes.
And it's a pretty important day in your career.
Yes, it was.
And so when you started working for Brooklyn Center, what were your job duties?
I was assigned as a patrol officer working an overnight shift.
And so what kind of things did you do as a patrol officer?
Do a little bit of everything for the city of Brooklyn Center, everything from medicals to traffic stops to major type of incidents.
And at some point, did that change from being a patrol officer?
Yes.
And how did that change?
I was assigned to a few other positions along the way, an auto theft investigator and a detective.
And did you eventually become a sergeant?
Yes.
When did you become a sergeant?
In October of 2015.
And when you're talking about these other things that you did, were they after you became a sergeant or some before?
Those were all before.
So that helped you get promoted to sergeant.
Correct.
What implicit in my question is that is a promotion to sergeant, right?
Yes, it is.
And when you became a sergeant, how did your duties change? What did they become then?
It then went from being as a call taker specifically to a person who supervised a group of patrol officers as well as still taking some calls.
So were you a patrol sergeant? Would that be the right term?
That would be correct.
And so as a patrol sergeant, are you still out on the streets most of the time?
I would be about 50-50.
And when you're out on the streets, I guess all the time you're supervising the patrol officers, right?
Yes.
And so when you have been working or in your work as a Brooklyn Center police officer, did you get to know Officer Kim Potter?
It's a fairly small department, so I had known of her since basically the time I had started, but really didn't get to know her until I had been assigned to the shift she worked on in 2019.
Okay. And in 2019, what do you mean by assigned to a shift?
I had the chance we bid by seniority. I had enough seniority to bid to a day shift, which she was on that day shift.
So prior to that, had you worked shifts with her? I'm not quite sure how that works.
No, I hadn't. I was actually assigned to a night shift where she was assigned still to a day shift. So we never even really saw each other at that point.
So for that 14 years from 2005 to 2014, or 15, you're on different shifts.
Correct.
Okay. But then in 2019, did you become her supervisor?
Yes.
And so then how often would you supervise Kim Potter?
That would be every working day, which worked out to about 7 days every 2 weeks.
And as you're supervising her, strike that. Let me ask you this. Throughout your career at Brooklyn Center, were there times when you socialized with Ms. Potter outside of the workplace?
Not before 2019.
But after that, you had those occasions?
Yes.
And do you also know Officer Anthony Lucky?
Yes.
And when did you get to know him?
I don't know the exact year, but he was one of the explorers for the Brooklyn Center Police Department when he was still in high school.
So still a teenager.
Yes.
And then obviously he became employed at Brooklyn Center as well, correct?
Yes.
And so did you know him then? Well, obviously you knew him. Did you supervise him then?
He was in the field training program. I wasn't the field training supervisor, but for the time that he was assigned to Officer Potter for field training, I was his duty sergeant.
So just so we can understand how that works, the trainees, the probationers, have a separate supervisor for that program.
Yeah, when they're involved in the field training program, there is a supervisor who is in charge of the program, assigns them where they need to be, and track how they're doing.
When they're out on the street, then it's the patrol sergeant who's supervising them technically out on the street. Does that make sense?
Yes,
And then there's also a field training officer with them.
correct.
Now, I mentioned earlier, kind of why you're not in uniform. Are you still with the Brooklyn Center Police Department?
I am not.
And when did you switch jobs?
In October of 2021.
And where are you working now?
I work for the Goodhue County Sheriff's Office.
And so that is the reason we kind of teased down later. You're not in a uniform. That's a non-uniform position.
Correct.
During your career,
Glad
have
he
you
teased that earlier.
received training in how to use a TASER?
Yes.
And have you been certified to use a TASER?
Yes.
Do you recall when you first became certified to use a TASER?
The first time was in my initial training of the skills program back in 2002.
So even before you became a police officer?
Yes.
And when you started at Brooklyn Center, did you get authorized to carry a TASER for Brooklyn Center?
Yes.
And before you could carry there, did policy require that you receive some training or certification?
Yes, initial training.
And did you do that when you first started in 2005?
Yes.
And since 2005, then when you were certified, have you been certified every year since then?
Yes.
And when you were a patrol and a sergeant, did you carry a TASER when you were out on the street?
Yes.
As part of your training, have you been put through what we'll call voluntary, how shall I say this, voluntarily being stunned by a TASER?
Yes.
Explain what that means for the jury, please.
As a part of the training, they use the two probes of a taser, and when they pull the trigger of the taser, it then has the incapacitating power over you, and you kind of lose function of your body.
I've done that, folks. It's no fun.
Part of this is that you agreed to do it,
Yes.
No thanks.
and that's as part of the training.
Yes.
They actually shoot you with a TASER.
Yes.
And how many times did you volunteer to do that?
Once.
Why not twice?
Because it's not a great feeling.
And when that's done, are there others around you to help you?
Yes.
Explain that, what that means.
They're there because your muscles will lock up, and if your legs lock up, you lose your balance and can fall over. So they're there to catch you if you fall.
And have you also been involuntarily exposed to the effects of a TASER?
Yes.
Can you explain that for the jurors, please?
There have been times that my partners have used a taser on suspects where if your hands get in between the taser probes, you then will receive that current through you.
And that has happened to you?
Several times.
And how does that feel?
It does not feel very good.
So based on those experiences and your training as a certified TASER user, if somebody is going to get tased, what do you need to do if you're holding the person?
You try not to have your hands in between the taser probes.
I'm going to turn your attention to April 11 of 2021. Do you recall that date?
Yes.
And were you working that day?
Yes, I was.
And just tell us what your shift was on that day.
I start my shift at 5:30 in the morning, and it goes until 5:30 in the evening.
And you were a patrol sergeant that day?
Yes.
Do you recall how many officers were out on the streets during that shift?
I don't remember exactly.
How would it typically be? How many would it typically be?
We would typically have 3 to 5 starting at 6 a.m. We would then have one more possibly starting at 2 and one more possibly starting at 4.
And did you hear a call for backup from Officer Lucky?
Yes.
And at the time, did you know he was in a trainee capacity?
Yes.
And he was with an FTO.
Correct.
And did you know who the FTO was?
Yes.
And who was that?
That was Officer Kim Potter.
And so the call was about what do you recall the call for backup being about?
I heard that he was on a traffic stop and was asking for a second officer to his location.
Would that be customary to call a backup on a traffic stop?
Yes.
So nothing unusual about his request for backup on that traffic stop?
No.
And did you respond that you would come to that to back him up?
Yes.
He said,
And how did you
I'm
do
going to
that?
come.
Over the radio, I called out my call number and said that I would be en route.
Do you recall him providing the location of the traffic stop?
Yes.
Was it an area you were familiar with?
Yes.
And did you then go to that location?
Yes.
I think it'll be interesting to
And
see if this officer is looking
Do you
for an
recall roughly how
opportunity
long
to
it took you
defend Potter.
to get there?
I would probably say 2-3 minutes.
So you were not too far away.
He just suddenly left the department
And,
after this.
Can you just describe for the jury the general location where that stop was?
I would be around 63rd Avenue and Orchard Avenue.
Now I'm going to put up on the screen an exhibit number 1, which has been received in evidence. Do you see that exhibit in front of you?
Yes, I do.
Do you recognize what's depicted there?
That would be 63rd Avenue, centralized on Orchard Avenue.
And do you see the location of where the stop was?
Yes.
They should have showed a
And
picture of a different
there should be in
street,
front
but
of you
labeled it the same.
a little stylus.
Yes.
And if you want to just draw a circle around the area where that was. And so just to be clear, or for the record, you're drawing a circle around the location on this photograph where the blue rectangle and the yellow X are, correct?
Correct.
And so did you in fact drive up and stop behind the stop?
Yes.
Okay. And so this location, from your years of working at Brooklyn Center Police Department, what county is this area located in?
Hennepin County.
And as you arrived there, where did you park in relation to Officer Lucky?
I parked directly behind him.
And were you working alone or with another officer?
I was alone.
And so as you got there, did you approach their vehicle then?
Yes.
And what did you see generally when you approached the other squad car?
As I approached, both doors were open of the squad car with Officer Lucky sitting on the driver's side and Officer Potter sitting on the passenger side. In front of them was a four-door white sedan.
And did you have a conversation then with either Officer Potter or Officer Lucky?
I talked with Officer Potter.
And what did you learn?
I learned that the driver of the vehicle had a warrant and was also a party to a order for protection.
And did you learn more information about the warrant as you were there?
Yes.
What did you learn about the warrant?
I learned that it was a gross misdemeanor warrant for a weapons possession.
And based on your years of work as a police officer, what did that gross misdemeanor weapons warrant mean to you? What did that indicate?
It means that a person had been arrested for carrying a firearm without a permit.
So it's a permit violation.
Yes.
And so as you're conversing with them, was a decision made about what to do?
Yes.
And what was that decision?
That Officer Lucky was going to place the driver under arrest and then look more into the order for protection.
And so was that what was done?
Yes.
And how many of you then reapproached the white car?
3 of us.
And how did the three of you divide it up?
Yeah. So Officer Lucky went to the driver's side with Officer Potter following a little ways behind him as the training officer, and I approached on the passenger side.
And so why did you go to the passenger side?
Yeah, I usually put one person on each side so that you get a good view inside the vehicle to see what's happening.
So that's sort of standard operating procedure, shall we say, when you approach a vehicle with backup?
It's one way of doing it.
It's funny that when they
And,
talk to officers on the actual scene, they have to be
Ms. Potter went
confronted
to
with
state
a
it
really
towards the back of the
unfortunate
vehicle at
fact
the time?
pattern for the
I
state.
believe so.
Was that customary for an FTO?
Yes.
By the way, Nick, I've lost my ability to comment on the comments. I'm not sure. I just don't have that window. So if people are asking me questions, and some people are, I can't
April
comment back.
11th, were you wearing a body camera?
Yes.
And
I'll send you all the important questions anyway.
were you also, operating a squad car that had a dash camera?
Yes.
And, excuse me a second.
Body cam, dash cam. So Johnson's body cam should be pretty exciting stuff.
Yep.
Epic.
And
It'll wreak havoc on the
the
state's
dash camera,
prosecution.
was it activated as you came up and stopped at this stop?
It was activated when I activated my body camera.
So did you activate your body camera before arriving at the stop?
I activated it just as I pulled up.
And why did you do that?
That's policy. Any traffic stop, we turn on our body camera.
And so when you do that, your dash camera automatically comes on.
Yes.
And before today, have you had a chance to review your body camera from this incident?
Yes, I have.
And have you also reviewed the dash camera?
Yes, I have.
And before today, we were able to show you some of those that would be exhibits today, correct?
Yes.
And so you recognize those as accurate recordings of what happened.
Yes.
Your Honor, we would offer exhibit 61.
Is there any objection to 61?
No.
There be no objection. 61 will be admitted into evidence and you may publish counsel.
Thank you, Your Honor. Now, before we do that, there's a couple of questions I want to ask so that the jurors can understand some of the things going on in the video, all right? Do you recall at one point learning the name of the driver?
Yes.
And what was the name of the driver?
Dante Wright.
Do you remember Ms. Potter asking you or making some comment about the Wright brothers?
Yes.
And did you understand what she was talking about? Well, what did that mean to you when she raised that?
It meant she knew something about them that should have kind of sparked my interest.
But your response was what?
I didn't know who they were.
Okay. And the Wright brothers that she was referring to, do you know who she was referring to?
No.
Okay. And had there been a Wright family that had been sort of known to officers?
There was another one that I was aware of.
And they did not have a Dante Wright?
No.
Did they make airplanes? I mean, maybe that was the issue. He's
All
really
right, so what
flying
I'm
down
going
the
to
road,
do
isn't
then
he?
is start exhibit 61, please. Now, let's pause here just for a moment, please. So as you can see, there is 2 videos present on the screen, correct?
Yes.
And the video in the lower right, do you recognize what that is?
Yep. That would be the dash cam video for my squad.
And the video in the upper left?
That would be my body cam video.
And just as the video started, we did not hear any audio.
Correct.
Eventually there will be audio, correct?
Yes.
Can you explain why that happens?
Both of the cameras are constantly recording and will save the first 30 seconds before the video is actually started.
And that 30 seconds is the part without audio.
Yes.
Okay. And then as we're looking at this, just for the record, its timestamp is 13:59:16. Where are you driving here in this video?
This would be 63rd Avenue.
And which direction are you heading here?
I believe this would be headed eastbound.
Yeah, I tested you a little too much, didn't I? Is this, you're about to make a U-turn, correct?
Okay, if this is before I'm about to make the U-turn, I'd be going westbound.
Yeah. And so you had to make a U-turn to get back to the stop.
Yes.
And then the 13:59 military time, correct?
Yes.
And so that would be 1:59 p.m.
Yes.
His body cam isn't in Zulu
Okay, let's go
time
ahead
like
and play the
yesterday.
video then, please.
So racist.
That was the thing yesterday. It's like, yeah, I noticed that that's in Zulu time. So I understand it to be 2:10 or whatever. It's like, why is your body camera in Zulu time? It's very weird. Oh, so
Was
he
that
was
an officer
right.
or the paramedic who had the Zulu time? I don't remember now.
I don't know.
Studies a 14-year-old black male dressed. When he walked in the house, he was running from the police.
She just accused him of blackmail. Very rude. His hair looks significantly grayer in this footage.
You're going to want to find out who the female is because there's no OFP.
He's got a gross misdemeanor warrant, and there's an OFP for a female, so I need to ID her. There's also residue, like weed on the middle console. So, probably search the car. Apparently, the car is his brother's.
You want to tell them what the warrant's for?
Warrant is for the weapons violation.
Oh, gross, yeah.
So,
Deontay Wright.
Dante
Wright.
Dante Wright.
Aren't those the Wright brothers? Not the ones that fly, but the other ones?
I don't think so.
So I'm just gonna get him out and I cuff him up. And he's in more, so I'm just
Yeah, that's fine.
Yeah, we will be here in a second.
all right, man. Here, come here.
And,
Okay.
By the way, if I didn't ask you, what is your current rank at Goodhue County?
Major.
Okay. So, Major Johnson, we heard in that video a voice saying, I don't think so. Did you recognize that voice?
Yes.
Whose voice was that?
That was mine.
And that was in response to Ms. Potter's question about the Wright family.
Yes.
So they really don't want the rest of that
tail
video?
End of that, the three of you start to approach the vehicle, correct?
Maybe they'll show
Yes.
the next one.
And when you approach the vehicle,
Kind of rude to
passenger
cut
side,
out the part where he jumps into the car.
I observed that there was a female sitting in the passenger seat in the front.
did she have anything in her hands at the time?
Not that I remember.
Do you remember indicating that she had some paperwork in her hands as you approached?
That's possible.
And
Yeah, leading.
and what did you observe next?
I observed that Officer Lucky had asked Mr. Wright to step out of the vehicle.
And did Mr. Wright do that?
Yes.
And what happened then?
I couldn't overhear a lot of what was being said, but I was able to gather he was telling them about the warrant.
Did you hear Officer Lucky tell Mr. Wright to do anything at that point in time?
I heard him to tell him to turn around.
Okay. And what about his hands? Did he say anything about that?
He put his hands behind his back.
And then at some point, at that point, did you tell Mr. Wright he was under arrest?
Yes, I did.
And why did you tell him that at that point?
Procedurally, you tell somebody that they are under arrest before placing them under arrest. If the person then doesn't cooperate with the arrest, they've been told that lawfully they are being arrested.
And so what's the importance of telling them that right at that moment in time?
Because that was just about before he was to put his hands on Mr. Wright.
So if they don't cooperate, could you charge them with some additional crime?
Yes.
Because you've told them that, right?
Yes.
So then, as you saw that going on, did you hear Officer Lucky saying anything?
Yes.
After what did you hear him say after that?
I heard him say something about don't pull away.
What did you notice anything about Mr. Wright at the time?
I saw part of his body start moving away.
And so what did you observe then after that?
That's when I actually opened the passenger side door.
And why did you open the passenger door?
I was going to make sure the car was in park and the vehicle had shut off so they couldn't leave.
And so when you opened the passenger door, what did you do next?
I leaned in across the passenger and put my right hand on the shift lever and my left hand on the ignition key.
All right. What about the passenger? Did you take any steps to deal with the passenger at that point?
There wasn't much I was able to do. I was kind of in a compromised position, so I just leaned against her with my body weight.
Okay. And did she put up any resistance to you when you did that?
No.
She weighs 80 pounds and he's a big guy. Didn't need to do much.
And at that point, where were you standing?
I was leaning into the vehicle.
Okay. Where were your feet?
Feet were either on the curb or on the street.
And did you said something about grabbing the shift knob, correct?
Yes.
And what did you do with that?
I pushed it forward, which would be towards the park position.
So had it been out of park?
I don't believe so.
Okay. But you said you pushed it forward. I'm just trying to.
I was pushing it as far as it would go forward. That way I knew that it was in the park position.
And did you know whether the engine was on at the time?
I don't.
You indicated you reached toward the keys, right?
Yes.
What were you trying to reach for the keys for?
I was taking the key and I was turning it forward, which would be towards the off position.
So you were attempting to turn the vehicle off?
Yes.
Did you know, but you didn't know whether it was on or off?
I don't know if it was.
And at that point, what was Mr. Wright doing?
He was struggling with Officer Lucky.
Okay. Was he able to get back into the vehicle at that point?
Yes.
And what did you think he was going to try and do at that point?
Drive away.
And so at some point, did you remove your hand from the shift knob?
Yes.
And what did you do then?
I took both my hands and held on to Mr. Wright's right arm.
And were you able to grab his right arm?
Yes.
And why did you grab his right arm?
Two things. One, to prevent him from shifting the vehicle, and one, to put him into a handcuffing position.
At that time, did you know what Officer Lucky was doing?
I couldn't see Officer Lucky at that time.
Did you know what Officer Potter was doing?
I don't.
And you grabbed him to put him in a handcuffing position. I'm not sure how to ask this, but who else did you think was going to help you handcuff him? Does that make sense?
Yes. I believe it would either be Officer Lucky or Officer Potter that would be controlling his left arm to put him in a handcuffing position.
And when you did that, when you grabbed Mr. Wright's right arm, were your feet still on the street or the curb?
Yes.
And did you then hear Officer Potter's voice?
Yes.
What did you hear Officer Potter say?
I heard something to the effect of, "I'll tase you."
And what happened after that?
I heard the verbal command of taser, taser, taser.
And then what happened?
And then I heard a loud pop.
The reason the DA is being very
And
careful is
did
this
you
guy's
know what the
likely
loud pop
favorable
meant?
to Potter.
I thought at the time that it was a taser.
When you heard taser, 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 what did you do with Mr. Wright?
I let go of his right arm.
Why did you do that?
I didn't know where those taser probes were going to be going, and I didn't want my hand in between them.
And when you let go of him, you had hold of his right arm. Was that the only way you were holding him?
Yes.
And did you see his position at the time that you let go of him?
All I could tell was that he was sitting in the driver's seat.
And where were you looking at that moment in time? Do you recall?
Kind of down towards the center console.
So after you let go of Mr. Wright, what happened next?
I saw him going for the shift knob, and I started backing out of the vehicle.
So it wasn't in gear when she shot him.
Nope.
And were you able to do that?
Yes.
And before testifying today, have you had a chance to watch your body camera from this time period of the exchange?
Yes, I have.
Your Honor, that is Exhibit 63, and we would offer that at this time.
All right, we are going to get to watch it. I wasn't sure if they were going to
63
show
will be
it.
admitted into evidence, and you may.
That car was not in gear when she shot him. Takes away a big recklessness
Officer
argument from the state.
Johnson, I'm sorry, Major Johnson. When we play the video, I'm going to freeze it just a few moments to help explain, so you don't have to be talking at the same time the video is running. All right?
Yes.
All right, then, Your Honor, we would publish.
It really guts all of yesterday's testimony.
We'll be here in a second.
You're under arrest, Dante.
Now, I have frozen the video here, and for the record should reflect that the timestamp indicates 2:01:52. Is that correct?
Yes.
All right. And so we watched the video to that point. And can you describe for the jurors, obviously this is the blue jeans are the passenger, correct?
Yes.
And this is the point where you're sort of leaning against her?
Yes.
Can you describe for the jurors, the arm we see here across really the top of the screen?
Looks like my right arm there is going for the shift knob.
All right. And this is the moment when you were able to, were you at this moment able to grab a hold of the shift knob?
Yes.
And can you tell what your left arm is doing?
I can't see on the screen with the shadow, but that would be the time that my left arm would be going for the key.
And by shadow, what is it?
On the monitor here.
Yeah, you probably can tilt the monitor if that gets rid of some of the glare.
It means the framing of the round lens on this rectangle screen.
Okay. And all right, so this is all right. So what I'm going to do is let this run to 2:02:54.
Good to know.
Now, at 2:02:54, do you still see your right hand?
It's 2:01:54.
And that's still on the shift knob, correct?
Yes.
Can you see the other hands that appear to be by your hand?
Yeah, there looks to be one other hand next to it.
Do you know whose hands those are?
I can't say for sure.
Okay.
Why did you erratically draw
Who
lines?
else was in the
just then?
vehicle at the time?
Mr. Wright.
And okay, let's run it to 201.56, please. So those hands that we had seen by your hand, now are you able to sort of tell whose hands they were?
Yes.
Okay. Whose were they?
Mr. Wright.
And so he appears to have been trying to move the shift knob,
Yes.
but you prevented him from doing that.
Yes.
That's
And,
not good for the state
then
either.
He pulled
His
away.
legs are out of the car now.
Yes.
Wright's legs.
In this moment, we can see your right hand still on the shift knob. Is that right?
Yes.
And what is your left hand doing?
That would be reaching for him.
And we'll hear a voice say, "Just stay back." Do you recall who said that?
I didn't hear that part.
Okay. All right. Let's play to 58, please.
Just say that.
Did you hear the voice there?
Yes.
Whose voice is that?
That was me.
And who are you saying that to?
That would be to the female passenger.
And did she stay there?
Yes.
And then we also just heard another female voice in the background. Did you recognize that voice?
Yes.
Whose voice was that?
That's Officer Potter.
So then let's run this to 59, please. Now, at this point in time, can you describe for the jurors what you've done with your right arm?
That's gone to reach for his arm.
And in the background, did you hear a female voice again?
Yes.
And who is that?
Officer Potter.
And then let's go to 2020.
By the way, this is all an effort to amplify evidence too.
Did you hear that female voice in the background?
Yes.
Did you recognize that voice?
Yes.
And who is that?
Officer Potter.
And can you describe for the jurors what you're doing here in this still moment at 2:02?
Do you agree that you're
I'm
holding his hand in a way
his
that,
right hand and arm.
in a way in which you would kiss it?
Is your left arm holding on to him as well?
Both are, yes.
And your right hand appears to have a grip on Mr. Wright's hand in a certain way.
Yes.
Can you describe for the jurors what you're doing there?
I'm holding on to it so that he both can't grab onto something, and also it's a position to hold, place him back into a handcuffing position.
Is there a term for that particular way of holding them?
I don't have one.
Okay, like a wrist lock or something.
That's not specifically a wrist lock.
Okay, but this is a way of getting them ready to handcuff or not?
Yes.
All this stop and go action is intended to make this appear as if it took a long
And
time.
at this point in time, you have his arm, Mr. Wright's right arm, over the passenger?
Yes.
Interminable.
Okay, we'll let this run to the end now, please.
You did?
Yes!
Okay.
I guess we're all fucking doing it! I shot him! Oh my god!
Kim, sit down.
And Major Johnson, in meeting with you, we showed you a composite video of Officer Lucky's dash camera and your body camera during this time period, correct?
Yes.
And that is done to help the jurors understand the overall scene.
Yes.
And does that composite video fairly capture what happened in this time period?
Yes.
Your Honor, we would offer Exhibit 62, which
Oh
is
my
that.
goodness. Laid proper foundation for a video?
62 would be admitted and you may play
Never even
it.
heard of that before.
We will be here in a second.
Hey, Nate.
Hey, what's going on, Andrew? I love your breakdown of the Taz Chop shooting, bro. I've been sending that to everybody who asked me. It was fantastic work, man.
I'm glad somebody likes it. You're getting a lot of hate.
Oh yeah, I saw, but no, it's exactly what I was thinking too. And this poor cop, they're trying to railroad, unfortunately. But,
You're under arrest,
you know,
Dante.
it is what it is.
I'm sure it's just a coincidence that Johnson quit the department shortly after this event and the charging.
If I was the defense attorney on cross, I'm going to ask him: do you think she saved you from death or serious physical injury? That's my question. If you hear that question, then you know. Because he's halfway in the car.
Yeah.
You did?
Yes!
Okay.
I shot him! Oh my God!
Kim, sit down.
PI access 63rd and Captain Drive, flight from 38 start north on the red.
Starting north on the red, then can you repeat your first part you said?
Before Ms. Potter said, I shot him, did you know that sound had been a gunshot?
No.
And after that, did you observe what happened to the white car?
Yeah, I observed it continue eastbound down 63rd and drive into oncoming traffic.
If you guys didn't notice, this is the George Floyd prosecution team.
Did you?
Yeah.
Yep.
Same courtroom too.
You heard that there was a crash down that direction.
Yes.
So
Not much of a courtroom, but
it'd be easier for us to refer to the stop scene and the crash scene. Does that make sense?
Yes.
Because there were essentially two scenes that day.
Yes.
Did you go down to the crash scene?
No.
And why not?
Because Officer Salvosa was already there.
Okay. And how did you know that?
I could see his squad pulling up right as Mr. Wright's vehicle had gone into incoming traffic.
Okay. And at that point, did you know that Mr. Wright had been shot by Ms. Potter?
I knew that a shot had been fired, but I didn't know if he was hit.
So when you're saying he drove into incoming traffic, you didn't know his physical condition at the time of the crash?
Correct.
Now, we heard some radio traffic calling
Nobody
for north on
would.
the Reds. Did you recognize that voice?
Yes.
Whose voice was that?
Officer Salvosa.
And did you do anything with your radio at that point in time?
I was trying to transmit, but I wasn't able to
Why not?
because there was other people on the radio.
So only one radio can run at a time.
Yes.
And so were you eventually able to get on, well, was it Officer Salvosa's radio traffic that was interfering with yours?
I think so.
Could be, I guess is one way to say it.
Yes.
Yeah, right. And then, so were you able to eventually get on the radio?
Yes.
And what did you do?
I called out that we had had shots fired and asked for additional resources to 63rd and Noble.
When you said shots fired, plural, do you know why you said shots if there was only one?
It's just always the way that it's been said.
Yeah, you always say shots.
I don't know where it came from, so it's just been shots.
Yeah, just sort of typical language, right?
Yes.
And then, so the additional people that you called in, why did you do that?
Because I knew that we had two scenes. We did have shots fired, and we're going to need additional help no matter what it was that had happened.
If an officer is involved in a shooting, are there separate procedures that take over to deal with that kind of situation?
Yes.
And in those situations, are there officers known as involved and uninvolved?
Yes.
And at this point in time, did you know that you would be an involved officer?
Yes.
And that Potter and Lucky would also be involved officers?
Yes.
So what did that mean to you at that point in time with regard to your supervisor role right then?
It meant that I needed somebody to take over as the scene supervisor once that was possible, because I wouldn't be able to do all of the things that needed to be done as being an involved officer.
And so then you called in, I think you mentioned other agencies. Do you recall doing that?
Yes.
Why?
I didn't know how many officers we currently had clear in Brooklyn Center, but I knew that we were going to need more than we had available that day.
And what did you ask at that point in time, Officer Potter and Lucky to do?
I asked them to sit down.
And and did your body-worn camera continue to run?
Yes.
And have you been able to observe that video as well, your body-worn camera following the incident?
Yes.
And at this time, we would offer Exhibit 64, which is that video.
All right, they're going to convict her on her legal
64.
conclusion that she's going to prison.
Yeah, that's it. This is kind of ridiculous. What they're doing to this poor woman. I understand she killed somebody. I understand she should be civilly guilty, but criminally guilty, I don't. They're nowhere near that.
Hey. I grabbed the wrong fucking gun. I shot him. Oh my God.
Kim, sit down.
Nick, what you've been saying all this time makes sense. If she grabbed the wrong effing gun, as she's saying, then you don't have a conscious disregard for a risk because she didn't know she had the gun. So like that kills it right there.
3 or 4 audible
It's the biggest
beeps.
problem.
Can you describe?
They have to
explain the jury
overcome.
what those beeps are.
Somehow
That was
making
me trying to
recklessness be
transmit
what it
over my
is.
radio. However, at the same time, somebody was already transmitting.
So that beep is an indication of what you described earlier, not being able to get on.
Yes.
All right. Okay.
30 mark on the red and can you repeat your first rate?
305, we got shots fired. Start more units, please. We're going to need additional units to Noble and 63rd.
Negligent homicide, guys, requires an element of recklessness for a criminal conviction. It's not like civil negligence. She's probably civilly negligent in this situation, but not criminally liable.
Take a breath, okay?
Just breathe. Car injured as well. As soon as we get additional cars, I'll check for injuries. Suspects are not compliant. They're moving it.
No, you're not. Just...
Prejudice shots from 1 on the unit.
Kim, that guy was trying to take off with me in the car.
That part is what the defense is going to jump on. That guy was trying to take off with me in the car.
Additional supervisors from other agencies, please.
He's still.
Yeah,
Yep. This guy believes his life was in danger. So did Officer Lucky.
Yeah, they got Lucky to say it. And Lucky said he would have used the taser too. That kills your first degree manslaughter. As soon as he said that, I would have used my taser too.
We'll take 2 rigs, stage them a couple of blocks out.
Oh my God. Oh my God.
Copy, stage couple blocks up.
Driver, stop breathing.
Driver not breathing.
I'll take an additional squad and we'll yank him out. But get him here on the rest. I'm by myself, holding him at gunpoint.
Take a breath. Kim, breathe, okay?
We can get the road shut down, westbound.
Yeah, just park.
I'll take it there.
My squad, not yours. Park with my squad.
Northbound at 53rd.
Kim, take a breath. Kim, you're okay. Take a breath, okay?
She looks like a horrific racist right now. Definitely wanted to kill a young man.
1 male not breathing, 1 female with facial operations. And then I've got
See, I think the point people don't understand is the conscious disregard means she did pull the gun and maybe was trying to threaten him with it, and the gun went off accidentally. You got your involuntary manslaughter. But her pulling the wrong tool,
Anybody that's
then
available.
there's no conscious disregard because she didn't initiate that risk. That's the part that the prosecution has to overcome. And there's no way watching this that they've overcome that.
Yeah, the state's trying to apply that Engel decision beyond reasonable boundaries.
And then we'll have to check on anyone else after. But the driver is not breathing according to the passenger. Several Brooklyn Park units are arriving.
And Cynic in the chat just brought up a good point. She doesn't look like Chauvin did at all during his video.
I can't see him. So we're going to need to
Completely
activate
different.
him if he's
And it
not
wasn't 9 minutes 29 seconds, right?
Come
It
up
was
Right.
Yeah,
instant
that's true.
decision in a violent physical confrontation.
We have a new panelist joining. Hello, Natalie. How's it going?
Hi, how are you?
Good. Nice to
Nat.
meet you.
Nice to
Anthony,
meet
just
you.
sit down here, okay?
3219, the suspect I'm at gunpoint at is a flee from 38 stop.
Working on it.
Hey, both you guys, okay. Are you anything injured?
6207, whoever got a bumper, come on.
Lucky's like, damn, this is my 4th shift. What the hell?
So, Natalie, you have two. Do you have 2 channels?
I have one channel.
Okay, one says Natalie Lawyer, and then there's another one that says Natalie Lawyer Chick.
Yeah, I don't know who Natalie Lawyer is, but I think
Hello,
she's,
you're free to
she's another
message.
person.
15-year-old son.
Wait, so you're Natalie Lawyer Chick then?
I'm the chick.
Okay, gotcha.
4142 arriving.
Lucky is very unlucky.
Yeah.
Literally, like one of his first. This is the worst. That was one of the people in the Chauvin case. It was one of his first shifts too when this happened.
Yep. Hey, Tim,
Yeah.
as soon as we're code 4 here, I'm gonna get all that taken care of for you, okay?
And that's not a coincidence either. I mean, the departments, both those departments, seen a lot of attrition. So when you have a lot of experienced officers quitting or retiring or moving to other departments, they got to be replaced. You're going to be replaced by young, inexperienced officers, and you're not going to get better decision making out of them.
Take him.
I just
Take a breath.
want to note how much fun any cop driving a Charger was having. Do you see that guy take off? Oh, you don't
No
need me
speed
here?
limit.
Video. Miss Potter can be
Yeah,
heard
both of
saying,
them were training off. Just think about that. Both of them were training off.
and that was when you said to
Chauvin
her
and Potter. Wow.
that he was trying to drive off with me in the car.
Yes,
Do you remember saying that to her?
I actually don't.
And when did you learn that you had said that to her?
When I watched my body cam video,
How long after the incident was that?
it was probably about a week.
In that video, she also asked to call Chuck, correct?
Yes,
And did you understand what she was asking?
yes.
Who is Chuck?
That would be Detective Chuck Ballou.
And do you know how to spell his last name?
It's V as in Victor, ALLEAU.
And did you understand why she wanted to call Mr. Valou?
Yes,
Why?
because he would be her union representative.
Smart.
While you were working,
Smart.
on April 11th, were you a member
Get
of
your
that
union
union?
rep right there.
Were the patrol officers a member of that union?
Yes,
And was Miss Potter, did you know if she was in a role with the union?
Yeah, no kidding.
This
Well, she wanted to assert her legal rights.
And the jury.
Yeah, that's what they're trying to get on.
Yep.
May I be heard about that, please?
Because the union automatically gets you a lawyer if you're involved in a police involved shooting to get you, and you get
Yeah.
and usually tell you to be quiet. So
Yeah.
Yep. So now they're gonna.
so they're trying to get around that.
They're gonna try and argue to make her look guilty by invoking her, effectively trying to invoke her Sixth Amendment right in the best way she knows how.
Right.
So
But
that'll-
that's the rub. They're gonna say she was asking for a union rep, not a lawyer, and that kind of
Right.
gets around it. But how
Right.
you get the lawyer is by getting the union rep. So
Right.
So, real quick, welcome to the stream, Natalie. You are an attorney. I believe you're a defense attorney, correct?
That's right. I'm a defense attorney.
Awesome. So happy to have you here. What state do you practice in?
I practice in Maryland, and I'm currently on my lunch break.
All
I've got a motion. So I've had virtual day today, but I've got a motion to suppress at 3:00 and a plea at 2:30. So I have a little bit of a break until then.
Well, I'm glad you joined us, and happy to finally be able to get you on one of the panels. So
I'm really so excited. Thank you so much for opening the invitation. I appreciate it.
yeah, absolutely. And guys, Natalie's channel is in the description, so you can just go click on Natalie Lawyer Chick, and it'll take you right to her channel, and you can check out her content. Make sure you subscribe, and hopefully we'll have her back on for more frequent visits. But she does this weird thing where she actually works or whatever.
we talk about it. Natalie actually goes and does it. So
Hey, Natalie, are you on Twitter?
I am.
How would I find you there? Is it a
Nat Lawyer Chick.
She's also in our group chat. Andrew,
Yeah.
where the links are.
Okay,
So you can
all right.
you can find her in there if you click on the members thing and follow her if you need to.
Thank you.
That assumes I know how to do any of that. Okay.
This is very interesting about contacting the rep and whether or not contacting the rep would be like talking about your invocation. This judge is very defense friendly. I would love her if I was practicing in front of her, but I wonder if she would extend it that far. It's very interesting, but it might be irrelevance. Like, why is it relevant at all?
Yeah, it has nothing. Again, most of their testimony has nothing to do with the 20
My
seconds.
original ruling is granting the objection.
Yeah. Because it was the way to get to the attorney, so you can't use that now against her.
Ms. Potter's union membership is not relevant to any issue in this case. You are to disregard any testimony regarding that. Okay?
The dirtbag.
Good ruling with an instruction, but yeah. Prosecution's pulling out stops today. Well, they were.
This is what a prosecution with a weak case does.
Yeah, they're pulling on all the emotional things right now.
And so, Major Johnson, did you then, for the rest of that shift until you left, stay at the stop scene?
No.
Right. At some point, you left the scene altogether. I guess my question should be more precise. Did you ever go to the other scene, the crash scene?
No.
And while you were still back at the stop scene, did you do something with Ms. Potter's firearm?
Yes.
And can you explain to the jurors what you did?
Due to her mental state of not knowing what she might do, I knew that her firearm was a piece of evidence at that time. So I removed her firearm and put it in my holster and put my gun in her holster, just so that evidence was preserved.
And then was that all captured by body camera as well?
Yes.
And Your Honor, we would offer at this time Exhibit 65.
Okay. The objection is overruled. I'll allow you to play the video. A65 will be admitted into evidence.
Thank you, Your Honor.
She's so no nonsense. I really like her.
I just hate how long it takes her to say anything.
So you're here, okay?
I don't see how they're going to get a conviction with her being so emotionally overwrought afterwards.
I'm going to take this, but give you mine, okay? No, that's not happening, Kim. I'm giving you my gun, okay? I'm just going to hold on to yours. All right? Kim? We'll get it all figured out, okay?
I don't know. I don't know what's happened.
Okay, Kim, sit down, please, okay? My gun in your holster.
I don't know what happened.
I mean, if she had known she had a gun in her hand, it could be reckless, despite this, emotional, obviously genuine emotional distraught after the fact. But emotionally, it will play well to the jury. Clearly, there's no malice here.
No, well, and that's not an element, right? It's the reckless for yeah.
Yep.
So her reaching to the gun where the gun is on the other side.
Major Johnson, were you wearing a taser that day?
Yes.
And during this time period that we just saw, immediately after the incident, did you check Potter and Lucky for injuries?
Yes.
And did you see any injuries?
No.
Did they report any injuries?
No.
And did other officers eventually come to the scene?
Yes.
And as part of that process you made reference to earlier, did you assign officers to Potter and Lucky?
Yes.
And explain just real briefly why you do that.
It's just to make sure that they are being taken care of, that we keep them uninvolved from the incident, that they don't hear anything else that is happening, and that person's kind of their caregiver for the next little while.
And under that policy, are the involved officers supposed to talk about the incident?
No.
And when at some point did another sergeant arrive to sort of take over a supervisory role there at the scenes?
Yes.
And did you provide information to that sergeant about what you knew?
Yes.
Just to be clear, it was a Brooklyn Center sergeant?
2 Brooklyn Center sergeants.
Okay. And then did they sort of take over control of everything at that point?
Yes.
And you provided them the important information that they needed to do that, to take over?
Yes.
And did you, subsequent to that, or later, obtain more information that concerned you about Officer Potter?
Yes.
And what was that?
That another officer was concerned that she may harm herself.
And which officer was that?
That was Officer Clean Fricky.
Do you know how to spell her last name?
It's F as in Frank, R-I-C-K-E.
And so what did you do?
Officer Potter was sitting in a squad, and so I had gone over to her and discreetly asked if I could see my firearm that was in her holster. I was able to turn away from her with my firearm, remove the magazine from it and the 1 round that was in the chamber. So at that time, there were no rounds in the firearm.
Did you do this in a way that she could see it?
She was not able to see.
And did you give the ammunition to somebody?
Yes, I handed it to Officer Fricky.
And then did you get it back?
Yes.
All right. And so at that point in time, where is the gun that Officer Potter used in the incident?
In my holster.
And where is your gun?
It is in Officer Potter's holster.
And the ammunition from your gun is where?
In my pocket.
Your Honor, we are going to offer Exhibit 71, which is a video of this incident.
Any objection?
I mean, relevance.
Okay, the objection is overruled. I'm going to let 71 into the play.
So they argued that it was cumulative because he just testified to it, but this judge has allowed testimony plus a subsequent video all day, every day of trial. So not likely to change.
And still photos after.
Because you weren't here at all, right? Can you stay with her? I would rather, she knows you. I'd rather have you stay with her. Awesome.
Can I make this?
Yeah.
And that's when Eldridge isn't repeating testimony again. I guess this is the lip reading part.
Very, very useful video. He testified to what the conversation was about.
There's somebody in the back of my squad who needs an ambulance. She needs a cut lift.
Okay.
It's wait on.
Talk to Peterson or somebody else. Okay. All I want you to worry about now is.
There's a female in the back of 332. She has some facial injuries. Can you just make sure she gets seen? No problem. Got it.
Kim, can I see my gun real quick? I'm going to give it right back to you, okay?
Making sure it's all good.
I'm just going to give her my gun for now. Okay. I have yours. Okay. Chuck is on his way, all right? I don't even.
And then at some point, did a commander come to the scene?
Yes.
And so just explain to us the kind of the hierarchy of sergeant, commander.
Yes, so sergeant, and then my direct supervisor would be the patrol commander, And his direct supervisor would be the chief of police,
And who was the patrol commander at the time?
Tony Grunig.
And let's see the habit I'm in. Can you spell Grunig for us?
It's G as in George, Ruenig.
And did he eventually come to the scene?
Yes.
And did you provide him information from the incident?
Yes.
And everything that you thought was important there?
Yes.
And did you explain to him that you thought the person was trying to drive away with you in a car?
No.
And were you able to then sort of stop any responsibility you had for controlling the scene and turn that over?
Yes.
And were you eventually taken from the scene?
Yes.
And somebody gave you a ride?
Yes.
And you went back to where?
The Brooklyn Center Police Department.
And did you understand at some point later then that the investigation would be taken over by an outside agency?
Yes.
And which agency was that?
The Bureau of Criminal Apprehension.
And did you have an opportunity to meet with investigators from the Bureau of Criminal Apprehension later?
Yes.
Just for the jurors' brief understanding, they are a state law enforcement agency.
Correct.
And during that part of the day, did the BCA investigators talk to you about the firearms?
Yes.
And can you describe for the jurors, what was done in that regard with regard to the two firearms, yours and Potter's?
Yes. They came to me and I had explained the circumstances of why I had that firearm, and they then collected the firearm from me.
When you say the firearm?
That was in my holster.
And which we knew at that point was the one that you had taken from Officer Potter?
Yes.
All right. And what happened then after that?
That was turned over to them as evidence.
All right. What about your firearm?
I didn't see my firearm again.
Okay.
Natalie, are you muted?
I was.
You did not bring your firearm back.
Chat was just saying it, and I was like, I hope.
I just saw that. I was like, am I? I think I was before.
Oh, okay.
Shortly after this, you wrote a brief report about what happened, correct?
Yes.
And,
What font did you use?
Would it refresh your recollection about those moments if you had a chance to look at that briefly?
Yes.
Okay. Your Honor, may I?
I do have a copy of it.
Why didn't you include our beach
With
pictures
you?
as your
Yes, I
visual
did.
aid?
If you want to look at if you could please, the second page, the last paragraph. Do you see that?
Yes.
And counsel, just for the record, Bates 650. Just read that to yourself. Does that refresh your recollection about your firearm?
Yes.
Okay. So did they bring you your firearm at some point?
They may have brought mine back, but I didn't get it back.
Okay.
That is still with the BCA.
All right. So they came to you with it, but maintained it as well.
Yes.
All right. Just want to clarify that. Okay. And so you turned over to them Potter's firearm as well?
Yes.
At least we know cross will be 1/10 this length.
It'll also probably be brutal for the state. For
Yeah.
the state case,
This-
I guess.
This cross is going to be monstrous for their case.
I hope it's Earl. I
And
like
as
him.
Part of that
Earl
interaction,
Grey.
BCA agents, did they actually take photographs of you in your uniform?
Yes, they did.
What is this relevant to?
That's all I have here.
Chain of
Fluff.
custody?
Members of the jury.
I think for the firearm.
Morning
Chain of
break.
custody for the
Okay, so,
firearm. That's what it is.
20 minutes.
But that's really not at issue here because we've seen
No.
the shooting. So I don't know why they would have spent so much time on that.
Okay, what is this? Fox, what are you doing to me? To the panel, I have a question for you. Is there a dispute over whether or not this car was in park prior to the shooting?
Well, I think one of the arguments the state wants to make is that even if she was going to tase him even if she had tased him, that would have been a reckless use of force because the car, if it had been in gear, his foot on the gas, then he's tased, he's immobilized, the car just becomes a missile on a public roadway. So that becomes recklessness that could support, I don't know, this charge of manslaughter, I suppose.
But do we have anything to suggest that the car was in gear? I mean, the Officer Johnson's testimony is that he was pushing on the gear shift, but it was already up. So he pushed it up. Even if it hadn't been, it was in park, and the shot is fired. He doesn't let Dante Wright get his hand on the actual shifter prior to the shot being fired. I mean, I'm just curious, do you guys see any potential that this car is somehow in gear prior to the shot?
But I think what the state's trying to do here is just create like a general feeling of recklessness, feeling of hazard, something for the jury to latch onto in an emotional sense, not in a reasoned line of argument sense.
Right. So if you'll recall, though, I asked you a question of if it was in gear, not what the state's trying to do. So do we have? So can I get an answer from you, counsel?
I haven't seen any evidence that the car was in gear, and only evidence to the contrary.
Sorry to badger you a little bit. No, there's someone in chat suggesting that there's a dispute over this fact, and I'm like, I don't see the dispute at all.
I think what we need to do is we have to be able to finish the cross on Major Johnson, but today. So we're not going to split it up. But let's take a 20-minute break, and I'll check out what the weather is. Okay.
Are we seriously going to have a weather delay on?
Well, I mean, they're not used to snow there.
Are we kidding? It's Minneapolis. It's like, here's how weather delays work in Minneapolis. You wait an hour and they plow it. The amount of snow that has to fall to make it unreasonable to travel in Minnesota is astronomical.
I think you would automatically sequester a jury in that state with a case this serious, knowing the type of weather that you get. Just sequester them in a hotel that's walking distance so they can get right to the trial.
It's Minneapolis. There's a skyway to a million hotels, a million restaurants. You don't have to leave the skyway to get pretty much anywhere important downtown. And that court building's connected right to it. I used to work right by there.
And they have more than one plow.
Yes, they have many plows. And you in downtown, after a very short amount of time, most of the car tires have done the work anyway. You're going to have, wet, sloppy snow because it's 30 degrees. And the road and with the cars driving on it constantly is going to melt that down.
So
hey, Nick, during this break, I'm actually going to log out and log back in, see if I can get that comment field back in. And for the people saying it's because I'm old and I messed up the window, yes, I'm absolutely certain that's what happened.
So wait,
but I'll come back in just a moment.
Is it okay? It's your comment section in the StreamYard thing. Is that what it is? Okay. Yeah.
So the private chat, I have a little box where I can chat with you folks. In the comments, I used to have a box, but it's not there. So
are you? Did you check to see if you're actually subscribed to my channel?
No,
because you can't comment if you're not
on
subscribed on this stream, and so that might be feeding back, but I have no idea. I don't know how it would do that.
All right, I guess I'll take a look at that too. But
also,
in any case, I'll be
caught in 4K if you're not. Just kidding. Yeah, pop on back in.
So I have a quick question because I'm gonna pop off for a couple minutes for my next hearing, and then I'll be back on.
Sure.
But my question is this, going back to your question, could it be argued that even if the car wasn't in gear, and I'm not 100% sure that it wasn't, but I haven't heard any evidence so far that it was, maybe in the video, maybe they'll say, oh, you can hear it or something. I don't know. But say that the car wasn't in gear, couldn't the state still argue, not the best argument, but couldn't the state still argue that the fact that he was trying to drive the car away and then you tase him and, he's trying to put the car into gear, you make him lose control of his body, and then he does actually crash. So it was reckless because you can see what's happening. You can see, it's not like he's sitting there compliant, obviously, or else they wouldn't be tasing him. Sitting there compliant, and then they, tase him. And there's no way we could have known that he would have. But it's like there's a reasonable apprehension of risk that a person trying to drive a car away is going to drive the car away, and then by tasing them, you're going to make them lose control of the car. Do you see what I'm saying? Like,
yeah. I think the state could make that argument. I was just feeding a personal vendetta in the chat. That's what I was doing because I'm petty.
Okay.
But
noted.
But no, there certainly is sort of that element, but it gets to all of this gets to a problem for the state. Using a taser at the time that the car is in gear and moving, where his feet might hit the thing, could be unreasonable. But at the same time, then that kind of bolsters the argument for deadly force. Is if you have cops in the car and this guy is trying to engage the gear shift and drive away, then those cops are suddenly at imminent risk of substantial bodily harm or even death. And so
he's attempting to flee. I mean, he's not like cooperating with the arrest and they want to tase him. And if he's going to flee, he's not going to do it at safe traffic speeds, right? He's going to flee at speed from the arrest, and that's dangerous too.
That's true. Yes.
That was one of the annoying objections they missed yesterday. I think it was yesterday or the day before. Or maybe they tried but got overruled by the judge. But they said basically, if he drove away, couldn't you follow him at a normal speed? And it's like, how on earth could you know how fast he's going to drive?
That's a lot of speculation.
Yeah, that was a strange.
That was Nick was sitting there screaming, "Calls for speculation!" Like
that. But I mean, I think the biggest evidence that the car's not in gear is that it's not moving at all. And so unless he had engaged the parking brake, and we don't have any evidence that the parking brake's engaged or that he disengages the parking brake, no one's talking about reaching for a parking brake. And if there doesn't appear to be anything like that, cars in gear move unless it's a manual transmission. And then if you take your foot off the clutch while it's in gear, it shuts off. So you have these weird issues going on with that. But
I thought the car was in gear, but I have to go back and watch that video again. You always assume things and then have to look at it again.
Yeah. I mean, it clearly gets in gear, and and up until today, I mean, this is the first testimony we have about that. And the testimony in the body cam footage was that Officer Johnson, he pushed the gear shift as far forward as it could go because that would be in park. And then he had his hand obstructing another hand reaching apparently for the gear shift, which he determined to be Dante Wright's hand. But that hand goes away prior to it actually engaging, and then the shot is fired. So I think from the way I look at it, I don't see a current dispute. I don't see any testimony to the contrary. The girlfriend didn't testify that. She's the only, now all of the witnesses to the incident have testified about the incident, and that I don't know how they would elicit that fact if they're going to try to. And I think they should be trying to get to recklessness, but they haven't yet. So
it's right now based on.
All right. See you later. Thank you.
Come on back.
I'll be back. Okay. Thank you, guys.
Yeah.
I'm actually going to go and I'll be back later. But one thing I'm like looking at this trial from the last couple of days we've been going over this thing. I'm getting those Rittenhouse feelings of not guilty, a strong not guilty going down here, because I just don't see any evidence they've put forward to show me that this person was culpable, was negligent, and was a culpable negligence under Minnesota law. And the sense of that this was, if let's say if she put the taser on the wrong side of her duty belt, gotcha, right? You put the taser on the wrong side, you pulled it. We train you not to do that. You took a risk and it didn't work out. Gotcha. Or if she pulled the gun out threatening the person, and then it went off. Okay, gotcha. But every piece of evidence and everybody they've put on, even the other cops have said I would have tased them too. So, I'm trying to understand. It's almost like they're trying to ask the jury to kind of ignore that piece of it and just say, okay, well, because of all, because if she tased him at this time, it could have caused more problems. So you should find her guilty of being reckless in this moment. But the moment that the jury's supposed to be considering is when she pulled that gun out. Did she know that she was pulling her gun, or was it a mistake? And if it's a mistake, then there's no way that she can be found guilty of either manslaughter in the first or even the involuntary manslaughter because you don't have that conscious disregard of a risk. It's just there. I don't know where they're going with this. That's what I want to really say.
I can tell you where they're going because they filed it in their motions. But I agree with you 100%, Nate. That's my reading of how the law ought to apply to these facts as well. But what the state is saying is that they have this Engel decision where a security guard had a gun in his hand and then was struggling to pull someone out of a car, shot the guy by accident, never intended to fire a shot. But the court said, well, just having the gun in your hand in a struggle was enough to support a claim of recklessness. There's a risk that the gun might go off during the struggle, right? You clench your hand, the gun fires, even if you didn't intend for it to fire. And now the state is saying, well, we read Engel to mean that if you do anything intentional, that's enough for the intention part of recklessness. And in this case, she intentionally, her intent to pull the taser is sufficient to check off that box for the intentional requirement for recklessness. I think that's an insane reading, but that's the argument, because when the defense tried to get the charge dismissed on the argument you just made, and the one I agree with, and that was the state's response. So the judge has actually heard that argument from the state and said, well, that's good enough to go to trial on.
But even in that Engel case, even in the Engel case, you're right. He had the gun, but he pulled the gun intentionally.
Yeah,
right?
he knew he had a gun.
Pulled the gun,
right?
Yeah, and in this case, she didn't know. So
she did.
That's the difference. That's the key difference. So I don't know. Maybe, but again, it's probable cause versus the beyond a reasonable doubt. Maybe that's it. Well, there's enough probable cause to take it to a jury. But this is what's dangerous.
As a matter of law, I see this whole case really as being a question of law, not a question of fact. I think the essential facts are undisputed. It's whether or not the facts, the undisputed facts, can even support a charge of manslaughter on the legal merits, and I just don't see it.
Well,
I don't see it either.
I think the state could. I don't think they're doing it. It doesn't seem to be the tack they're taking, but the state could make the accidental nature of the draw a fact in dispute. I mean, I think they'd get crushed on that argument.
Yeah.
But to bring that to a jury and say, well, Your Honor, if the question is whether she intentionally drew the gun or maybe knew or should have known she drew the gun, so therefore it gets to something which is weird.
But that's negligence,
right? But so if they can make a fact question for a jury out of drawing the gun, then that I guess could be going. Or if she became aware, if the jury could determine that she became aware that she had a gun in her hand, because it's on the body cam footage. They did mention 5.5 seconds. That's where I think they could get a jury question on it. I don't think it's a strong argument, but I think that might be enough to pass the dismissal pre-trial. But they shouldn't have been charged, frankly.
No, of course not. Of course not. Yeah, they have to get resolved, and that's the piece that they can't get resolved, is that conscious disregard. I know I have a gun, and that's the problem, and that's the piece that there's been no evidence that gets them over that point. But we'll see. I'll see you guys in maybe another hour, because I'm going to jump over on Eric's law, what they call Legal Palooza stream for a couple of minutes after I pick up my kids. So
awesome.
I'll see you good people later, bro.
Talk to you later, Nate.
Peace. That's the stuff they seem to be trying to get to. It's a mess. Officer Johnson's testimony, I don't see anywhere where it helped the state. But some people in the chat were asking, why are they calling these witnesses on direct? Wouldn't they rather cross-examine them? The problem for the state here is that they have to call somebody to make a factual basis to do this case. Otherwise, if they don't call Officer Lucky, Officer Johnson, if they don't call those
maybe the
guys,
defense doesn't call them,
then
then you don't get to cross.
How do they establish the facts? And then the defense says, we rest and move for a dismissal, Your Honor. They haven't even raised facts at this trial that would support the cause. They clearly misrepresented their case during pretrial motions, and then you move.
Plus, they've been getting away with leading questions anyway.
Right. They did. That first day, that redirect was really bad on Officer Lucky, and they let the leading questions go quite a bit. The second day, they pounced on him a little more. But
no, they were basically asking the witness to just move their jaw, and they would provide the testimony,
right,
to the jury.
Okay, so Rusty Radloff asks the question: do you call Potter to testify at this point? as the defense.
I mean, they said they would. They've already told the jury that they would. So
Right.
if listen, there's always risks involved, but once you tell the jury you're going to have your client testify and then they don't take the stand, the jury's going to be like, that doesn't seem right.
Such a weird thing I don't know why they tell the jury that their client's going to take the stand. I don't know why they.
I mean, you're really committed at that point.
Yeah. Well, I think with Potter, though, what seems to be the case is she seems to be someone with a clean record. She seems to be someone who's generally liked in the department. I mean, she was the union rep this is the person that if any of these guys had a problem with their employment for a period of time, they would have all talked to her. They would have asked her for help and she would have provided that help. She's probably well liked in the department. Every cop who's testified seems apprehensive to say anything negative about her or even her actions this day. Again, the opposite of, in some ways, of Chauvin. It wasn't as clear cut. And she doesn't seem to have been in the field as, there's some testimony that she was in the field over her career, but it doesn't seem to be a lot. So she doesn't have like excessive force stuff or anything that they could bring up. So they're not really worried about her character. And they're not really worried about how she's going to come across talking to this jury, because how she comes across on the video was extremely immediately remorseful.
Yeah. So, I mean, the three risks of putting your client on the stand are always, their character. Normally the defendant's a criminal, so there's lots of stuff you can bring up. That's not the case here. The other two risks are that the prosecution might goad them into some kind of outburst that would look bad, because folks, you don't know what it's like to be subject to cross-examination by a really skilled prosecutor or attorney in general until you've had that experience. I mean, they had Rittenhouse on cross for 3 hours. That's tough. And then the third risk is the prosecution knows what they want to say in closing, and they're going to ask very carefully phrased questions to try to get very specific words out of the witness that they can then kind of block together in their closing argument to support their narrative of guilt. And the witness has really no idea what those magic words are that could be so damaging to them.
Right.
And those second two risks are, there's no way to really absolutely secure your client against those, no matter how innocent they are.
Correct. Evil Bunny has a question for you. Says, question from your text, assuming the advanced class for January 8th is not full yet.
It's not full yet. Yep.
Okay. Do you have any idea? They were saying they might know some people, so they should direct them to the class. They're already taking it.
lawofselfdefense.com/advance. When it's full, we'll let people know.
Okay. Perfect.
I mean, they won't be able to sign up if it's full, so they don't have to worry about it. If they're able to sign up, there's still spots available.
Mikkel Nino says, can you please cover the Daybell/Vallow trial? It won't be until next year. It's wild. Sex, murder, and zombies. Yeah, I need to read up on that case, but I'm not opposed. I'm not opposed to covering that trial. I think it'll be sensational, and it's got some public attention to it. So that could be very interesting. Mark Gee says, Nate, what country is this? Oh, shoot. I should have asked before he left. But we know this is MAGA country. That meme should never die. Jonathan Duger says, the easy way to test that would be the dash cam. To put the car in drive or park would, hold on, I'll bring the court back on. Would require the depression of the brakes, and the reverse lights would flash moving through reverse. Oh, there you go. Yeah, that'd be interesting. Dragon's Treasure says, since November 12th, I've been working 12 to 15-hour days trying to catch up to everyone's ridiculous volume of orders. As of yesterday, I finally caught up. Thank you, everyone. Got some new equipment, so I'll never be so late again. That's Dragon's Treasure Tea, thedragonstreasure.com, a haven for tea and anime lovers. Check it out if you like loose leaf, hand rolled, picked, whatever tea. It's really good. It's high quality stuff. I actually like it quite a bit.
It looks like we're going to have the tea man on cross. Speaking of tea.
Yes. I like Earl Grey. I like his presence in court so far.
Yeah, I've been very impressed by the defense.
Okay, please be seated.
Yeah, both he and Eng are capable and competent so far.
Members of the jury, I know you don't have any windows in the courtroom that you're waiting in. So I wanted to let you know that it hasn't started snowing. Okay. All right.
She has to tell them so they
Okay,
actually pay
does
attention and
the
are not
defense
thinking
have
about
any
dying
cross?
on the way home.
Good morning, Major Johnson.
Morning, sir.
Your present employment is where?
Goodhue County Sheriff's Office.
Okay, and you're a major there?
Yes.
Could you tell the jury what that means as far as, in Goodhue County, that's in Red Wing?
Yes.
Red Wing. Could you tell the jury what that means, being a major on the Sheriff's Department?
Yes. Basically, I oversee the patrol division of that agency.
Okay, so you're the boss?
One of them.
All right. How many oversee the patrol division?
Just me.
So you're the boss of the patrol division?
Of the patrol division.
Okay. You don't like to brag about it?
No.
Okay. You've known Kim Potter for many years, is that right?
Yes.
When you came on the police force of Brooklyn Center in 2005 was when you first met her?
Yes.
And although you didn't work the same shifts, you would run into her at various times?
Yes.
Would you consider yourself a friend of hers?
As of recently, or I should say, over the past few years, we've become more of friends.
Okay. And in 2019, you were a sergeant at that time, but you were assigned to the patrol of her unit, right?
Yes.
Correct? Okay, I mixed those words up, but I think you understood it. So you oversaw her from 2019 until this year, correct?
Yes.
And was she, in the review of her, was she determined to exceed expectations? Do you know what that means?
The objection is overruled.
Did she get that? Tell me if you know this or not. Did she get in her review the top review of exceeded expectations?
Yes.
And what is that meaningful? What does that mean to a patrol officer?
That means that they go above and beyond the normal activity of a patrol officer.
And you were aware that she also worked with domestic victims, is that right?
Yes.
And she also was a casket carrier for officers killed in the line of duty, correct?
Yes.
Now, to your knowledge, and since you worked with her since 2019, worked over her, have she ever received a complaint of excessive force?
No.
Objection, Your Honor.
The objection is overruled. And the answer will stand. Major, will you just remember, if an objection is made, stop talking right away, okay?
Yep.
And don't answer unless I tell you to.
Yes.
But the answer will stand.
You should ask the question again.
Just to clarify.
So,
just to make sure the jury heard.
Let's just go to the incident.
Missed opportunity
On
there.
April 11th, you heard Officer Lucky over the phone, go ahead.
Radio.
Radio, thank you. You heard Officer Lucky over the radio say he's making a traffic stop.
Yes.
And you knew at that time that Officer Lucky was a trainee, and Officer Potter at that time was their FTO, correct?
Yes.
Field Training Officer.
Yes.
And so you decided to go there as being the officer to watch over it, correct?
To be his assisting officer, a backup officer.
Okay, a backup officer. Your Honor, excuse me a minute. Where's my water?
Now he'll sound less gravelly.
Vodka.
And we already went over the video and of your testimony as to when you arrived and you learned about that the fellow that had been stopped, Dante Wright, had a warrant for a weapons violation.
Yes.
What does that tell you as an experienced police officer and now a major at Goodhue County Sheriff's Office when somebody has a weapons violation?
It means if they had a weapon before, it's possible they have a weapon again.
All right. It also means that they had the weapon illegally because they did not have a permit for it.
Correct.
And in order to have a weapon, you have to go through classes and get a permit, correct?
To carry it, yes.
So he had a weapons violation warrant by a judge, correct?
Yes.
And he also had a restraining order, correct? Order for protection, OFP?
Yes.
And at the time you were talking to Lucky and Kimberly Potter, Officer Potter, you learned that, correct?
Yes.
And they decided to execute the warrant and find out who the lady was in the car, correct?
Yes.
And was that proper procedure based on your experience and you overseeing them?
Yes.
You agreed with that, correct?
Yes.
You also knew that there was marijuana. You were told there was marijuana seedlings or something else in the car, correct?
Yes.
So your goal was when you went up there to the right car was to arrest him for the warrant and also to find out who the lady was next to him to make sure that was not the lady that had the FTO on it, or not the FTO, the order for protection on him. Is that right? And when you went up to the vehicle, you went on the passenger side, correct?
Yes.
And that was to what?
As a cover officer.
What does cover officer mean?
Somebody who gets a different view of what's going on inside the car.
Okay, and if there is some kind of attempt to escape, you could assist in stopping the escape, correct?
Yes.
And that's what cover be covering your arresting officer, correct?
Yeah, part of it.
So in this case, we've watched many, many videos and time sequences. And when you went up to the car, Officer Lucky, based on the videos, told Mr. Wright to step out of the car. Do you remember him telling him that? You don't remember exact time, but do you remember that?
Yes.
Okay. And did Dante Wright step out of the car right away, or don't you remember?
As far as I remember, he did.
Okay. And when he stepped out of the car, Officer Lucky was going to handcuff him, correct?
Yes.
But you were the first one that yelled over to the other side of the car and told Dante Wright that he was under arrest, correct?
Yes.
And then the other two officers, Officer Potter and Officer Lucky, also told him he was under arrest, correct?
I didn't hear that.
You didn't hear that?
No.
All right. So between the time that you told him he was under arrest until the time that he resisted arrest was approximately, according to the tapes, approximately 13 seconds. Is that about right? From when you told him he was under arrest to when he tried to get away from Lucky and get in the car?
Without seeing a timestamp, it sounds about right.
Sounds about right. And then when he pulled away to get back in the car, 6 seconds later, when he was struggling with Officer Lucky, and 6 seconds later, Kim Potter, according to the video, went around Lucky to assist Officer Lucky in trying to restrain Dante Wright from not getting in the car. That's what's in the video, Judge. I'm cross-examining him.
This witness is questioned. He's talking about some other piece of evidence.
All right, no speaking objections. If you want to make an objection, one word objection.
Now the state got slapped.
We can sidebar if you want. Is the state requesting a sidebar?
Yes, sir.
Don't have him testify about what's in the video. So they're objecting to him talking about the timeline of Kim Potter walking around Officer Lucky because it's somehow in not in his
I think the
testimony.
real objection is that Gray is characterizing her conduct as assisting in making, a safe arrest, which of course they
Sure.
want to characterize her conduct as reckless.
Right. Let's see. Eugene says no pesky snowplower will keep the judge from prolonging this trial. That's true. Earl's animated on this one.
Yeah, they've been for two old codgers. I've been quite impressed. Not their first criminal defense.
No. It's why you pay a lot for Earl. He's not cheap. Not a cheap individual, but they do the work. I was impressed during jury selection when they brought up the jurors' social media posts.
Yeah.
It's like, okay, they've gone outside the scope of just the initial basic voir dire. They've done research on, at least tried to do some research on social media of these people.
Like, are any of these witnesses in your Rolodex?
I've heard of a thing my grandkids use called MySpace. Have you, or do you have a MySpace?
The
You have mail?
Overruled, and you may proceed, Mr. Gray.
Thank you. According to the other video shown to the jury, after you said he was under arrest, approximately 13 seconds later was when Dante Wright started pulling away and trying to get back in his car. Do you agree that that's what you saw?
Yes.
About 13 seconds?
Now he's restating. Good.
And then approximately 6 seconds later, although you didn't hear it, on the videos from the other officers, from Officer Lucky, Officer Potter said, "I'm going to tase you." And did you hear that?
Yes.
Well, you heard the second one, I think. There was "I'm going to tase you" first. There's two "I'm going to tase yous." One you didn't hear. It was on the other side of the car.
I heard one.
Yes, we'll get there. And then after
just slipped that testimony.
By the way, when Officer Lucky was attempting to keep him outside the car, was Dante Wright resisting, or was he not? He was resisting and trying to get back in the car, wasn't he?
That's what it appeared.
Yes. And he didn't stop at any time when Lucky was wrestling with him to say, "Okay, I give up," and put his hands behind him, did he? Okay. And although he didn't hear it, seconds later, there was a statement by Officer Potter, "I'm going to tase you." He didn't stop then either, did he?
No.
He kept resisting, right?
Yes.
And what's an officer supposed to do when you're executing an arrest warrant for a weapons violation and trying to find out who the lady is when somebody does that? Are you supposed to let them go?
No.
What are you supposed to do?
Put them under arrest.
And if they try to get away, use force, correct?
Yes.
So 3 seconds after she said, "I'm going to tase you" the first time, she said again, "I'm going to tase you." And at that time, according to the videos, she was pointing what she thought was a taser, but it was a gun, at Dante. Right.
Is there a question, Mr. Gray?
Yes, I am. I wasn't done with my question. At any time between the time that you saw him, Mr. Wright, go into the car, into the white car, until you heard the second, "I'm going to tase you," did he stop resisting at all?
No.
Did he enhance his resistance by still fighting with people to get in the car?
Yes.
And what's your size? What are you, 6'2" or something?
Yes.
6'2", good shape.
I'd like to think so.
You work out.
And we've seen Officer Lucky.
You ever see naked men in the gym?
Yes.
Did it appear unreasonable to you as an officer that this driver of this car, Dante Wright, with this warrant, would do what he did? Did it seem unreasonable to you?
Yes.
So after the second, I'm going to tase you, and that's the one you heard. After you heard that one, did the Dante Wright stop at any time and say, okay, I'm done, give up?
No.
And at that point in time, was that when you went into the vehicle to grab that shifter?
It was probably a little bit before that.
Okay. And you're in there and you were struggling with him with your strength, right?
Yes.
To you, it was an exigent circumstance, an emergency, correct?
Yes.
And you were trying to get a hold of the shifter to stop him from grabbing that, correct?
Yes.
And you also tried to get a hold of the key with the other hand, correct?
Yes.
And you were in that vehicle and your body was lying over the young lady in there, correct?
Yes.
And one reason your body was lying over her was to keep her from sitting there, right? So she wouldn't get involved. Your statement?
Yes.
And then you weren't having any success in calming him down either, were you? He was still fighting and struggling, correct?
Yes.
And then you heard taser, 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 and that would be approximately 3 seconds after you heard Officer Potter say, I'm going to tase you. There was a time period between when she said that and when she said taser, 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 correct?
Yes.
During that time period, did Dante Wright at any time show any sign of stopping, giving up, saying, okay, I'm done?
No.
And then after, when the taser, taser, taser was said, approximately a second later, you heard the shot and you thought it might be a taser, you didn't know. The loud noise, correct?
Yes.
And the reason that an officer with a taser says taser, taser, taser is to warn other officers that were in the vicinity of this fellow, Dante Wright, to back off, correct?
Yes.
And by the way, in using a firearm, you're taught in training that if you use your firearm, you're expected to shoot your firearm twice, correct?
Not every time.
Okay, but are you trained on that?
It is one of the things, yes.
Yes. And that's called using deadly force, correct?
Yes.
In this case, you heard one pop and that was it, correct?
Yes.
In between the time of taser, taser, taser and a second later, did you release from the body of Mr. Wright?
Yes.
And then you went outside the car, correct?
Yes.
And you're disoriented, correct?
Yes.
And that's because of your struggle with him and the loud noise. Fair statement?
Yeah, the loud noise.
And you, as soon as you got out of the car, according to the videos, that car took off like a jet. Fair statement? Did you see it in the video?
Yes.
Did it go quite fast?
Yes, took off quick.
And within seconds after it took off, there was a loud crash, actually 2 crashes, correct?
Yes.
And that was the accident down the block, correct?
Yes.
Approximately a block away, half block, do you remember?
Just a little more than a block.
More than a block.
Car taking off like
And
a
then-
jet is way more impressive than a jet taking off like a car.
Officer Potter realized that she had shot him. Fair statement?
Yes.
And you didn't know that at first, correct?
No.
And then after she said she shot him, she was really having a difficult time saying, oh my God, oh my God, oh my God, correct?
Yes.
And you were concerned about her, correct?
Yes.
And then she said, oh my God, I'm going to go to prison. Do you remember her saying that?
Yes.
And Lucky said, according to the video, no, you're not. No, you're not. Kimberly says again, oh my God. Lucky says again, no, you're not. You remember that?
I don't.
All right. then you said, Kim, the guy that was trying to take off with me in the car. You agree you said that, right?
Yes.
And if he had taken off with you in that car halfway, what would have happened to you? What would you think would be the worst that would happen?
Probably dragged.
Dragged and what?
Injured.
Seriously injured, maybe even dead, right?
Yes.
And if that were the case, would an officer
He dragged
in your
that out of him.
position with Officer Potter trying to stop him from resisting with you and resisting Lucky, would it be fair for that officer to use a firearm to stop him?
By state statute, yes.
By state statute.
Yes.
There's a statute that says to avoid death or grave bodily harm, you have a right to use deadly force, correct?
Yes.
And you're aware of that statute.
Yes.
Nice.
So basically, based on these videos and the conduct of Dante Wright, as far as you're concerned, and you were there, Kimberly Potter would have had a right to use a firearm, right?
Yes.
There it is.
Yep.
I've been arguing that from before the case. That's if she would have just pulled it and not said taser, she would have been justified anyway.
The trouble is there's no unintentional justification.
It's trouble for a legal argument.
Yeah,
I don't know that
right.
it's a trouble for a jury.
Oh, I'd be making this argument too.
Yep.
I confer with co-counsel for a minute.
Whoa, they went into full reverb echo mode there. That's good. This is a good cross.
Yeah.
Of course, it really helps when all of your cross-exam witnesses are very favorable.
If that always helps, it helps to have the facts on your side. And, that's a handicap the state has. That's why they go on so long.
Yep.
That's it.
Thank you, sir. I'm done.
Correct.
Just minutes. Which the state has to redirect. Oh,
Thank you. Major, you were asked about the right to use a firearm.
Yes.
And you've had extensive firearm training, correct?
Yes.
And when you use a firearm to shoot somebody, that is deadly force.
Yes.
And
blow up his heart.
Ms. Potter used here was deadly force.
Yes.
And when you use deadly force, you have to consider surroundings.
Yes.
And when you
Objection leading.
Yeah, no kidding.
No leading questions, please.
I will rephrase. When you use deadly force,
just use the word
you
how.
need to consider surroundings.
Yes.
And do you need to know whether you could shoot another police officer or another person?
Yes.
And on April 11th of 2021, the Brooklyn Center Police Department had standard issue ammunition.
Yes.
And that was, what kind of ammunition did you use?
I don't know specifically which one.
Was it hollow point?
Yes.
And
blew up his heart.
when you
The heart blew up.
could Officer Potter, in using a firearm, have shot you?
Possible.
Could
Speculation.
And the objection is sustained.
how's that?
How's that?
Could she have shot you? Yes.
Can I sidebar and figure out why you just defeated my line of questioning? Oh my gosh.
This is a very experienced prosecutor, folks. I mean, he's flailing like this because they don't have the legal merits. That's why.
Yeah, if they look, it's the same thing with Binger. The reason Binger looked incompetent and Krause looked incompetent is because they had a bad case.
Right.
These are guys who put people in into jail and prison all the time, daily. They're
Easily.
they're not winning jury verdicts daily. They're negotiating out plea agreements, and then they're winning several jury verdicts a year, likely. Benjamin Blatt says Major Johnson looks like Cameron Fry from Ferris Bueller. Grew up, learned some hard lessons from wrecking his father's car, and set his life straight. He also hit that bench press, so now he doesn't kick cars out of garages anymore. He just picks them up and throws them.
So Nick, just FYI, on a tech thing I was having with the comments, I still don't have a comment field in the whatever they call that duck thing.
Weird.
I do have a comment field on YouTube. I am subscribed on YouTube, so YouTube would permit me to comment.
Okay, what I would do is
you don't have to do anything. I just want you to be aware. I mean, it's not a problem for me. It's fine.
Yeah, I don't know. I wouldn't know how to fix it anyway. You can pop the chat out on your YouTube if you want it in just its own, just the chat window. That's what I do.
Okay.
Counsel, I'm going to let you rephrase that question.
Good tip. Thanks, Nick.
When you heard this loud pop, which side of the car were you standing on?
Passenger.
And which side of the car was Officer Potter on?
Driver.
And where in relation to the two of you was Mr. Wright?
In between.
And when you heard the loud pop, where were you in relation to Mr. Wright? How far from him?
6 inches to a foot.
And where was the female passenger at the time of the pop?
Right to my left.
And where was Officer Lucky?
I don't know.
And at the time of the loud pop, you could not see Officer Potter, correct?
No.
And in part because you were looking, well, why is that?
I was kind of looking down towards the center console, and Mr. Wright was in between us.
And you don't know, well, let me ask you this.
I'm struggle.
You did not take out your, well, did you take out your gun and shoot Mr. Wright?
No.
So irrelevant.
Did you take out your taser and taser Mr. Wright?
No.
He was physically fighting with him. Hands were occupied trying to.
Indicated that you could have been dragged. Were you dragged by the car?
No.
And
So irrelevant.
did you just stand up as the car pulled away?
Yes.
The entire time of the interaction with Mr. Wright, where were your feet?
Either against the curb or against the street.
Half inside, half outside the car.
Wonder if Earl's going to come in and recross him.
He should. I would.
Yeah. You weren't dragged, but you were afraid you might be, right?
Right.
Any officer would be
You,
afraid of being dragged,
were
right?
asked
Do you know any officers who were dragged?
if, based on your position in the car, you indicated you could have been dragged, correct?
Yes.
And you indicated that you wanted to keep him from fleeing.
Yes.
And why did you then grab the shift knob of the car when you first reached into the car?
To keep it in park.
And to prevent it from moving?
Yes.
And when you had your hand on the shift knob, did the car move?
No.
When you had your hand on Mr. Wright, when you had both your left and your right hands on Mr. Wright's right arm, did the car move?
No.
After Officer Potter used her taser, did the car move?
After the taser?
Correct. I'm sorry. After she said taser and used her gun, did the car move?
Yes.
So she put you in danger, didn't she?
He made the car move. That was a foreseeable risk.
Just want to clarify a couple of things.
To be fair, that's how I drive. I just shoot my car.
You were asked if you were
Just fire one shot.
disoriented from the struggle and the loud noise. You said loud noise. Why were you feeling disoriented at that time?
Inside the vehicle with such a loud noise kind of throws your balance off and confuses you a little bit.
Did it affect your ability to sort of do your job right at that moment?
I was leading and moved the question straight.
Well, I'll let you finish the question first. What is your question?
Did that affect your ability to do your job at that moment in time?
The objection is overruled. I'll let you answer.
Not specifically to do my job.
Were you disoriented at all from the struggle, as counsel asked you?
No.
You were asked, you thought the car took off like a jet. Was jet your word?
No.
Would you ever describe it as taking off like a jet?
No.
Did Mr. Wright ever strike you?
No.
Did the passenger ever strike you?
No.
Did Mr. Wright ever grab a hold of you?
No.
Did Mr. Wright try to grab a hold of the shift knob?
Yes.
Were you able to prevent that?
Yes.
Mr. Earl Gray, Mr. Gray, with a name like Matt Frank, I should not make that mistake. Mr. Gray asked you if you were lying over the female. At any time, was it necessary to hold yourself up by leaning on her?
To hold myself up?
Right.
I was just kind of balancing against her.
Were you standing on the ground at that point?
Yes.
What was the point of leaning against her?
So that she wouldn't be involved in what was going on.
Incredibly dangerous, by the way.
What's that?
Her leaning against
Based on your
him
training
leaning against her like that.
experience, all these years as a police officer, are you trained about entering cars of people who might flee?
No.
You don't receive training on that?
No.
Was it a good idea to enter a car that's fleeing?
Not if it's driving away.
Okay. So in entering in the car, are you taking some risks?
Yes.
And by grabbing the shift knob, did you alleviate that risk?
Yes.
Yeah, someone in the comments says, I'm hearing Binger questions. Correct. That's what you're hearing.
You indicated earlier about a weapons warrant.
It's going to drag this redirect out to try and just make
Is it
the
always
jury
good
forget
to
about the cross.
Be concerned about the potential of a weapon when you make a traffic stop.
Yes.
And so that makes you, I guess, extra aware to the presence of a weapon. Would that be fair?
Yes.
At any time during your interaction
see
with
one?
Mr. Wright, did you see a weapon?
No.
Did you see him reach for a weapon?
No.
Wrong. He reached for the gear shift.
Yeah, exactly. The car is the weapon at that point.
Right.
More powerful than a pistol.
In the years that you've been working as a police officer, have you had to draw your taser?
Yes.
Have you ever drawn your handgun instead of?
The objection is sustained beyond the scope.
Does it exceed expectations to draw a gun and shoot somebody to death instead of their taser?
Objection.
The objection is sustained.
Your Honor, may I have a sidebar?
Yes.
Yeah, so on redirect, you're limited in your questions to the scope of the cross-examination. So he's asking him questions that were not raised in the cross-examination, and therefore he can't ask these questions. That last question was just him being a dick, though.
Yeah, that's right.
Was it proper for her to pull out a gun and shoot a man to death? Come on.
Yeah. By the way, you'd be surprised how many courts now don't do that. Outside of scope restriction anymore, and it's terrible because it just lets the questioning wander all over the place.
Well, I think that was how the Rittenhouse trial went.
Yep.
They were not limited to the scope. They're supposed to be, but they were not limited to the scope of cross.
It's awful, and it really allows for ambushes. Too.
Well, yeah, go ahead. Sorry.
No, I mean, normally, you can only ask on cross what was asked on direct, only ask on redirect what was asked about on cross. So it's kind of like a funnel that narrows down. But if you just allow it the later stages of questioning to cover anything, then there can be ambushes, things that were not deliberately not asked about on direct, so they could be asked about on redirect. When everybody's exhausted.
Yeah, that was the other thing with the Rittenhouse trial. We had direct, cross, redirect, recross, then redirect, and a recross. It was
more
like
than once.
Is this just we're in a coffee shop now? We're just going to keep talking forever, I guess.
And usually you avoid that degree of repetitiveness by limiting the scope of what can be covered at each level. It's when you don't have that limitation on scope that you end up with redirect.
Yep, exactly. Oh man, it's
and all of this should be very carefully orchestrated. I mean, these should not be impromptu questions.
Right. Well, again, if you're limited in scope to basically responding to what the other party just did, the idea is you're taking the notes and you're then addressing those things that come
the
up.
objection is sustained. It's beyond the scope.
Your dick.
So when Miss Potter on this day, April 11th, told you that she had pulled the wrong gun and used her Glock instead of her taser, is that inconsistent with what you thought of her when you said she exceeded expectations before?
I don't know what she was thinking at that time.
And that's partly because you didn't see the incident from her perspective.
Correct.
So your opinion about, well, all right.
Yeah, you can't do that question.
In the years that you have worked with Miss Potter,
Her
particularly over the last few years, have you come to like her?
Yes.
I was going to impeach his own witness.
You mentioned doing the carrying caskets. I think there's a better description for that. What is that?
I believe she was a lieutenant with the Law Enforcement Memorial Association.
And so what does she do for that?
Carries caskets.
They provide support for law enforcement funerals.
That involve caskets?
I appreciate that she does that.
Yes.
And you like that she does that?
Yes.
Do you admire her?
Yes.
Did you consider her a good coworker?
Yes.
I have nothing further, Your Honor.
That's some flailing questioning right there.
All right. Come on, Gray. Bring the tea.
With respect to hollow point bullets, are they used by law enforcement because a hollow point bullet will stay inside of the person shot rather than go through the person and hit somebody else?
That is a ballistic characteristic, yes.
Yes, and that's why they're used.
Yes.
And a car can be considered a weapon, correct?
Yes.
There it is.
It takes off fast, fleeing somebody, and it hits somebody, that's a weapon, that car, correct?
Could be, yes.
Okay, that's all I have. Thank you, sir.
There you go.
Anything further from the stage?
And I'd like to have a drink with that guy. He's the stories he's got. Oh my God, here he comes again.
You're gonna redirect on the car or the. You got two questions.
Jesus.
One thing that can hollow point bullets also affect the damage done to the person shot?
Yes.
And in training as a police officer, have you been trained about the dangers of shooting occupants of vehicles?
Good. Object outside the scope of my cross-examination.
The objection is overruled. You may answer.
I don't think we've ever had a specific training on that.
On shooting occupants of motor vehicles?
On shooting into a vehicle, yes.
And in fact, there's a policy about it. Is there a policy in Brooklyn Center about that?
Yes.
And is there also a policy about using a taser on people who are operating motor vehicles?
Outside the scope.
All right, I'm going to let you answer.
We just
Somebody
start
that's
direct
operating
over
a
now,
vehicle,
I guess?
yes.
And so the reason for that is what?
If they're moving, driving a vehicle and you incapacitate them, it could cause an accident.
That's just what Mr. Gray was getting at, correct?
Yes.
I have nothing further, Your Honor.
That was a weird leading question at the end.
At the time that Dante Wright was shot, was that vehicle moving?
No.
That's all I have.
Anything further?
Where?
You may step down.
Wow. Looks like we're going to have a lunch break, I'm guessing. 12.
Is she going to keep going? What about the snow?
All right, members of the jury, we're going to break for lunch, and I'll check the weather in the meantime, okay?
Okay. Okay, now. Thank you. Thank you, members of the jury.
If we're going to get any scolding here once the jury's out of the room.
So there's another new attorney that on the state side, the redheaded guy in the back left is a guy I have not seen consciously, at least.
On the left?
Yeah, I think we're up to now 6 different state attorneys have been on this case.
You're seeing him in this view in the back left?
Yeah.
I thought I saw him there
taller
yesterday.
guy.
Yeah, I thought I saw him yesterday.
Okay, please be seated, counsel.
I don't know who he is.
I take it the state has seen the defense's objections to the exhibits.
Your Honor, you're referring to the autopsy photo?
Yes.
We did receive the email, yes.
Okay. I haven't had a chance to look at these photographs, but if they have already been shown in the past.
Your Honor, they have not, and I do have plans to get a flash drive for the court and counsel during our break.
Okay, good. Thank you. We'll deal with that. I don't know if we're going to get to the medical examiner today or not, but we might as well try to take care of this, as soon as we can. Right.
Are we leaving early today, Judge?
I'm checking the weather, okay, and because I want everybody to be safe. But yeah, and we're breaking for an hour. We'll start up again at 12:30. I may call you in earlier to talk about exhibits, okay?
1:30, Your Honor?
12:30. Oh, that's right. Excuse me. It'd be 1:30.
Short lunch break, 12:30.
Yeah. Be back in 5, ladies and gentlemen. So there we go. Now we're at lunch. The weather, I don't know. I live west of the Twin Cities, and I don't think we had any significant snowfall, but I guess I didn't go outside. And I've been down here, so I don't know what the weather would be doing there. But typically, you'll see the weather hit my house about 3 hours prior to it hitting the Twin Cities. So that's what you'll often find, but that's why I mention it. 3 to 6 inches expected in the cities. Okay. Well, there we go. Fox has a weather cam. It's very helpful. Here, I'll pull it up. If it looks like a frozen hellhole, that's just Minnesota 9 months out of the year. Okay, so any specific observations you want to talk about? I mean, the state is doing what it can, I guess. I don't know.
Well, I mean, they knew Johnson was going to be a difficult witness for them. Again, there's a lot of hand waving, a lot of innuendo, a lot of suggestions of, well, perhaps this looks reckless or that looks reckless, but none of it is actually going to the actual criminal charge in question. And again, frankly, it's because I think the essential facts on that issue are largely undisputed. I mean, I'm not sure what there is to say about it. If the judge is going to say that, the pulling of any weapon is sufficient intent for a reckless manslaughter conviction, well, then it's
She's
probably
guilty.
a reckless manslaughter conviction.
Yeah.
I don't think that's what the law is from my reading of the law. I think she would have had intentionally pulled a gun in order for this to be reckless manslaughter. But to me, that's the only real question in the case, because everything, I mean, we know what she actually did. That's not in dispute. We know her bullet killed Wright. There's no causation in dispute. We know a car accident occurred afterwards, but unless she was actually reckless, she's not criminally responsible for any of that either.
And she's not, she's importantly, she's not charged with the car accident.
Right.
She's not charged with some sort of
a little bit of intervening cause problem there too.
Yeah. Is there, I guess there would be there's got to be some charge for negligent injury, I guess, but because no one else died, right? Just Dante Wright, and we know that
Reckless
the bullet
endangerment, something like that.
Yeah, reckless endangerment, I suppose, would be for the other people. She's not charged with it, so they don't have to prove that out. I mean, the question as to why she's not charged with it, if it's their entire theory of the case, is part of maybe should be asked. But yeah, it's the state is trying to, I just think, muddy the water as much as possible.
Right.
Generally, we don't like that someone died. Therefore, she must have been reckless in causing the death.
And can we show his body getting pulled out of the car 47 times to the jury from different camera angles? I mean, that's all what yesterday was about.
Right. Exactly. And that's
and the bloody girlfriend.
Seems like they're going to try and do that with new autopsy photos that are because the old autopsy photos weren't good enough, I guess. Or maybe
No, so they had the autopsy photos, which of course are just taken by the medical examiner. And apparently, from what I've heard in sidebar stuff here, the photos showed Dante in a very, kind of a horrific light, right? He's obviously dead. His eyes are open. It looks terrible, very prejudicial. So the defense had objected and said, listen, we don't want the eyes shown. Right. That's not relevant to this criminal charge. Causation is, I guess, it's uncontested, but I guess it's relevant. So that's fine. But cut out the eyes. And the judge had ordered the eyes to be blocked or cropped out or whatever. And I guess the defense saw the autopsy photos that are to be presented in the ME's testimony this afternoon and said, no, that's not what the judge said. And of course, the state, it wouldn't be the first time they're pushing beyond the boundaries of what the judges told them they're allowed to do. So I think that's where we are at the moment. So the judge is going to have to look at these photos again over lunch. And I think she'll come back and, well, who knows? I mean, I know, is it Natalie? I've never met Natalie before. She seems to feel that this judge is very pro-defense, and that's not my take at all.
I mean, I feel like the judge is basically neutral. Is what I've been getting. I don't get a pro-defense, but I also don't get like a strong pro-state thing. She's ruling against them on several objections. She's letting the state get away with a lot on their examination, but like nothing crazy from what I've seen. And when the defense raises objections, she tends to consider them. I thought she let the redirect go well outside the scope of cross after limiting it to the scope of cross just a second prior. But
right.
Other than that, the thing with that is judges sometimes they want to hear the story too. And if you've got a judge that wants to hear the story and is interested in the case, they're going to let whatever they want in. So,
somebody commented, she giggles for Earl. That was true. I noted the giggle.
There you go. But yeah, I mean, she's gonna, her question was, have these autopsy photos been shown before, and we haven't seen any autopsy photos yet. So I don't think that I remember. Maybe in the opening statement they would have shown one,
yeah.
but I can't remember if they have, not during any testimony yet. So so that wasn't going to be the problem. But yeah, I guess maybe the photos that she has were just, they're the cropped photos taking out the eyes, being resubmitted, and the defense objecting again to them. So maybe that's what it is. But yeah, it'll be interesting to see what ends up happening here. Why again the judge doesn't already, like, oh, I'm going to prepare a flash drive for that, Your Honor. It's like, okay. Why don't we have these already submitted to the court?
Right.
Why don't you have, if you're going to be introducing these things, why don't you have the flash drives already prepared, and bringing them in this morning? I don't get it.
I mean, ideally, all of this, I mean, it's not like they didn't know this trial was coming. This should all be very well orchestrated by now. There should be no surprises, nothing unexpected, unless you hear some weird, bizarre testimony from a witness on the stand. But normally everything, in an ideal trial, everything is perfectly orchestrated. Everybody knows what everyone's going to say, exactly what evidence will be shown. And the only question is, what's the jury going to make of the two arguments that they're hearing in court?
Right.
But there should not be any of this mid-trial drone video footage that's left by the evidence ferry on the prosecutor's doorstep.
Well, and the one bone we can throw to the prosecution here is, well, they had to edit these photos to take out the eyes, so their nose up cropping. But even so, they knew that yesterday, that they resolved this question yesterday. They did the edits, sent them over to the defense, apparently, who is now objecting, or who sent an email objecting to them during the evening or nighttime. And so they still should have known coming in. Yeah, we better throw these on our flash drive and have that ready for the judge to review today.
But it's another characteristic of these type of prosecutions that really lack legal merit for the state, where they just innocently misunderstand the scope of the judge's constraints, right? We saw it with Binger. Binger was like, oh, but I thought you left the door open on that CVS evidence, Your Honor. I thought I could still talk about that. I didn't know the door was completely shut, knowing full well that to the extent the judge left it open, you talk with the judge outside the hearing of the jury about believing that now the door's been open to that evidence.
Yes.
Same here. It's what Eldridge did yesterday, right? Oh, I thought you meant we couldn't put in cumulative video evidence, but cumulative photo evidence, I thought that would be okay. She knows that's not okay.
Yeah.
She knows that the judge was speaking to cumulative evidence generally of any form other than testimony. That's what the judge said. She just pretends she doesn't understand.
Yep, that's and like you said, it goes directly to the nature of the prosecution and the problems that they know they face. They know that they don't have a strong case here other than to get the jury convinced that her overall actions were bad, the death is undesirable, and therefore she should be criminally guilty.
Right.
And that's not how we do criminal law. And I've seen several people in the chat saying similar things. She should be charged with something. She should be guilty of something. And that's what civil remedies are for. That's what her being, well, she resigned, I think, from the police officer position, but that would be her being terminated, and then the family could go after her pension maybe, or likely they'll just be suing the police department in general, because the police department will pay much more than Kim Potter ever will be able to pay. But that's how you do it. And so that's how you deal with accidents and mistakes that are not criminal liability. There's civil liability. There's the shame of it.
There's no intent.
Right.
I mean, not even a mere intent to create a reckless circumstance.
Yeah. And the closest they can get is that maybe in the manual somewhere it says you should try to avoid tasing someone who's driving. But that's just a manual. Like that's just a suggestion by the taser company. That isn't actually a an answer to whether or not the use of a taser on someone in a vehicle is reasonable.
You know, I would guess that exists because the taser company got sued. Because a cop tased someone who was operating a vehicle and there was a crash, and they were listed in the lawsuit as a defendant.
Yep.
As their device contributing to this course of events. So they added to their handbook, please don't do this because we don't want to be a defendant in a civil suit when you do this next time. But those are all guidelines. I mean, the officer, the privilege for using force is much broader than those guidelines, and it's contingent on the totality of the circumstances. And to a large extent, the totality of the circumstances are defined not by the police officer, but by the suspect. The suspect defines the scope of what use of force is permitted. And here, Duante writes about to flee at speed in a motor vehicle.
Yeah, and in the same way, the taser book says the best target for a taser is the back. The taser book also says try not to tase a fleeing person because it lacks effectiveness. So you've got tasing people in the back, but not fleeing a tasing person. If a cop tases someone in the front, we're not to presume that they acted negligently by tasing someone in the front. Cops tase people in the front all the time. But if you have those ideal, if you have those ideal conditions that you were talking about, a very slow moving sort of thing, well, yeah. And you've got two cops, one doing cover, the other one can come behind and tase the person. Sure. You tase them in the back. So the cop in the front doesn't have to do the tasing. Plus, if you're tasing someone who's lunging at you, they may grab you or something. I mean, you never know what could happen. So ideally you want to tase them in the back, but same thing with the car. These are guidelines and suggestions and some CYA, because if you tase someone in the front and the leads go here and here, and then that person goes into cardiac arrest, the taser company gets sued if they don't have a proper warning on it to let people know that there's a risk of that a taser can induce a cardiac arrest or some arrhythmia that could lead to a health issue. So those sort of provisions aren't binding on officers.
Yeah, and it's probably because someone had a cardiac arrest one time when they got tased. Who knows what drugs were in their system or what other factors were involved. So taser got sued that time too. So they add that to the handbook. But we obviously don't presume that a person who's tased will have a cardiac arrest, or it wouldn't be a less than lethal weapon.
Right. And and then there wouldn't be any question in the Rayshard Brooks shooting. right down in Atlanta. So that's what's going on in the trial so far. And that's where we see the state trying to make their case. And I think the defense is putting up a competent defense. Again, they're active on objections. They miss some, but nobody's perfect. And also, you have to consider how many you're making, but where Earl objected to the exceeding the scope there, and then he could have objected on the next 5 questions. He could have done that as still exceeding the scope, but he found out pretty quickly from the judge she's going to overrule him, and so you let it go and let him finish out his questioning. But their cross-exam has been very good, as far as I can tell. But
yeah, I've been very, very impressed by this duo, and I guess there's a third lawyer there too, a woman, Amanda, maybe something.
I don't remember her name.
I'm thinking Amanda Winchester. That's probably incorrect, but it's something that sounds like that. But she hasn't to date played any active role.
Yeah. And I don't know that we've seen her actually speak in court, really. She seems to be a research assistant for a lawyer who's researching actively during the trial, probably checking their notes, probably checking for anything that may pop up, doing quick research on statutes if they want to bring something up. So she seems to be that part of the team. But I've got some chats to read here, if you're cool with that.
Sure.
Kevin Gravier says, "Got my book for Law of Self-Defense about halfway through. Thanks, Andrew. Great read."
Oh, glad he likes it.
Kevin Dorr says, "Free Assange." Someone in the chat said Julian Assange is being extradited to the U.S. So that's been a while coming. You think his plane will make it? Gaddison says, Wait a minute. Why is Ghislaine Maxwell on this plane with me? No. Gaddison says the state will not call Sergeant Johnson because his testimony will undermine their narrative completely. He told Potter she was justified in the video. Whoa, you got wrecked. The state. No, it would be if they had anybody else that they could have called on direct than Officer Lucky and Officer Johnson to testify to the facts about what happened. They would have called anybody other than those officers.
Yeah.
But they just didn't. The other person to call would be Potter. They can't call her. So they've got the girlfriend who they did call, and then they've got those two officers and those officers were seemed to have been reasonably certain that she was justified. So remembering that it's their necks on the line, if she doesn't pull that gun or taser, as it were, if she does, that's something that the chat brought up too. The state's making this big deal about them being able to walk away from the car. They're only able to do that because she said taser. Like she said taser, it signals to them to let go and to back off. That's why they're not in the car when the car starts driving. If she hadn't said that or if they were still holding on when she fired and he just throws the car into drive and drives off, they're still in the car at that point. So, and if she didn't get the shot off, that's another thing. If she didn't actually get that shot off and he manages to throw the car into drive and start going, they're in danger at that point. Brandon Lesko says, guys, why doesn't the defense pursue some line of questioning proving they can't determine the shooting was the only factor in the crash? He could have been spooked by a unicorn. Maybe he was high.
Well, the defense they're not telling their story yet.
Right.
So they can only respond to the state story. What story the defense will tell, we'll see when the state rests and the defense gets to present its theory of the case.
And the defense is going to bring up Kim Potter and say, were you scared for your fellow officers? Like, what was running through your mind at the time you pulled the trigger? And she'll say, I was scared for my fellow officers.
I thought these two guys were about to die.
Yeah. And
I was going to watch them die when that car took off. Yep.
And maybe me too, because she's in front of Officer Lucky. If he gets dragged, she at least gets knocked over. That's another thing. So the defense will get to tell their story. They're going to have, Potter testify. They're going to have the officer testify. I have the defense witness list here too somewhere, which I wonder.
Someone had posted, by the way, Amanda Montgomery.
Oh, okay.
The third defense attorney. That sounds right to my recollection.
The defense does have 18 witnesses listed.
Mm.
Let's see, lots of the officers.
Are they recalling any state witnesses?
I'll pull it up here. I don't remember everybody's name, so I'm bad with names. It's got William O'Keefe, Jason Heilman, Sergeant Mike Johnson.
So he's that's the guy. He's back.
Yeah, Officer Andrew Lucky, him
back.
too.
Yep.
Michael Peterson, Stephen I. James, Lawrence Miller, Colleen Fricky. That's the
woman who took the bullets.
Right.
Yeah.
Timothy Gannon, former Brooklyn Center police chief.
Right.
Jim Maas, Ann Curtis.
He got fired the same time Potter got fired.
Gannon did?
Yeah. Or retired, whatever.
Yeah.
But he had come out immediately after the shooting and said, no, we're not going to prosecute her. This looks like just a mistake to us. So they both got, thrown overboard.
Hey, you should step down.
Right.
I don't know who Ann and Jeff Curtis are. That's Lisa Tees maybe. Frank Roth, Sam Smith II, Thomas Hall, Becky Boy, and Mona Pearson. So there you go. That's who we've got. So the only repeats are Lucky and Johnson, which would be a great name for a buddy cop show, right? Just have Lucky and Johnson on patrol. I think that's the only recalls. Yeah. I wonder if they'll call all these people though. Because the witness list doesn't fully indicate who will end up testifying. It's just who they might call.
Yeah.
But
yeah, I mean, these tasers, folks, cops carry them because sometimes they work. And when they work really, when they work effectively, they're amazing. But frankly, I've never been a cop, but my anecdotal experience covering these kinds of cases is a large fraction of the time they either don't work at all or they work very poorly. The person just rips the wires right out of themselves and continues doing whatever they were doing. So there are circumstances in which they're definitely worth a shot. You don't want to shoot people. You don't have to shoot. If there's another way to stop them from doing whatever it is you need to stop them from doing, and you can do it safely, a taser is definitely worth the effort. But I think most cops will tell you that they don't have a high degree of confidence that any particular taser shot's going to actually compel someone to stop what they're doing. You hope it will.
Yeah, that was that's the main thing that the reason cops use the taser is because they really don't want to kill someone.
Right.
And for anybody, I saw a couple people saying, "Oh, she looks more concerned for herself because she says that I'm going to prison thing than the fact that she just shot someone." I mean, I think that's a little much personally, because the cops do not tend to step out on their day going, I really hope I get to ice someone today. That's just not how they tend to operate. Sure, some cop could have a bad day and think that, but most of the time, they don't want to kill someone. One, they don't want to go to prison, but two, killing someone's that's heavy. It's a heavy burden that they have to carry, and they have to live with that decision. So that's why they pull tasers rather than guns. Let's see. Matsy Foamhead says, if the feet were up, shifting his body weight backward 0.22 seconds before he was shot while crossing state lines on the patio, shot justified. Thank you. Kimberly Campbell says, Nick, if you have your nightly stream tonight, can we discuss the man who beat his daughter to death while she tells him that she's sorry and she loves him? He wasn't supposed to be in the home. Maybe. That sounds like a really uplifting case.
Yeah.
I definitely want to talk about that.
Welcome to the weekend.
Andrew in North Carolina says, a free super chat. Thanks for the great coverage. Hey, thank you, Andrew. America 76 says, Jussie was Kamala's big brain plan to kickstart her campaign. Thanks for all the great coverage and content from the panel. FBI Glowboy says, yo, Nikki the Nose, can you ask Bronco what he uses as a CCW?
Yeah, I've answered this one before. Currently a SIG 320.
What caliber is that?
9mm. The one I carry is 9mm. They probably make them in other calibers, but these days a modern 9mm ammo is just about as effective, I should say, as ineffective as any other handgun ammo.
And you hate 40 caliber, right?
The only reason I don't like 40 is I carried a 40 gun for a while and I shot it competitively for a while. But when you shoot competitively, unless you're a millionaire, you reload your own ammo. And the 40 caliber brass would develop this kind of a shelf around the case head, like you might see in Magnum rifle rounds. Every time you resized it, it would push a little bit of the brass towards the bottom of the case, and then it wouldn't chamber anymore. And it was such a I never had that problem with 45 ACP or 9mm, so I just gave up on 40 just for that reason. In terms of a self-defense round, I guess it's fine. I mean, it's more recoil than a 9, and it's no more effective than a 9, and medical examiners can't tell the difference in the wound channel between the two. So I'm not sure what you're getting for more flash, more recoil, and less capacity compared to a 9mm pistol, which is why I carry a 9.
And it's a 40 cal is bigger than a 9. Like the pistol itself's a little bit bigger.
A 40 is basically a 10mm diameter round. So instead of 9mm, it's 10mm.
So
and 45 caliber would be like a little over 11mm.
Yeah, I don't carry. I had a carry permit, but I don't typically carry now. So I haven't renewed, but I have a 45. I have a 1911. It's big. It's fun, but
yeah, I carried a 1911 for 25 years when I was in Massachusetts, had my concealed carry permit, in part because they had a 10 round magazine limit. And if I can only carry 10 rounds, they may as well be bigger rounds then. I mean,
right.
So in the 1911 could carry 9, 8 in the magazine, 1 in the chamber. If I carried a 9mm, I wouldn't have the advantage of a 15, 16 round capacity because it was contrary to state law anyway. But once I moved to, even here, by the way, in Colorado, we have a 15 round magazine limit that apparently everybody ignores. I mean, you can go into any gun store in the state, buy 30 round AR mags. But
weird. I didn't think, I mean, Colorado has some
it was
blue
after one of the
tendencies,
school
so.
shootings here. They passed the 15. Yeah. And during the
that-
political hysteria. But the SIG 320 is a 15 round mag gun. So that's one of the reasons I chose it.
Pancake Turd says the NRA has supported and even helped draft every major piece of gun control legislation going back to the National Firearms Act. Leftists thinking of the NRA as some all-powerful lobbyist group is a good thing. Barry Dworak says, I'm not a lawyer nor a high fashion aficionado, but prosecutors look like teenagers who had to dress up for a last-minute family wedding. Well, everybody's just been spoiled by Binger. Binger, Binger's all out there trying to look suave as a prosecutor. Most prosecutors are just, same as a lot of other lawyers. You just put on a suit because you have to put on a suit. You're not trying to slay the jury that way. But some defense lawyers really do dress really nice. That was a comment Barnes made. It's like Binger's dressing like a high-priced defense attorney.
Right.
And there was a reason for it. He's, that's what he's got.
Hey, some defense attorneys make a lot of money.
Allison S says, hey guys, what are the Blakely files? Why didn't the judge mistrial? So the Blakely issues.
Factors. Yeah.
So this is in regards to sentencing. And in sentencing, they want to aggravate this sentence. They want to say that her conduct was particularly egregious. Therefore, she merits a deviation from the sentencing guidelines in Minnesota. There's a presumptive sentencing guideline. And if you want to go above or below the sentence that is recommended, then you need to have this deviation. And these are the Blakely factors that they talk about. You have to have facts sufficient to support that deviation. And so the judge didn't grant a mistrial because, well, I don't think the judge is going to grant a mistrial on that anyway. But she wants this thing to go to jury and not be decided on this technicality. But I wouldn't be surprised if the judge notified counsel that they need to be a little more careful about what they're doing and not to expend the court's time needlessly on this sort of cumulative testimony about the accident after the fact. Because if they want the Blakely factors, they've got the evidence that they're going to get out of that now. So,
and that was all a pretext. You don't spend an entire day of testimony by 9 witnesses for Blakely factor purposes. That's nonsense.
Right. I'm trying to see if I have the sentencing guideline. I had it up yesterday, but it'd be interesting to see what her presumptive sentence would be if she were to actually get a conviction here. I've got it. I'll have it up in just a second. Just got to make sure I'm not picking the drug one. Minnesota has 2.
What are you looking up?
The sentencing guideline grid.
Oh, yeah. Okay.
So here we go. It doesn't have manslaughter actually clearly listed. So I'm not going to pull it up because that'd be annoying, but it's likely a severity 9 charge for manslaughter. Well, I guess we can real quick.
I was really shocked at how modest the manslaughter sentence was for New Mexico. 18 months.
That's really
light.
low. So how this works, guys, is you have your severity level of the offense on the left, and they have some of those offenses and where they stack up. But there's a more comprehensive list. I'm guessing manslaughter is going to be an 8 or a 9 on that list. And so you then go to your criminal history score. I'm guessing Kim Potter has no prior criminal history, so her criminal history score is going to be 0. So then you have your grid here. The presumptive sentence will be between these two numbers. The judge has leeway between. So if it's 9, 74 and 103 months as a presumptive sentence.
Yep,
and
that looks about right to me.
Yeah. So if you want to go beyond that, and an aggravating factor like we saw in Chauvin can add up to double. I don't think he got doubled. He got like a 75% increase or something like that. But an aggravating factor can double the sentence. So if you get 103 months and then it's aggravated, you got 206 months potential. It can triple it if there's enough aggravating factors too. So that's the type of sentence that Kim Potter would likely be facing if on manslaughter 1 and then on manslaughter 2. If I had to guess, she'd be in that lower box.
Yep.
But yeah, so the Blakely factors would allow them to double that sentence based on her position of trust as a police officer, based on particular disregard for the safety of others. Even though
I think even she was in uniform.
Yeah.
I think that's one of the factors.
And there's a non-exhaustive list. I mean, you can actually just make up whatever you want and try and sell it to the judge, and the judge can agree. So, but yeah, all of that should be done post-trial, really. You should utilize the factors that were raised in trial testimony, and then you should add any factors that you believe you can support to that. And then if the judge wants to call an evidentiary hearing to get more of those factors out, the judge can do that.
Right.
So that's hopefully that's an adequate explanation. Allison C says, with that witness list, I'm surprised the state didn't call me as a witness. I'm as qualified as some of the people they've had on the stand.
Well, that's a tactic too. I mean, for folks who don't know, especially I see this pattern all the time in these cases where the state really lacks legal merit to their argument. They know that every witness they put on the list, the defense has to look into. So if you put 200 people on that list, a typical defense team, they don't have the resources to exhaustively research those people. At least you hope they don't, or at least they're wasting time and effort, resources to do all that work. When you know you're only going to pick 10 of those people or 15 of those people are actually going to come into court and testify. So it's kind of a diversion of resources attack on the defense pre-trial.
Mm-hmm. And yeah. Oh, someone was asking in the chat earlier about how much this defense costs. And the cost is astronomical. I mean, that's it. Earl Grey, I don't know his rate, but you can assume pretty safely that one of the highest regarded defense attorneys in the metro area is earning in excess of $500 an hour. So if we just take $500 an hour, and in New York, that would be a bargain, but we're in the Twin Cities, so I'll use it conservatively. If he's $500 an hour, we've had, in 2 weeks, we've had somewhere near 80 hours of court time alone. So he's $40,000. Paul Eng probably costs $400 to $500 an hour too. So there's another $40,000. Then you've got the third attorney there sitting there for 80 hours, probably at a rate around $300 to $350 an hour. So then you've got, another $30,000 potentially.
And staff costs and there's all kinds of other costs.
And that's just for the hearing time that we see. We know that they're working after hours. I would say you can easily triple that cost on prep for those attorneys. So you're pushing, you're over $250,000 on a defense like this pretty quickly. So just to let you know what this type of defense costs. And that's not even counting how much time they had to spend. They had to hire a researcher of some sort to look into the social media posts of all the jurors. You've got a jury pool of 200 people. That's 200 people to research.
I mean, plenty of the killing charge. Most of the cases I work on, nobody's killed. It's typically an aggravated assault or aggravated battery charge. But the killing cases I consult on, it's routine to see them burn through $200,000 before they get to trial.
Mm-hmm. Chauvin, it was something like 1.2 million for his defense, if I remember right.
I hadn't heard that, but that makes sense.
I seem to remember that, or is that being an estimate? Something like that, but it's absurdly expensive to defend yourself. And that's why anything you can do to mitigate the chance of even going to trial, you should. And that's a lot of what you focus on. Make yourself hard to prosecute in the first place.
Right.
Make the right decisions so you don't even get charged. And hopefully you're not a Rittenhouse or a Potter with a political motive behind your charging. But on
Three-quarters of our effort here at Law Self-Defense is to try to educate people to make good decisions. If you make good decisions and you have good facts to give your lawyer, the chances of getting prosecuted become extremely low because prosecutors don't like to take those difficult cases to trial. Unless it's a politically motivated prosecution, then you're going to trial no matter what. But then you still have the benefit of having good facts, and they have to work hard to try to get a conviction. Unfortunately, in that case, you're still out the money, even if you get acquitted, and the reputation and all that. There's no way to recover that. I guess with the money, you might check out lawselfdefense.com/CCW safe. They'll pay your legal costs at least. So that would be nice. You don't have to sell your house or business to cash out your kid's college fund to try to not spend the rest of your life in a cage.
The and talking to a different defense attorney on a case where I assisted, you know, the people never ended up paying the retainer. The retainer was $32,000 just to start this case. It was a criminal sexual conduct case, and they never ended up paying the retainer. And so the attorney was like, well, you know, that's going to really hamper the ability to defend. And he's I was talking to him, and he's like, they clearly don't want the defense because they still have a house.
Yeah.
Right. They still have a house. They still have a car. It's like, you know, do you want to go to jail or do you want to keep your things? That's a question you have to make, unfortunately, because it costs money to do these things. Let's see, what else was there? There was.
I mean, it's funny. We give our book away for free at lawselfdefense.com/free book. We ask people to pay, I think it's $8.95 shipping and handling.
Right.
And the amount of bitching we get over asking people to pay the shipping and handling is unbelievable. And I'm like, folks, if you just sit for 3 hours and read this book, the prospects that it could save you hundreds of thousands of dollars in legal expenses down the road, and maybe the rest of your life in a cage, for $8.95, I think that's a pretty good deal. And that's just the cost of getting the book into your hands.
Right. Andrew Pigzik says CZPO1 with Buffalo Boar plus P hardcast, because why not?
Well, because that's a lot for a prosecutor to talk about. That's why. So
I don't know anything about what that means.
It's a very nice pistol. It's a particular brand of ammo and type of ammo. But I just tell people, when you're getting that detailed, you're just creating headaches for yourself. If that's a gun intended for serious social purposes. If it's a range gun, I don't care what it does or what you call it or how you load it.
Right. You can have all the fun you want, but if your self-defense carry gun should be basically
as boring as you can possibly make it.
Chesney Thomas says, "Hey Nick, first time super chat from Cape Town, South Africa." Hey, thank you, Chesney. Hope everything. I know South Africa was having a lot of issues a while ago, but I didn't know if COVID kind of calmed that down or made it worse. Who knows? At Andrew, love the P320, but any thoughts on the SIG lawsuits for accidental discharge?
I don't know what's going on with that. I mean, for people who don't know, there was claims for a while that if you dropped your 320 in a particular way, like in the back of the slide, the gun could discharge. I think I saw somebody on the internet replicate that effect with a blank round. But anytime people claim accidental discharge for having shot somebody, you always have to wonder, is that really what happened? Or did they just recklessly handle the gun and shoot somebody? It's like these old cases they used to have where people would say, well, the car just took off by itself. And of course, what was happening is they mistook the gas and the brake pedal and drove the car through a coffee shop. So I don't know. I'm not concerned about it. SIG did have a major recall campaign where they paid to have you ship the gun back to them. They did a modification to it. They shipped it back to you. That's supposed to have solved the problem. I did that I have a number of SIG 320s, and I did that with some of them and not with others because I thought the modification degraded the quality of the trigger, and I don't typically drop my guns, so I wasn't that worried about the accidental discharge risk. But that's the extent of my knowledge on that.
I actually had a car that did take off on its own, and I was not involved in any accident. I have nothing to worry about. It was a Ford Escort, 1995. It was my first car, 1995 Ford Escort. And for some reason, and I think they found this problem in other Fords as well, there was something that would trigger the cruise control to turn on. And so I was with my buddy, and I'm like, I'm having a hard time slowing this car down. It's like I'm fighting myself. And we got to the bowling alley where we were going, and I throw the car into park, and it just goes, it just revved up like crazy. So I turned it off because I'm like, what the hell is happening? And then the worst part was when I turned it back on, it was still locked into that, which you would think that would shut it down, but there was some issue with those. And I had to get the cruise control temporarily disabled until they could get it fixed. It was nuts.
Scary.
Baltimore guy says people plead out for $3,500 on a daily basis. Yeah.
Well, that's one way to go. That's one reason people plea out.
Yeah, I think that's the
You
point
know.
they're making is like, you just plea out, you pay, you do your jail time or you pay a fine. You're not going to prison forever. Sometimes,
Yeah.
you know,
I mean, most of the cases I work on involve clients who've never been in trouble with the law a day in their lives. They're normal law-abiding people. They got into some kind of confrontation. They waved a gun around. Now they're charged with aggravated assault. They're looking at 10 years, maybe more, with a firearms enhancement sentence if they're convicted. And then they're offered a plea opportunity. And of course, they don't want to take it because as far as they're concerned, they didn't do anything wrong. They're not a criminal. Why should they take? And often the plea is still a felony, just no jail time or whatever. And of course, they don't want to take the plea. And you have to sit those clients down and say, listen, it's up to you. But if we put you on trial in front of a jury, there's maybe a 10% chance you get convicted and spend a decade in prison. Or you take the plea and there's no time. So, you want to roll the dice or not?
yeah, it's one of my friends used to play sport with a guy who he was charged with basically he was sleeping with a female, and they claimed rape, right? After the relationship went south. Actually kind of a funny story. The mom wanted to be with the guy, and the guy's like, no, that's weird. I'm with your daughter. And then after that, they decided that he was sexually assaulting the daughter. So he gets charged, and they racked up every incident of sexual contact that they had as a separate charge. And he was facing like hundreds of years in prison. They offered him a plea deal to plea down to one of the charges. And, it was like 3 years or something like that. And then he would be done. You'd have to register as an offender or whatever, but it's like 3 years or go to trial on forever. Yep. And I think he took the plea deal. I didn't know the guy. So, I don't know if he might've been a bad guy, but that was what happened is here's this massive charge, or you can plea out to 3 years. Just the 3 years.
Yeah.
Though.
And by the way, nobody knows what really happened, right? I mean,
Right.
except the people involved, but the prosecutor doesn't know, a judge, a jury, the cops, nobody knows what really happened. They just have some evidence, mostly in that case, the woman's testimony. And they feel they can build a narrative out of it that's consistent with guilt, and they're ready to take it to trial. And
there was video that they engaged in sexual contact. So
that's always helpful.
There's a big element right
Is
there.
there ever an upside to the video?
One
Dear
of my
Lord.
friends suggests that if you have a third party taking the video, that is a third party who is a female taking the video, then there is an upside because that person can then testify that there was consent and all of that stuff.
Unless they don't.
Right. I mean, that's the risk, but that's their philosophy. So I'm like your sex life is complicated. Mine is simple. I'm just married.
Yeah, same here.
Turtle Lover says, I employ Andrew to get a P229 and lose the P320. Former CID special agent when I was in the Army. And when we got the military variant, negligent discharge in the Army skyrocketed, including a few in our own agency.
Well, the 229 is a fantastic pistol. I've owned them before. In fact, the gun I had in 40 was a 229, now that I think about it. A little heavy for what I want. In fact, I'm probably going in the opposite direction. I'm probably going to a SIG 365 XL, which is a smaller 9mm pistol than I currently carry.
Othamer says, hey, Nick, 25th birthday today. Took the month off and spending it in Orlando with my sister. Good luck with torturing yourself watching all this. Oh, once we got out of jury selection, I didn't think that this was torturous anymore. I find that the trial pacing, some of the questioning from the state in particular,
the direct is pretty interminable sometimes, but at least the cross is coming, and that'll be more fun.
And they're dragging out their questioning for a particular, because they don't really have much else to do. But that being said, other than that, looking for the objections is interesting. Seeing cross-exam, of course, is what we're waiting for on most of this stuff. And yeah, seeing any evidentiary issues that come up, I'm actually thoroughly entertained. So Mr. Archer says, during the arguments at the end of yesterday, didn't the prosecution claim that the defense had brought up to the judge that they were challenging cause of death? Maybe this is why the focus on ammo and the accident.
Well, I don't know what the defense is saying in sidebar. We don't get to see that. And I would hardly trust the state's characterization of what the defense is saying in sidebar. But to the point, it wouldn't surprise me if the defense had mentioned that maybe Dante Wright owns some responsibility for the bad outcome here.
Yeah, I think that's the thing. The cause of, so there's the cause of death from the medical examiner's perspective, which is the bullet traversed between his lung, his heart, and then his other lung. I don't think that's in dispute. But what the proximate cause of the shooting, which caused the death, would be the next question. And yeah, there could be some dispute over that for sure. But someone in the chat had asked if it was possible that the car accident was the actual cause of death.
I don't see it.
Yeah,
not that gunshot. You're not surviving that gunshot wound injury.
Yeah, and you're going to die within minutes
Yeah.
Of something like that. Titan Tech 90 says, Andrew, I saw you on Tim Pool your first time there and got your book and have recommended it to many others. How does the CCW safe insurance work in states like Oklahoma with constitutional carry / no CCW permit requirement?
The answer is I don't know. So I don't work for CCW Safe. I don't sell their products. I'm not an expert on what they offer outside of what I myself get as a member. That's why I tell people I'm not telling anyone to sign up with CCW Safe. I don't know if they're a good fit for you or your circumstances. Only you could know that. But when I look at the various companies offering that kind of service, they're the one that's the best fit for me. And because that's the case, I encourage people to look at them as a possible option.
There you go. Yeah, I don't know. I don't know. You'd have to read their terms and see if they have a requirement for a permitting as part of the term of the insurance.
And they have various plans and various, all these companies have various conditions and restrictions, and as you might expect for this kind of coverage. And so you'll just have to go and, your own circumstances. I don't know your circumstances. So you'll need to see if it's a good fit.
White Alakazam says, yo, so I had jury duty, was an alternate juror, and got dismissed the last day. Basically, 3 guys went drinking, definitely on camera getting in a car, and his car ended up on top of the victim, locked, and the defendant gone. Only his DNA. There you go. Interesting case there. Brian Miller says, what do you think about Smith & Wesson M&P 9mm as everyday carry?
No personal experience with it, so I couldn't have an informed opinion.
All right, next. There's so many questions in the chat. So if anything pops up that you want to talk about, please let me know. I'm just going to try and keep on top of these while we have a lull in the trial itself.
I do see a number of people asking why I don't recommend USCCA. I'm on someone else's stream, and I don't like to say negative things on someone else's stream. But if you'd like to know why I don't recommend them, you can go to lawselfdefense.com/USCCA.
Well, you don't have to talk about it, but you also don't have to be coy on my behalf.
it's not my practice.
No, I gotcha. Sip and
I
Eat
never know. I'm on a lot of forums, and sometimes USCCA could be a sponsor. Or something on the forum, and I wouldn't know because I don't pay attention to those things, and I would inadvertently be dissing their sponsor, and so I just prefer to avoid that.
Yep. USCCA does not sponsor the stream, but they could try. Let's see.
They have the money.
Let's see what you're willing to do. The Supreme Court of the U.S. just ruled on a Texas abortion law. Can you please explain what it means? I read it, but not a lawyer. I'll probably look at it tonight. I haven't had time to read the ruling. The summary I've gotten of the ruling is that they will allow the lawsuit against Texas to proceed, or the lawsuit against somebody to proceed. However, they are not striking down the Texas abortion law at this time, which is not promising actually for the for that. The lawsuit will likely go back to the judge, the district court judge who already ruled against it, or who already dismissed it. And then it will likely go back to the Fifth Court of Appeals, which has already ruled against it twice. So, against the lawsuit in favor of the law. So, we'll see what happens. And then it may be going back to the Supreme Court on the merits of that particular case at that point. We'll have to watch. But for now, it just means that the Texas law is still valid. It is not stayed. And there are no abortions past 6 weeks in Texas. So Oklahoma abortion clinics, hire some more staff, at least temps. Can you have temp abortion doctors? Like, I don't even know if there's licensing requirements for that. Cameron Nelson says, Andrew, what's the concealed carry insurance you recommend? You mentioned that one already.
And
Zach,
for folks asking me about all the other ones, Law Shield and all that kind of stuff, I'll just say I recommend you take a look at CCW Safe, and I think those others are all substantially less good choices.
there you go. Zachariah Kitzman says, uncivil, any kind of fool could see. Well, he's not here.
Yeah.
I don't know what that was in response to. Risky Analysis says, I've heard that TSR is suing Wizards of the Coast for their blurb over the original TSR published D&D material. Are you going to cover it? Yes. Very, very likely I'll be covering it. I just got a copy of the lawsuit last night, and I hope to cover it with some interesting people. So we'll see. Some people I got to make a really interesting connection yesterday related to old Dungeons and Dragons, and it was fantastic. Wanton Samurai says, very helpful. Thank you. Ducky Cries Belvin says, Nick or Andrew, does Tim have anything under that beanie? He never took it off in my presence. Tim Pool. Where's that?
I've seen photos of him without it on. He's never taken it off in my presence.
Yeah.
I guess we're not that close, but I've seen photos of him, and looks like he wears the hat to keep a warm head that doesn't have that much hair on it.
Yeah, and there are photos out there, but maybe they're Photoshop, maybe they're doctored. Who even knows?
It could be.
Who even
Deep
knows?
fakes.
I know who knows. Nate the lawyer knows.
What? What's up?
Nothing. Had a super chat about Tim Pool's beanie. How's it going, man? Welcome back.
It's all right. I went over to jump on Eric's stream, but they ended it as soon as I got home. I was like, no. So I was like, let me jump back on here and watch poor Kim Potter get railroaded by the prosecution. It's like one thing though that's really bothering me about this is the prosecutors just have way too much power. It's just like the Brooks case in Atlanta, where the week before the shooting. For those of you who don't know the Rayshard Brooks case, he was the guy who beat up the two cops. Then he pulled out a taser and pointed at the cop, and the cop returned fire. And a week before that event,
the cops taser.
He took the cops taser. Yeah.
Right.
But a week before that, the district attorney had just leveled charges of aggravated assault with pointing a deadly weapon at two protesters. And he got on and said taser is a deadly weapon under Georgia law, and that's why he was charging him. Then when Rayshard Brooks points the taser at the cop and the cop returns fire, all of a sudden the taser is not a dangerous weapon. And it's just like, really? Is that really the, like, I understand there's politics involved in
well, that guy was about to lose election.
It's ridiculous.
And he did lose election.
He lost it too. That's true.
You see that the prosecutor in the Zimmerman case was the same thing. Angela Corey, she was about to lose her election, and that's why she took that case to trial outside of her. And it worked. I mean, she lost the case, of course, but she reversed her political misfortunes and was in fact reelected.
But why should someone have to spend thousands of dollars like Rittenhouse? Rittenhouse would be in jail if he didn't have the support of two people, $2 million to get him out, and some of the best legal team on the country. But why should it have to come to that when something is just so obvious? Like this case, even though I know, I've been called a white supremacist, even though obviously look at me for saying Kim Porter, I think is going to be found not guilty. But I don't see how they've not built any type of substantial case to get me to say that she's in any way guilty beyond a reasonable doubt. There's a whole bunch of doubt, and it's from their own witnesses. So it's just a scary time to be in the criminal justice system, because it seems like these prosecutors are just prosecuting people not because of the merits of the case, but because of some political ambition. You know what I mean?
Yeah, I think this discretion and power we give to prosecutors is, it's like the old expression. I mean, give away only as much power as you would want your worst enemy to have, not your best friend. And when you have trustworthy prosecutors, they don't abuse this discretion and authority. But when they become untrustworthy or politically motivated, well, then they, as Mark Richards would put it, they wreak havoc on defendants, even when there's really no serious prospect of proving guilt beyond a reasonable doubt.
Yeah, I mean, that was the whole issue with the Kyle case, is an honest read of that complaint, not even of the situation, but of the complaint that they submitted, suggested that they never had a case. And that was the big issue I had, because I thought they would just write a sleazy complaint, and I guess to their credit, they didn't. They just plowed through anyway. Mark Gee says,
and there's no downside. I mean, there's no consequence for the prosecutors. And even when they lose, like Angela Corey, even when she loses the case, she wins re-election. There's only upside for her.
Marky says, okay, now that Nate is back, what country is this?
MAGA country!
So Andrew, that meme is so popular right now.
It's killing it. You don't know. So Andrew, what happens is we were talking about just
should sell that as a ringtone.
Yeah. We're talking about
I know what I might be doing this evening.
That's it, right? Then we were talking about the Nigerian brothers and how they had the deep accent. So they were like, MAGA country. General Trump says MAGA country. And he's like, I thought it was a white guy. Like, no. So, and the fact, the Jussie Smollett thing, though, it's funny, though. I'm still surprised. Like, they were, can you believe, like, not to say they had any type of real, credibility to begin with, but Black Lives Matter last night before the verdict comes out and says they support Jussie Smollett because the police are lying. And it's like, do they understand the people who led that police department and all the top brass were all black people? They weren't white people, right? The mayor was black. The chief of police at that time was black. It's like, those are the people who are saying this. This is not like, this is not like we're in Texas somewhere. So how could it be a race thing?
It's often very striking. And of course, it's a good thing, right? You want your police department and the leadership as well to reflect the community, right? So that's all a good thing. But it's often striking to me when you have one of these shootings where it might be a white officer and a black suspect, and then they lock down the scene and all the senior management leadership from the department shows up. A large proportion, maybe a majority of which are also black. And they're the ones that are hiring and firing cops and making all these decisions. They're setting the culture within their department. So it becomes rather difficult to believe that the department that's led by those men and women is somehow inherently racist.
That's the argument they're making.
It's, there's some doubt. Well, it was from Shaft, right? Too black for the badge, too blue for the brothers. Right? That's the famous line of Samuel L. Jackson, the not original Shaft. Abe Eggstein says, a neighbor of mine got into a fight with a coworker. In revenge, the coworker put child products on his router. Ooh. The FBI didn't even have any proof it was ever transferred to a computer. He ended up pleading guilty to get no jail time. But that lifetime offender status, oof.
That's tough. I know that's from the Duggar case, because I just had one of those cases that went well for me and for my client. But those are tough, because when they get you, they got you. So but
it's just pure possession, right? I mean,
strict liability. The federal law technically says, and you guys can tell me what you think about this. If you happen to accidentally come into possession of it, it's an affirmative defense that you immediately destroyed it or turned it over to law enforcement. Would you ever recommend a client to go to law enforcement and say, I found all these pictures of kids on my computer?
No. So I have a very good friend of mine who worked, he was, before he retired, an FBI special agent for a while, assigned to this kind of child porn type of cases. And he'd say what would often happen, he's told me, is that somebody, I'll make up a scenario, a minister in a church, not entirely making that up, but one of his staff discovers a whole bunch of child pornography on his computer,
right?
And accuses him, and he pretends that he had no idea it was ever there. And to prove how innocent he is, he packs up his computer, brings it to the local FBI, and says, this stuff somehow appeared on my computer. And as far as the FBI is concerned, they're opening up an investigation on that guy because they don't believe that for a minute. And by the way, most of the people who get in trouble for these kinds of images, it's not 1 or 2 images on the computer, folks. It's thousands and thousands and thousands, hard drives full of this kind of content.
They get into collecting it. I mean, that's what ends up happening. And that's why the prosecutions on them are so generally successful.
Yeah. If
Because
they ever go to court.
It's a paper case.
I mean,
Yep.
It's a paper case.
And
it's right there.
And you really don't want that question presented to a jury anyway.
No, you go to trial, the jury's going to see those pictures.
Yeah,
the
and
jury's going to see that evidence. What do you think the jury's going to do?
Well, that criminal sexual conduct case I mentioned earlier that I did the plea hearing for, I had all of the juror questionnaires, and they had impaneled 2 or 3 juries and then rescheduled trial. So we had all these prior juror questionnaires, and I think I had 55 of them. Again, small town case here, so no one knew this guy. They didn't need a huge pool, but we're reading through these things with the guy in my office, and I'm like, let me just read you the answer to the question of this case involves these facts or these allegations. Can you be impartial? And of the 55 of them, 50 said basically that this guy should be killed, right? Or put in prison forever. That's
a tough case.
And it's like, there's 55 jurors and 50 out of 55 of them think that you should be dead. What, do you want to go to trial on this? Like, do you really like,
May the
it wouldn't have been me
ever in your favor.
It would not have been me trying the case. So, like I said, I only did the plea hearing, but it's like, do you want to go to trial on this? Cause if you do, I'm sure your attorney will take this to trial. That he's obligated to follow your direction, but here's your odds, man. Not strong dice rolls.
It's better for the attorney to go to trial. I mean, we exist to work.
Yeah.
But
if you have resources and you're going to pay up front on something like that, but if you have resources, they'll take it.
Pay up front, of course.
Yeah.
Right.
You never get paid otherwise.
DG
the
McBride,
criminal trial is tough. No, I
Yeah,
was saying with
go
criminal
ahead.
trials, it's tough because a lot of times too, people they really don't know how expensive a private attorney is. And then, I hate coming into those clients who they have enough money to survive, but not enough, but they're not poor enough to get a court-appointed attorney.
Yeah,
And
which is
that's
very
when
common, by the way.
Oh yeah, then you get the real sticking point. So it's you
have
you
to
don't know how many
be-
bills I've had to write off because I'm the person can't pay rent, and it's like, all right, it's whatever.
Yeah,
Yeah,
I mean,
well, that's-
my first experience in the law was before I was an attorney. I was working at a public defender's office, and one of my jobs was to do those interviews with people who'd been arrested or sitting in jail. They want a public defender, and you got to get, what are your assets and all this kind of stuff. And a lot of these people this is upstate New York. There's a lot of poverty up there, and these people have not much, barely anything, and they still don't qualify for a public defender. It's not uncommon.
And some state, I think Minnesota does a thing where if you don't qualify for a public defender, you can still have an appointed attorney. However, they have an hourly rate that's assigned by the state, and they have collection rights on you. They can enforce either a partial or a full collection of the bill. But the benefit is that you end up paying like $50 an hour instead of $250 to $300 an hour for an attorney.
Yeah.
But it's still, $50 an hour gets really expensive on a case too. It's not like that's going to be cheap for someone who doesn't have much. But I did a bunch of stuff for, $500 was all they could pay, and it's like, okay, we handled it, got cases dismissed for $500, which I thought was good work and a good deal. But go ahead.
No, you never know. But the thing is that as bad as it gets, sometimes you never know what cases. Like the case that I for those who don't know, I was in the front page of the New York Times. One of my cases made the Times, and that case, all I got paid was like $25 and some fried and they have dinner, right? Because the person they were in poverty, but we had a great outcome. It was great, and some publicity for the case. But you know, not. I think people fail to realize that in the legal profession, like here in New York, they literally force you to give back because they have the pro bono pro bono hours and things of that nature. But sometimes you can do just good work, and most people don't know the grind of trying to get cases and trying to turn them over. It's really, really, really a lot of work, and you get what you pay for. Unfortunately, a lot of people don't realize you do get what you pay for. If you could pay top dollar, you know how much. Look at O.J. Simpson. I always point to the O.J. Simpson case for this. That he paid millions and millions of dollars to that legal team, but it was worth every penny for him to be free. And that's what. And when you're up against these crazy prosecutors, that's the way you got to think about this as life and death. You can't be cheap. You got to pay because you want to try to stay out of prison.
And by the way, the prosecutor knows what your resources are.
Of
they know
course,
that
yeah.
going in. So, and they know it's a tougher fight if you have more resources, and that alone can play a role in whether or not you end up getting charged or brought to trial, because, you know, prosecutors mostly have at trial conviction rates of 90%, 95%, because they get to pick the cases they bring to trial. They like those easy wins. I mean, one of the reasons we use the tagline, be hard to convict, is because the harder you look to convict, the less likely you are to go to trial in the first place. And that's just the way the system works.
Because prosecutors don't like to lose.
No,
I mean,
they really don't. By the way, I saw some comments here about public defenders in the comments going by. Folks, I've worked with a lot of public defenders who were world-class attorneys. Just because someone's a public defender does not mean that they're a bad attorney by any stretch of the imagination. What it does mean almost certainly is that they're way overworked. That's extremely common.
Yeah, that's the thing with public defenders. It's not that they're going to do work incompetently or anything like that, but if your case has some novel legal argument, if your case has some special set of facts that would be found on careful investigation and examination, the public defender might miss it, not because they're incompetent, but because they've got 200, 300 cases going right now
and no resources.
They don't have the support. They don't have enough paralegal staff. They don't have enough co-counsel. That's the problem with public defenders. It's not about their competence.
Yeah, folks, we'd all like to believe that, you know, we live in a society where how much money you have doesn't affect the justice you get, but that's not reality. That's not how it works.
Oh, that's a great, yes.
Like, counsel, just stick around for a couple minutes.
Oh,
so we can talk about
snow cancellation,
autopsy picks, and maybe confer with Emmanuel on how we arrange that. Okay, Emmanuel? All right. Okay. Is counsel ready? All right. Okay, thank you, Deputy.
DG McBride says, great panel as always. I'm a lawyer in Tennessee, and I'm gifting Andrew's book to several of my friends who carry. Make sure you know what the definition of self-defense is. You don't want a surprise to the downside in that regard.
Oh, I can't hear you.
Get on the mic.
Find that the next witness goes pretty quickly. You consider the second witness. We do have another one in the hall.
Okay, well, how long is this witness going to take?
Depending on cross-examination, less than
A half an hour?
less than
Okay, and how long is your next witness after that?
depending on cross-examination, less than
Okay, let's see how it goes.
Now, I do want to make this point too. Four lawyers on the state side for any case is a lot. That's something that's rare. Usually you have, two, and even that, excuse me, even that is sometimes crazy. But to have four, that shows you they're really invested in trying to get a conviction here. It's
They've
kinda
also
crazy.
had two other attorneys make appearances who are not there today. So they've had at least 6 attorneys make appearances in this case.
Okay,
Even look at the OJ case. There was only two attorneys there.
Okay, just to let you know, it has started to snow. I am going to conclude the trial today a little bit earlier. I'm going to see how it goes. We may get through one witness or two witnesses, but I'm definitely going to let you go home early today. All right. Okay, the state may call its next witness.
At this time, the state calls Tony Grunig.
Is this the 12-year-old lawyer?
Yeah, this is a
Joshua
young guy.
Larson.
Officer, please come forward and stand behind the witness chair.
You know, you get more prosecutors on the case when there's going to be cameras.
Swear under penalty of perjury that you will truthfully testify in connection with this cause.
They are often
Take a seat.
trying to climb that ladder.
And remove your
politically.
mask, please. State your full name and spell it.
It's Tony Lee Grunig, TonyLeegruenig.
Okay, officer, a couple things to keep in mind when you're testifying.
So what are we going to get out of
The
this
court
witness
reporter, as you remember, is
that
taking
has
down
any
everything that's
relevance
being said.
to the
Yes or
actual
no? Instead of
case?
shaking your head. No,
Starting to get cumulative here a little bit, to be honest with you.
If you don't understand
little
the
bit,
question, let the lawyer know. If an objection is made, stop talking. Don't answer the question unless I tell you
Just
to.
1 second. Alec Urban says, I used to work in a PC repair shop. Someone's laptop that I was fixing had CP in a hidden folder. My boss and I called the police, and I was cleared because my boss vouched for me, and it wasn't my PC in the first place.
A police officer with the City of Brooklyn Center,
How long have you been a police officer for Brooklyn Center?
19 years.
Starting in 2002?
Yes, sir.
This is
you
the
have a
chief.
law
This
enforcement
is why.
experience prior to that?
Yes, I worked in South Dakota.
He's the acting chief today.
Yeah.
Not the chief who got fired.
Could you go back to the beginning of your career from Brooklyn
That guy's
Center,
the defense witness.
in Brooklyn Center and explain your role and rank and how it's changed over the years?
Sure. I started as a police officer in 2002. Spent about 3 years on patrol. I was promoted or moved into a drug task force position, and then a violent offender task force position, and then was promoted to a sergeant, and then promoted to a commander. Spent about 11 or so years as a commander. Within that role, I rotated through the 3 divisions. The division commanders report to the chief of police. I started in patrol, was moved to investigations, and then to community services. And then most recently, I was back in patrol.
Your current rank is acting chief of the department, correct?
Correct.
And how long have you been in that role?
Since April 12th or 13th, somewhere in there.
Of this year?
Of this year, yes.
And you're a licensed peace officer?
I am.
And you take continuing education courses to maintain that license, correct?
I do.
I'd like to discuss Brooklyn Center and the Brooklyn Center Police Department generally as it existed on April 11th of 2021. What's the population of Brooklyn Center?
That's around 30,000 people.
Where is it located?
It's a first ring suburb of North Minneapolis or Minneapolis.
Okay. And that's in Hennepin County, correct?
It is.
And how many licensed peace officers, when fully staffed, does the Brooklyn Center Police Department have?
Fully staffed is 49 police officers.
And out of those, how many sergeants are there?
There is 7 sergeants.
And how many commanders are there?
3.
And then there's just one chief, right?
Correct.
In this case, so far, the jury has heard about the role of a patrol officer and the role of a patrol sergeant. Could you explain your duties as a commander as of April 2021?
Sure. It's largely administrative. So report to work every day to a desk. But for the most part, take administrative duties, which could range from working on ordering patrol cars or answering emails, but largely administrative. We answer to the chief of police, and I have as a patrol commander, I'd have 6 sergeants that would report to me.
Yep. So I appreciate your modesty, but basically you supervise officers and sergeants, correct?
Correct.
And you said you have a desk job. Do you have essentially regular work hours, weekday hours?
Correct. Salaried employee, regular work hours, weekdays.
Okay. And what you describe as paperwork, but it's paperwork related to policing, correct?
Correct.
So I'd like to know about your duties when there's a report that an officer uses force. Can you describe the process that you follow?
So an officer will use force. A street supervisor would try to report to the scene when force is used. The officer then would fill out a use of force sheet that is reviewed by the sergeant. And then the sergeant signs off on the use of force sheet if it's appropriate force, forwards it to the divisional commander who is in charge of that sergeant. Generally, it's the patrol commander. The patrol commander reviews the use of force sheet and then submits it for filing.
And takes any necessary action, correct?
Correct.
I want to go one step farther from that. In addition to the protocols for responding to just use of force incidents, are there separate protocols for situations which would involve an officer involved shooting or in custody death?
Yes, a critical incident.
Yes.
Yeah,
And are you familiar with those policies?
I am.
Do those policies also place upon you as a supervising officer additional responsibilities?
Yes.
Now we can talk about those responsibilities in a minute. I now just want to get a big picture. In a scene response, in terms of scene response and who conducts any subsequent investigation, are these officer-involved cases handled differently than typical cases?
Yes.
How?
So and critical incidents, right? You're talking about?
Yes.
So we would just do our agency, Brooklyn Center, if it was our incident, would just do a cursory investigation, maintain the scene, maintain the perimeter, the evidence, and turn it over to another agency.
Okay. And by turn it over, you mean turn any subsequent investigation over?
The entire, yes, the investigation.
The entire investigation.
Yes.
And why in a critical incident do you turn the investigation over to a different agency?
For conflict reasons and for transparency, so that we can allow another agency to investigate the incident.
So you don't be seen as investigating yourself?
Correct.
Or drawing conclusions about critical incidents yourself?
Correct.
As of April of 2021, is there a specific agency that typically assumed the role of investigation should there be one in Brooklyn Center?
Yes, the Bureau of Criminal Apprehension, or BCA.
Okay. And in a typical case, how is the decision made to essentially outsource the investigation?
The chief of police makes that decision.
Aren't you the acting chief?
Bureau of Criminal Apprehension, and I'm going to refer to it as the BCA. If the BCA is assigned to investigate a case, does the Brooklyn Center Police Department have any role, at least at the outset?
To basically give them the information that they need to investigate the crime, a thumbnail overview of what's going on, and then handing the case over to them. So very little to answer your question more directly.
Okay. What about if an event is acute, if it just occurred, are there other roles or other actions that Brooklyn Center Police may need to take, knowing that the BCA is ultimately going to be taking over the investigation?
Preserving the evidence on the crime scene would be the other acute one.
Yeah. And what may preserving evidence in the crime scene entail? What might it include?
Maintaining a perimeter, maintaining integrity of the evidence and the chain of custody from our agency, turning it over to another agency.
Okay. And when the investigation is turned over to another agency, does that occasionally take some time for that other agency to arrive on scene?
Yes, they are generally not a 24/7 agency.
And so if there is an event that occurs, is it common for you to take into consideration that the investigative agency may not arrive for some period of time, including hours?
Correct.
And so you know that those efforts to maintain scene integrity may also last hours.
Correct.
When the BCA arrives, would a commander typically have additional responsibilities?
Yes, just to maintain the scene and perimeter generally, because the BCA would not maintain a perimeter probably.
Sure. Would you be typically obligated to convey some information to the BCA upon their arrival?
Yes.
And what information may that be?
The layout of the crime scene, the location of the witnesses, the evidence, the location of the evidence.
And that role often falls on your shoulders, correct?
Correct.
And does that also require then, when you would come to a scene of a critical incident, that you basically have to figure out what happened or to understand what basically happened so that you can convey that information to the BCA?
Correct.
Now, in a critical incident, what is typically done with the officers involved in, let's say, the shooting?
either as the shooter or a witness?
They're removed from the scene as quickly as possible, generally brought back to the police department with a partner officer.
Okay. Sometimes referred to as a buddy officer or escort officer.
Correct.
If an involved officer used a firearm in an incident, is there anything typically done with the firearm?
Eventually, I would say the BCA would collect that firearm.
But the agency that typically would be collecting that would be the BCA, not your agency.
Correct.
Prior to April 11th, have you responded to other officer-involved shootings?
Yes.
Have you done so as a supervisor?
Yes.
And have you followed Brooklyn Center's policies and protocols in those past incidents?
Yes.
Okay. Now I want to talk about April 11th.
Oh, thank God.
Do you recall that day?
I do.
Were you working that day around 2 p.m.?
No, I was off, but on call.
Did you receive some information that prompted a response from you?
I received a significant page from dispatch that our agency was involved in an officer-involved shooting.
And do you recall when you received that information? 2:15, sometime around there?
Correct, around that time.
Okay. And the information that you received was that there was an officer-involved shooting in Brooklyn Center, correct? That information?
Correct.
Okay. What did you do in response to that specific information?
Contacted the duty sergeant, Sergeant Johnson.
Okay. Did Sergeant Johnson convey any additional information to you?
Yes, gave me the involved officers, Officer Potter and Lucky, and I believe he also informed me that the victim was deceased.
Did he inform you that he was involved?
Eventually, I'm not sure if he initially told me.
Okay. After you received that information, what did you do?
Report back to my residence and then went to the scene of the incident.
Okay. How long did it take you to get to the scene of the incident?
15 or 20 minutes.
Okay. As you drove to the scene, did you receive any additional updates?
I'm sure I did. I probably contacted the chief of police as well.
Okay. And the chief of the police at that time was Tim Gannon?
Yes.
As you were driving to the scene, what role did you anticipate playing in this case?
The scene commander in charge of the crime scene, and eventually to have to turn it over to the BCA.
Okay. You had mentioned an individual named Sergeant Johnson. Do you recall how long you've known Sergeant Johnson?
His entire career, which somewhere around 14 years, 12 to 14 years.
Okay. And is that in your capacity as supervising sergeants?
Yes.
Okay. And could you describe your relationship with him? Personal, professional?
Professional.
Professional. You had mentioned Officer Kim Potter. You'd agree she's in the courtroom today?
I do.
She's the defendant in this case?
Yes.
Can you describe the scope of your interactions with her?
Professional mostly. Was the union president, and I was the patrol commander, so we had a fair amount of interaction. We also go to the same gym, so we talk about gym and workouts.
Okay. Could you describe the type of communication you had with her in the role that she played?
As the union president,
Yes.
Labor management negotiations.
Oh, this is
In
irrelevant.
this case, her activities as a union representative is not relevant. So move on, counsel.
Needless to say, you had interactions with her beyond those of someone who supervises officers. There was a secondary relationship that you had with her professionally.
Correct.
Are you familiar with Officer Lucky?
Yes.
And am I understanding that he is a fairly new officer in your department?
In field training, yes.
Wouldn't you agree
On
his
April
name is
11th, he was in
ironic?
field training, but he's still an officer in your department.
Correct.
Okay, now back to the incident. Do you recall when you arrived at the scene?
Around 2:38, 2:40, somewhere in there.
It was a pretty hostile direct.
As you arrived, were you wearing a body-worn camera?
No.
At that time, did you know who was in charge of the scene in terms of what sergeants were present?
I knew Sergeant Peterson and Sergeant Johnson were there. I believed probably Sergeant Peterson was in charge.
And that's Sergeant Michael Peterson?
Yes.
Mike Peterson?
Yeah.
As you arrived, can you describe what you recall seeing at the scene?
I arrived on the eastern edge of the scene, which would be like 63rd and Catherine area. There was a crashed vehicle. There was 2 crashed vehicles actually, and I believe the deceased was on the northwest corner of that intersection.
I'm only going to ask you a single question, and then I'm going to play a video. Do you recall that when you first entered the scene, you encountered an officer from the Brooklyn Center Police Department?
Yes.
And was that Officer Summers?
You liar!
Did you have a brief exchange with him?
Yes.
Okay. At this time, the
question
state
was 3.
offers Exhibit 91.
Any objections in 91?
And number 1 is cumulative, and number 2 is not relevant to this offense.
The objection is overruled. I'll allow you to, 91 will be admitted and you may publish.
Thank you. Please play 91, Mr. Miller.
I object to his counting skills.
And hey, bad math is why you go into law, right?
What's up?
We can handle some of the traffic.
They're down, way down there by the lights down, way down there. That's where the initial stop was, right by the school. Or
Like 63rd and Zane, or just down a couple more?
No, just right by the, is that the church or what is that?
Is Peterson down there?
So
Is
these
he
are
a witness?
the parents.
Okay. Any witnesses? Just the parents?
Well, no, I don't, not that I know. Yep.
We should all be wondering what the hell that mattered.
Following the event captured in this video, do you agree that you then walked down and talked to those sergeants, Sergeant Peterson and Johnson?
Yes.
When you arrived, would you agree that you sort of took over command of the scene?
Yes.
Did you receive information about what occurred at the
camera,
scene?
so I don't want to be eating on camera.
From whom did you obtain that
You're fine.
information?
Sergeant Peterson and Sergeant Johnson a little bit.
What did you learn?
Okay.
Soundbar to make the objection is sustained.
Hearing voices when you're in New York on it.
Okay.
So it improves that.
Sidebar.
She said there was an objection that was sustained for relevance.
He's gonna make.
He wants to
What do you
explain
think?
it.
What do you think? A business records exception. These are notes kept in the ordinary course of his conduct as a police officer. Therefore, they're an exception to the hearsay rule.
So
Was
what's
it
he
a
trying to
hearsay
object?
objection or a relevance
Uh,
objection?
It's a hearsay objection for what he learned from another officer. I think is the question when he arrived on scene. So there could be an ordinary course of course of business exception to the hearsay rule here.
So him being updated by the other officers, the hearsay. So you would, but how do you get around that? I don't know. Unless it's a report. A report, yeah, you get business records. But he's saying, what did these other people tell you? So I don't know if I don't know if you get around business exception.
Yeah. That video is can we agree that video is completely worthless? And like, why did we need to see video of him arriving on the scene and telling a guy that they were down there?
Just remind everybody about where Wright's body is.
Yeah, I suppose. I'm going to read a chat from, oh wait, no, I'm not.
Okay, I've already ruled on that objection. You may continue.
Yeah.
Did you discuss again, pardon me, was the information that you initially received about the involved officers reaffirmed that Kim Potter and Anthony Lucky were involved? It reiterates.
Objection is overruled. You may answer.
Yep. Did you learn about any other involved officer at that time?
Yes.
Pardon me, Your
Question.
Beyond Kim Potter and Anthony Lucky, did you learn that there were other involved officers?
Yes. Sergeant Johnson.
Was there another involved officer?
Sergeant Johnson.
Okay, yes. I'm sorry. Was there a fourth?
A A fourth officer?
Sure. Did you also learn information about an Officer Salvosa, who was an involved officer?
In the incident?
Not in the incident, but at the scene.
Yes.
Okay. When you learned that Sergeant Johnson's status as an involved officer, did his role change at the scene?
Yes.
And how did that change?
I needed to remove him from the scene and bring him back to the police department.
This is all to
You know
impeach
that there is
Johnson.
body-worn camera video which captures exchanges between you and Sergeant Johnson and Sergeant Lorenz and Sergeant Peterson?
Yes.
Okay. Just for the purposes of identifying witnesses, I'd like to show you a photograph. The state at this time offers Exhibit 92.
Is there any objection to Exhibit 92? 92 will be admitted and you may publish.
You're now seeing Exhibit 92 on the screen. Chief Grunig, can you describe what you see in this image?
I see myself, Sergeant Peterson on the left, and Sergeant Johnson to the right of him.
Now, when you say Sergeant Johnson is to the right of him, immediately to the right or something else?
To my right in the scene. Mike. Yeah.
Yeah. Would you agree the timestamp in this image is normal time, 2:38 and 28 seconds?
Yes.
As you spoke to your sergeants, what were some of the issues that you needed to address as the scene commander at that time?
Where the crime scene occurred, the evidence, the perimeter, the involved witnesses, where those parties were, if they needed to be removed or not.
Did you ever speak to Officer Potter or Lucky?
No.
Were they on the scene when you arrived?
No.
Do you know where they went?
I believe they went to the police department.
Now, with regard to Sergeant Johnson, you did speak to him.
Briefly, yes.
And he conveyed information to you.
Yes.
And you discussed the incident with him.
Yes.
This is sounding like a cross-examination.
And he
This is
knew.
all leading now.
Yeah.
Do you know that why Sergeant Johnson did not leave the scene immediately when Officer Potter and Lucky left?
I would guess to relay information to me.
This is
I don't
speculation.
know for sure what he was thinking.
But eventually Sergeant Johnson did leave the scene?
Yes.
Should have objected.
Were you aware of any other civilians besides the deceased, Dante Wright, who were involved in this case?
Yes.
And who were they?
Mr. Wright's girlfriend, who was a passenger in the vehicle, and then another couple that was struck by his vehicle.
Okay. And they eventually left the scene too, correct?
Correct.
After you gathered
Oh, they're still
information
there.
on the scene and the status of the incident and the response and the investigation, did you take any actions?
Contacted the BCA.
And did you make a request of them?
Yes.
And what was that request?
To report to our crime scene and investigate an officer-involved shooting.
Do you recall when you placed that call?
Not exactly, no.
If you could estimate a time, could you?
Somewhere around 2:45, 3 o'clock.
Could you walk us through that phone call?
Generally, I would have contacted Mike Phil and relayed where we were, the brief incident about what occurred, the location of where we were, some of the witnesses that we had. I would have also relayed that Sergeant Johnson had Officer Potter's handgun, and Officer Potter was the involved officer.
Did you report to your sergeants that the BCA was coming to the scene?
Yes.
And at that point, did you direct your sergeants to do anything?
Probably just to maintain the integrity of the scene and the perimeter.
At that point, did you inhale or exhale?
And as you were waiting for,
were you
the BCA's
ambulatory?
arrival, do you recall speaking?
Did you
to
move your
civilians at the
legs?
scene?
I believe I spoke to Mr. Wright's mother.
And what was the purpose of your communication with them?
To express my condolences and ask that she not move into the crime scene.
If I showed you a still image of you talking to the Mr. Wright's family, would you recognize it?
Yes.
This time the state offers Exhibit 94.
Give me what your objection is.
What is the purpose of all this?
You have a lot of fiction.
The objection is sustained.
Thank God.
Yeah, this is like kind of
Prior
ridiculous.
to
now.
today's testimony, did you see a photograph of you talking to the Wright family?
Yes.
At some point, did agents from the Bureau of Criminal Apprehension arrive?
Yes.
And did you have any contact with the agents?
Yes.
Who did you
Sexual conduct?
Mike Phil, special agent.
They're already
And you
pushing
recall
that
at what
30-minute
point,
window that they said
Special
with
Agent Mike
cross,
Phil arrived
by
at
the
the
way.
scene?
Not exactly the time. Probably about an hour later.
Hour later, maybe 3:45 then?
Yeah.
When he arrived, did you discuss with him the information that you knew?
Yes.
And was it important at that time for you to convey everything that you did know?
Yes.
What other information besides just the basic factual circumstances did you convey to Agent Phil?
The answer is based on hearsay.
That's a big
Sidebar.
catch too. It is. It's
Judge,
not. Even though he made the statement, this is interesting. Even though he made the statement, it's not a court statement being over for the truth. So it's a weird little hearsay catch. But he's right. He's talking about, well, what did you say outside of court?
If this judge is not getting on this thing saying, where the fuck are we going? Like, what is happening? Why are you?
I don't understand these judges who will not act like judges. I don't. Why do you have that job?
This is, it's so far, like there's nothing coming out of this.
The whole reason you exist is to hold these lawyers in check.
Yeah.
He told you 30 minutes with cross, depending on cross. I think we're at 30 minutes in about 3 minutes, something like that. I don't have the timer, but it's 2. We came back for lunch at 1. It's 2:03. We came back for lunch at 1:30. There was a little bit of talk beforehand.
Yep.
I mean, what are we doing? They might just not even cross him because there's literally nothing to ask that this guy knows about the incident.
Unless he's got some damaging hearsay. I mean,
Okay, counsel, you understand what my prior ruling is.
gonna break it. They always do.
Am I correct, Chief, that you conveyed to Mike Phil that Brooklyn Center Police Department would continue to provide scene security and keep track of the officers and witnesses who were involved at the Brooklyn Center Police Department?
Yes.
And did you also convey that you would open up the Brooklyn Center Police Department so the BCA can come and conduct a fair and independent investigation?
Yes.
If I showed you a photograph of you speaking to Mike Phil, would you be able to identify him? This time the state offers Exhibit 95.
Objection, relevance, and cumulative.
Objection to Exhibit 95. I don't believe it is. The objection is overruled. 95.
Even
will
he's
be-
smiling.
Is Judge Chu going to correct Larson here for the facial expressions? The smirking?
I don't think so.
Sergeant Green, for the record, you're being shown Exhibit 95.
How's
can
this
you
not
describe what you see
cumulative?
here?
I've seen
It's
this.
the car again.
Okay. And he's the individual.
This is supposed to be for identification purposes.
Yes.
Okay. And where are you
They're
standing?
the smallest things in this image.
In front of the victim's vehicle.
Okay. And would you agree the timestamp on this image is 15:52 or 3:52 p.m.?
Correct.
And was this the time frame when you were conveying to Agent Phil what you were told about this incident?
Yes.
How long did the BCA remain at the scene?
How long do you bathe?
How long did the BCA remain at the crime scene conducting the investigation?
Until around 7:30, 7:45 or so.
Okay. How long did you remain on the scene?
For that entire time.
And by that time, to your knowledge, the crime scene investigation had concluded?
Yes.
I showed you a picture of the
Now,
crime
I
scene.
would like to talk about your role in this case since the incident. Has the Brooklyn Center Police Department
If
cooperated?
I showed you a
with the
picture of your
BCA since this
bedroom,
incident?
Yes.
would you understand what I'm
Have you
asking?
made officers available to speak to the BCA?
They have.
Have you made officers available to talk to the state and the defense in this case?
We have.
Have you made
Have you
available
obstructed
training
this
records,
investigation?
personnel records, body-worn camera footage, squad video, records from prior cases that may
It sounds
bear
like a cross-examination now.
We have.
No further questions. Thank you, Chief.
Yes.
They're gonna ask to strike the entire testimony, maybe. Like, what's the purpose of this? What did that help? The BCA was on scene. Okay, is that a fact in dispute? You've got five.
Are they trying to impeach the entire Brooklyn Center Police Department? Say they're not trustworthy?
Yeah, no cross. Didn't think.
Yeah, there's no reason to cross them.
Next witness.
This time the state calls Special Agent Mike Phil.
Oh my God.
BCA.
Yep.
Let me go pick up my other kid. I'll see you guys later. This is brutal, man. Oh my God. They just
Well,
this is
it's
as
just
cumulative as it gets.
And it's a complete waste of time. Anyway, yeah, we'll see you later, Nate.
And this judge is not making it
Special
any
Agent,
easier.
will you please step behind the witness chair? Raise your right hand. Do you swear
Guys,
under
this
penalty
is
of
not the
perjury that
Schrader
you will
court. You can
truthfully
say victim
testify
all
the
day in
case
this
of
court.
Please take a seat and please remove your mask. State your full name and spell it.
Charles Michael Phil.
Oh, I hate that time.
LES Michael Common Phil P as in Paul HILL the second.
My first question would be, why are you wearing a
Couple
bow tie?
rules to keep in mind when testifying. Yes or no instead of shaking your head or saying or because the court reporter is taking down everything that's being said. If you don't understand a question, let the lawyer know. If an objection is made, stop talking immediately and don't answer, please.
I want to see that bow tie
Unless I
spin.
tell you to. And only one person can talk at a time. So wait until the question's finished before you answer.
Wonder why I didn't wear a top hat.
Okay. Counsel?
Could you state your occupation for the record?
I'm an assistant special agent in charge at the Minnesota Bureau of Criminal Apprehension.
How long have you been with the Bureau of Criminal Apprehension?
14 years now, almost 15.
Are you currently in the Force Investigations Unit?
Yes, I supervise that unit in the state of Minnesota.
Can you describe for the jurors, just taking another step back, can you describe for the jurors what the Bureau of Criminal Apprehension or the BCA is?
Sure. We're the largest investigative arm for the state under the Department of Public Safety. In the BCA, there's 3 divisions. There's the laboratory, there's Justice Information Systems, and there is investigations, which I'm a part of.
You're the Minnesota
Then
FBI.
investigations, there's clearly many other sections.
I now want to discuss your background, sir. Prior to your career in law enforcement, could you describe your educational background?
Sure, I have a bachelor's in criminology from Fresno State University in California and a master's in criminal justice administration from Michigan State University.
After school, where did your professional career begin?
I was a deputy sheriff for 4 years in Seattle, Washington, King County Sheriff's Office. And I then lateraled to Minnesota to work at the Brooklyn Park Police Department. And then after that, 2007, I joined the BCA.
Brooklyn Park, where is that in relation to Brooklyn Center, Minnesota?
It is right next to it, right straight to the west.
When you transitioned to the Bureau of Criminal Apprehension, what roles have you had at the BCA?
I joined in 2007 with the predatory crime section, then did some narcotics. Then I went to the financial crimes task force. After that, I joined
Those witnesses well prepped.
crime scene team, then to homicide. I was in homicide for 5 years.
Well aware of what questions are going to be asked
After
of me.
that, I was promoted.
Maybe
and,
he's friendly
supervised the predatory crime
to
section
the state.
in the metro here, and then the information and operations section, and then back to homicide.
Nothing wrong with prepping a witness, folks. I'm not suggesting anything wrong. It's just
And
an
all the
observation.
time that you've spent at the BCA, 16 years, that's all been investigative?
Yes, sir.
And you're a licensed peace officer?
Yes, sir.
And you take continuing education courses to maintain that license, correct?
Yes, sir.
Am I correct that as the supervising agent of force investigations, you conduct investigations on police officer use of force cases?
Yes, we do.
And obviously that would include officer-involved shootings.
Yes.
And as a supervising agent, what duties and obligations do you have?
Well, as a supervisor of the unit, there's currently about 10 of us. There's about 100 agents in the entire BCA, but our unit's about 10. When we're notified at the request of another agency, because the BCA is an assist agency first and foremost, we're requested to take over these investigations. Once that occurs, then I start to make phone calls, notify my administration, figure out what happened, and try to figure out how many agents I need to respond.
And let me unpack that just a little bit. In regard to officer-involved shootings, does the BCA, I believe you testified, does the BCA work on those at the request of local agencies, or do you have a separate jurisdiction?
At the request. The BCA agents have statewide jurisdiction throughout the state for any crimes in Minnesota statutes. However, uses of deadly force, officer-involved shootings, we're not required by law to investigate those. Sheriffs and police chiefs can decide who they want to investigate those. They tend to call the BCA. We've done them over the years, more and more each year, and we're now kind of the preferred agency. However, it's not required that we do so. It's at the request of a chief or a sheriff.
From a scene response and investigative role, why are these cases handled differently than typical cases within particular law enforcement agencies?
We call these cases critical incidents. They're not always shootings. They're uses of deadly force usually. So they're high profile cases. And by calling in an objective third party organization to the investigation, it allows the chief, the sheriff to step back and let another organization investigate it, handle the case all the way to its conclusion, all the way to court if need be.
Avoid conflicts, be independent, etc.
That is correct. So there's no appearance of bias.
Okay.
Maybe.
When an incident of this type occurs,
or bias in the right
then
direction.
like you get a phone call from a chief of police or a commander or something like that?
Usually law enforcement will call our operations center, which is 24 hours, or if they know us, which many do know the agents in my unit, they'll call us directly and they'll say, we just had a critical incident, we just had a shooting. And then they'll ask what to do next. We ask them certain questions and that helps us coordinate our response.
If the BCA is assigned a particular case, does the local agency have any role in the case?
Oh, absolutely. Because these cases occur throughout the state, we're responding. I have agents throughout the state, so it can take us anywhere from a half hour to 3 hours to get there. So in the meantime, the local agencies there, we rely on them to secure the scene, make sure that it's properly protected with tape, barriers, whatever need be to protect the evidence, and keep out citizens, media, anybody who might disturb the evidence. That's required. We need them to do that because we just don't have the personnel or the quickness to get there. And then we also need them to coordinate getting witnesses out of the scene and back to the police department or the sheriff's office so that we can interview them and talk to them.
Once the BCA arrives, does the local agency still have a role?
Yes. So even after we've arrived on scene, there's a lot of information that we're still gathering to figure out what happened, how many people are involved. It's always an ever-changing process. As soon as we arrive, more and more information becomes known to us. So as we are liaisoning with that agency, we're asking them certain things like, do they have body cameras? Do they have squad video? Is there evidence they collected? There's certain documents, reports, records that we're going to ask for. So throughout the process, we are asking certain things of that agency.
In the years since you've been at the BCA, how many officer-involved shooting cases have you worked on?
I have worked on, meaning assisted in some way, well over 100, and I've been the case agent for probably 24.
Can you describe what is entailed by being a case agent or lead agent?
Certainly. These cases are not typical cases where maybe one person or two agents can work them. They really take multiple agents. So the case agent is just the person who's the lead, who tries to take the lead initially to speak to the involved officers, speak to the family of the civilians involved, to kind of give them both a picture of what it is we're going to do. And then multiple agents will do all sorts of duties, interviews, evidence collection, however that may be, and it could be throughout the state for one incident. They will do their own reports. Those reports will come in, and the case agent's job is kind of watch those reports come in, see what evidence is being collected, watch videos that can be watched, and make sure that pretty much the I's are dotted and the T's are crossed for the case file.
I'd like to talk about how a case begins in your unit. Can you describe a typical protocol for how the BCA responds to the scene and what they do at the scene in a typical officer-involved shooting?
Typically, we're called. Usually, they're at nighttime or the weekends, and I try to get as much information as I can. And as I said, it's always fluid, but I need to know how many people to respond. So I'll try to figure that out first. Once we know how many people to respond, we need to know the area, the address, obviously, indoor, outdoor, those sort of things. I also need to notify my administration, who needs to know certain information. I have to notify the crime scene team. At the BCA, our crime scene team is comprised of mainly scientists, not police officers. They're not sworn. They're scientists who trained in collecting evidence. So I notify them so that they can respond with the appropriate personnel they need to get to the scene and do what they need to do. Once we start to figure out a little bit of what's happening, I'll usually direct certain agents to the police department or the sheriff's office because there's work to be done there, and then others will go to the scene itself because there's work to be done there.
So it's you'd agree that it's essentially information dependent. How many agents, where you need to send them, what do they need to do, et cetera.
Yes, sir.
I guess this must all be foundational, right? For some information they want to get into the record.
Yeah.
Do you recall that day?
I'm just not sure what
were you
information
working
they
that day?
want out of this guy.
No, it was Sunday.
Did you receive some information that prompted a response from you at approximately 2:45?
Yes, I was advised by our 24-hour operations line at the BCA that the Hennepin County Dispatch wanted to connect me to Commander Tony Grunig of the Brooklyn Center Police Department in regards to an officer-involved shooting. I called Tony, got some preliminary information from him, which was, he told me that one of his officers.
Okay, just don't relate things that people have told you, okay?
Okay.
You may continue.
Good catch.
You'd agree that Commander Grunig provided you information, correct?
Yes.
And then on the basis of that information, you decided what was an appropriate response from the Bureau of Criminal Apprehension, correct?
That is correct.
And did you make all required notifications of on your team?
Yes, I did. Based on what I learned, I directed some agents to the Brooklyn Center Police Department and others to the area of 63rd and Catherine and Brooklyn Center for what I was told was a shooting scene.
What I was told.
Okay, I know this is kind of difficult, but would you please refrain from repeating things that other people have told you?
Okay.
Okay.
A smirk on his face.
Do you want to move on, counsel?
I will. If the objections persist, I will ask for a sidebar here.
All right.
When did you arrive at the scene?
I believe I got the phone call about 2:45. I got there about 3:45, so about an hour.
Okay. At the time of your arrival, was there any other personnel from the BCA present?
No, I was the first one.
When you arrived, how many individuals from the BCA were present?
I was the
Just
first
myself.
one.
Yep. Can you
Earl Grey's terrified of a sidebar by Larson.
I parked close to the scene, got out of the car, and was immediately contacted by Commander Tony Grunig.
And did
What did he tell you?
Commander Grunig then convey information about what he knew
More.
Occurred?
Yes.
And did he then give you a walkthrough of the crime scene?
Yes, he did.
And do you remember the significant observations that you made on your initial arrival at the scene of the crime scene?
Yes.
How is this not cross-examination?
I walked to a Buick that was crashed and up on a curb. In front of the Buick and to the left was a deceased male who had some clothing removed and some medical apparatus were nearby. I could observe he had a gunshot wound to the chest area. There were 2 Hennepin County deputies standing nearby. I asked them if they had a tent. They said we did get a tent put up immediately so that we could cover his body. I then started to ask Tony Grunig some more questions about personnel involved at the scene, which would help me direct what to do next.
The people he identified as involved officers, did you know their location at that time?
Yes.
Okay, and that was a Brooklyn Center Police Department?
Yes, it was.
He checks more lists than Kraus.
Kraus, to be fair, was
After
only
you
checking
spoke to Commander Bruni,
menus.
what did you do next?
I began to contact my agents, and I needed to advise them of the size of the area, what needed to be done. First and foremost was the canvassing. I also observed what appeared to be family member inside the perimeter. I went over to those people who looked like family, introduced myself, and found out that they were related to the decedent. I told them who I was. I told them what our role at the BCA was. And even though they were inside of the perimeter, they were not near evidence or the decedent. So I allowed them to stay in that position, stay there, so that we could do our job at the crime scene.
Did other members of your team arrive at that point?
Yes, they did.
And did that include forensic scientists?
Yes, the crime scene team did arrive.
What tasks did the crime scene team take up at that point?
One of the things that I do as I'm there collecting information is then as soon as the crime scene team gets there, the team leader will ask me what I've learned since the time I spoke to her on the phone to ask for her to respond. And then by the time she arrives. So
There'll be more hearsay
obviously there's
now.
more information I gathered. I relayed that to her. And at that point, I did know that there was a traffic stop that started it. And that was farther down from where the crash scene was and where the body was. So I advised her of that. I did not know much more as far as evidence collection, meaning how many bullets were fired, what direction, those kind of things that a team would need to know and usually ask me. I didn't have those answers at that time, but I did tell her what I did know.
Did they, to your knowledge, follow the protocols that they have, such as photographing the scene, searching for evidence, documenting the scene, et cetera?
That is correct.
Okay. And did other licensed law enforcement agents arrive as well?
Yes, I did have some more agents arrive, and they took up some duties such as interviewing the family and canvassing neighborhoods.
The crime scene team, are they led by a particular individual?
Yes.
And who was that on that day?
On that date, it was Melissa Lauren.
Melissa Lauren. And the agents that arrived, did those agents include agents such as Brent Peterson?
Yes.
And as the supervisor of this team, as those efforts were taking place to canvass and to search the area for evidence, did you oversee their actions?
Yes.
Could you describe to the jury what canvassing means?
Sure. Canvassing means that we go door to door and knock on the neighbors' doors, whether they appear home or come out and talk or not. Hopefully we can make contact. We'll ask them if they saw or heard anything, because there's eyewitnesses and there are ear witnesses, and they will usually tell us. So we identify them. If they did hear or see, then we will do a taped interview with them so we can record that statement. We also ask if anybody has outdoor cameras on their home, security cameras. If they do, we ask if we can get a copy or we'll get a search warrant for those. We also ask if they recorded the incident at all on their own personal phones or devices. And if so, we will get copies of those.
Okay. Now, you previously testified that you had covered the body of the decedent. Let's get this out of the way. Was the decedent ultimately identified?
Yes, sir.
And his name was?
Dante Wright.
Okay. You testified that you had covered Dante Wright's body with a tent. I don't think just those words alone would help the jury understand what you mean. At this
How
time,
bloody was the body?
pardon me. Do you know that there was a photograph taken of this tent?
Yes.
At this time, the state offers Exhibit 98.
Did you?
Any objection to Exhibit 98?
Did you ever see
Exhibit
any baby
98
pictures
will be
of the
admitted into
deceased
evidence in
victim who
the
was murdered
picture.
by the police officer?
Special Agent Phil, I'm showing you Exhibit 98. Could you describe what you see in this image?
Yes.
Tent.
I'm standing myself in front of the unmarked squad. I have a hat on.
Agent Phil, could you move that mic? I see you're moving to look at the photograph. I just want to
Agent
make sure
Phil,
the
do
jury
you
hears
always wear stupid hats in the field?
Please proceed.
I'm talking to one of my agents, Colleen Myrie. And then I also have the crime scene team leader, Melissa Lauren, to my right. And then there's a crime scene team member to her right.
Okay. And is the tent that you testified about in this image?
Yes, that is the tent that the Hennepin County Sheriff's Office erected for us.
Okay. And that is the tent that covered Dante Wright's body after you arrived at the scene?
Yes, sir.
During the time when the crime lab team was looking for evidence, did they direct their attention to a particular location? Was there something in the crime scene to which the crime lab directed their attention?
The car itself, generally, is where we were working to start.
The white Buick, which was located in the image there?
Yes, sir.
Okay. And why did they direct their attention toward that?
There was a lot of blood inside the vehicle. There was a lot of blood inside the vehicle. It was clear to us that Dante Wright had been in that vehicle. We did not know what occurred in the traffic stop. So one of the things we're looking for after we get a search warrant is a weapon to see if there are any weapons involved. So that's what we were looking for.
And was at least some evidence of a fired gun located in the vehicle?
Yes.
And what was that evidence?
It was a fired gun cartridge.
Cartridge. Okay. And what's the significance of finding a cartridge?
Objection, irrelevant at this point.
The objections overruled. You may answer.
The significance of finding one cartridge would help to know that a bullet was fired, a gun was fired at least once.
I don't
We did not
know what
how
the
many times,
objection
so
was there,
one
honestly. Like,
was significant, but we didn't know if there were more to find.
Where was the cartridge located? Do you recall?
In the driver's seat, I believe, in blood.
Now, as you were on the scene with your members of the Bureau of Criminal Apprehension, did another agency at the scene, did another agency arrive at the scene to conduct additional investigation?
Yes.
And what agency was that?
The Hennepin County Medical Examiner.
Okay. And when did the Hennepin County Medical Examiner arrive?
I'm not sure at the time.
Okay. And what occurred after the Hennepin County Medical Examiner came to the scene?
I was there when they arrived, the investigator and the doctor. We do not generally touch or move decedents until they arrive because those bodies are in custody of the medical examiner as evidence so that they can do an autopsy. So we will not roll or move or touch until they arrive. So once they arrive, then all of us went inside the tent to observe the body.
Okay. And ultimately, did the medical examiner take that body with them?
Yes, they did.
Okay. After the medical examiner took Mr. Wright's body, did the BCA continue their work in this case until at least 7:30 p.m.?
Yes, we did.
Okay. And approximately 7:37, is that when the BCA left?
That's when we cleared. I was the last BCA person to leave.
Okay. While you were at the crime scene, did you receive any updates from other agents at the Brooklyn Center Police Department that assisted you in directing your investigation?
Yes, I did.
And what information did you receive that assisted you in directing your investigation?
Objection, hearsay.
It's not a hearsay purpose, Your Honor.
Objection is.
All right. Okay. Just make sure, agent, not to relate anything that somebody told you. Okay? All right. Could you restate your question, counsel?
what information?
Did you learn based on communication with your other agents that a firearm was recovered? In fact, 2 firearms were recovered?
Brooklyn Center.
Objection leading.
Yeah.
Leading in hearsay.
Did you also learn that body-worn camera footage was reviewed by your agents?
Yes, sir, at the Brooklyn Center Police Department.
Did you also learn that a taser was collected from the Brooklyn Center Police Department?
Yes, sir.
Was that taser actually a gun?
After you left the scene, what was the next step?
Block 17
in the
tasers.
investigation.
After clearing the scene, our priority was to take the evidence back to our headquarters in St. Paul, and that included the Buick vehicle so that we can do a full search there. We don't like to search vehicles. Generally out on scene, we like to bring them to our garage area where we can control the weather, control the lights, and collect any evidence that we find much more safely and without losing things on scene. So evidence went back to the headquarters. And then I also stayed in contact with Brooklyn Center regarding things like body camera collection and squad video collection.
Okay. And the body worn camera and the squad video, those were ultimately reviewed?
Yes, they were.
Did you also direct agents from the BCA to conduct interviews of any individual with material information about this case?
Yes, we will interview anybody who is willing and wants to talk to us, citizens, officers, anybody.
Okay. Did you request any forensic testing of recovered evidence in this case?
Yes.
Could you describe some of the forensic testing?
Some of the testing that was done was by the firearm section of our laboratory. So they will test the firearm. They will test to see if it matches casings, bullets, if they're recovered from the scene or from a person at autopsy.
Was an autopsy performed on this case? Yes.
Yes.
And was evidence recovered from that autopsy and brought to the BCA?
Yes.
Now, following your actions on the physical evidence and on the video evidence, did you also collect some documentation or paperwork from the Brooklyn Center Police Department?
Yes, we did.
And did that include training records and employment records?
Yes, we request those for most uses of deadly force.
Okay. Why do you collect training records?
We collect training records to make sure that whatever weapons or tools or devices were used were in accordance with the department policy. And if so, when were they last trained on them to use them? It's a pretty important thing that prosecutors request.
Agent Phil, you've discussed a number of actions here that were taken by other individuals, other investigators, other scientists. Are you aware that there are other BCA agents and scientists who are going to testify about their roles, their respective roles in this case over the course of this trial?
I am aware, yes.
Okay. No further questions at this time.
Did we introduce him just to get to the BCA
Thank you,
scientists?
Agent. You may step down.
At least they didn't bother with Cross.
Oh my God.
Again, nothing. There's nothing to that.
All right, members of the jury, we're going to adjourn for the day, and we'll start up at 9 o'clock on Monday. But I want to remind you of the instructions I gave you earlier regarding your conduct as jurors. Please keep these in mind each time we recess and when we adjourn for the day. As I explained earlier, it is essential that you follow these rules to ensure the fairness of this trial to all parties. While I will not try not to repeat the instructions to help you remember, I may not always do so. So if I forget, please remember what these instructions are. Just because I don't repeat these instructions don't mean they don't apply. Do not let outsiders influence you. This includes family members and friends and anyone else who was not actually involved in this trial. Do not discuss this case with other jury members during the trial. You'll have plenty of time to do that at the end of the trial. Once you've heard all the evidence and I've sent you to the jury room with my instructions and the verdict forms. Do not talk to anyone involved in this case, the defendant, the lawyers, or the witnesses. If anyone tries to discuss this case with you outside the courtroom, report this to me. When you go home during the trial, do not talk to your family, friends, or others about the case. You may tell them that you are a juror on a criminal case, and that is all I want you to tell them. Do not report your experiences as a juror while the trial and deliberations are going on. Do not email, blog, tweet, text, or post anything to Twitter, Facebook, LinkedIn, Google+, YouTube, or other social networking sites about this trial, even if I have not specifically mentioned other media sites. Do not visit any chat rooms where this case may be discussed. Do not read or listen to news reports or newspaper,
Don't say YouTube.
magazines,
Don't say YouTube.
radio,
Don't say YouTube.
television, podcasts, or other media about this case.
Don't read law
Do your
self-defense.
own investigation. Don't ask people about the case. Don't visit any of the locations mentioned in the trial. Do not use internet map applications such as MapQuest or Google Earth or similar mapping media to view the locations.
MapQuest still around?
Do not research anything about the case, including the issues, evidence, parties, witnesses, location, or the law through any form of written, print, electronic, or internet media, including Google, Safari, Firefox, Bing, or similar search engines. Do not create your own demonstrations or reenactments of the events which
Do
are
not
the
use
subject of the
CompuServe.
case. Keep an open mind until you've heard and seen all the evidence. Remember that you cannot consider anything you hear or learn about this case outside
Chat finally
this
heard
court.
Firefax.
If you don't follow these instructions, you may jeopardize the trial. This may require the whole trial to be redone, and we will have to start
Oh,
over.
heaven forbid.
You may also be penalized for your misconduct. If you become aware that another juror may have violated any of these rules, you must report it to me. I know that it can be a difficult thing to do, but in order to preserve the fairness to all parties that is guaranteed in our system of justice, it is very important that you do so. All right, I think it might be a little slippery out there. Travel home safely and have a relaxing weekend, hopefully. And I will see you on Monday morning at 9 o'clock.
Oh boy. Now we get some lawyer talk after hours, I think.
Okay.
You left your mask? Throw him out of the courtroom. Banned for life.
No mask. Isn't that reckless manslaughter?
Yes.
All right, please be seated. Counsel, what I'd like to do is just have an in-chambers conference with you about the autopsy photographs, okay? And how we're going to deal with them with respect to live streaming. I'm going to invite our technician in to let you know what you should do if a photograph is going to be shown. As you know, the overflow courtroom, the autopsy photos will be depicted, but the autopsy photos in respect to the wishes of the family and the dignity of the deceased will not be live streamed. So if you could follow me back to chambers, and Emmanuel, when you're ready, would you join us, please?
Well then.
Well, that was enlightening, or not.
Not.
Really glad we got those last two witnesses in. That was having neither of them. I mean, if they had asked any on cross, it would have been well over 30 minutes. I think the first one was over 30 and the second one was right at 30.
Yeah.
Oh my goodness. And I can't figure out what the necessity of having them on. Do we need to have the BCA agent there to testify to lay foundation that there would be other BCA scientists that were going to testify? I don't think so, but I can't figure out. I can't figure out what that guy's entire purpose was.
What was the BCA expert? At risk of sounding stupid.
He was just the first BCA agent on the scene, and
lead.
The first agent on scene.
Yeah.
But he didn't add anything. Like, there was nothing new, and he wasn't present for the actual shooting. All of his investigation work was done either at the site of the subsequent crash or I guess at the lab. He didn't testify about any interviews that he had.
Just another opportunity to remind everyone that someone's dead again. Is that what we're doing?
Yeah, that was my sense.
Yeah, where we've already been busted by the prosecution for please stop doing this.
I mean, I don't see what he could testify to that would be an issue in dispute in the case. I mean,
was
certainly
just
not
about
for
to
this
say.
kind of duration of time.
Yeah, it feels like they maybe have a strategy of, if we put a bunch of people in front of the jury, the case will seem more complicated to the jury than it actually is.
Yeah, you don't want to do that. But here's my question. There's really only one fact in dispute. We saw what happened, right?
Yep.
Yeah.
So we it's not like anyone questions who shot him, or her identity, or the manner of death or the cause of death. None of that's in question. So all this like scene processing stuff, I want to hear more about the use of force continuum. I want to hear more about, like, what are your policies within the police department about tasering. She talks about that in her opening statement, but I want you to like support that with the evidence at the trial. I want you to get into how it is that you're showing that she was reckless. Like, what standard was she consciously disregarding? Establishing the standard more. I was thinking this was going to be more of a technical trial that was going to be down to experts on use of force, not so much fact witnesses on what happened like following the actual event. So that surprises me.
Yeah, that's what you would think. I mean, that's what they have to prove. This one thing, they have to prove that her pulling that trigger rises to the level of either culpable negligence or an assault that can then be used to support first-degree manslaughter. I mean, other than that, they don't have to prove anything. I was thinking about it. The BCA guy did testify that he retrieved, or either he retrieved or one of his agents retrieved the bullet casing from the car. But again, it's not in dispute that she fired a round. It's not in dispute what gun it came from. It's not in dispute that there was one bullet fired.
It's not relevant. It's not even relevant.
I think you nailed it exactly, Natalie. It's really a question of law trial, right? Does this conduct we all saw, that's undisputed, does that qualify as reckless under the appropriate legal standard, right? Was it an intentional disregard of unjust creation of a risk of death? And it would seem the facts would suggest, I think, no, that no one was more surprised than her when the gun went off instead of a taser went off. Now, in the state's own motions pre-trial, they argued that all the intent that's required for recklessness here is her intent to pull some weapon. Any weapon is enough. I don't think that's the right legal standard, but it may be all they have to go on for this prosecution.
I mean, I could actually see them bringing in a bunch of these witnesses if there were something like testimony that she had confided in them, that she knew she pulled the gun, or that she knew that she had concerns that she would pull a gun, or concerns about her status of training or something. If they had some statements against interest that she had,
we would have heard that
in
in opening.
Right. But that's the only thing. Again, I'm trying to find any reason that the state would maybe bring this many witnesses about this simple, it's not a simple question, but about this direct question.
It's a succinct question. So like you and I probably, you don't call yourself law of self-defense. We haven't met yet.
Oh, Andrew, sorry.
Andrew. Right. We don't come to the same conclusion, I think, but I think that we both agree on what the issue at controversy is. Right. And I think that we're both saying that the state at this point is not getting to the issue in controversy. The issue in controversy is simply, what is the standard as far as the deployment of the taser? And did she breach the standard, right? Did she breach her standard, her duty, and did she do so with a reckless disregard? Okay. And I don't need to hear about the bullet casing. I don't need to hear about, I took her gun off of her because I thought she was going to harm herself and, put my gun on her. They don't need to hear any of that. All they need to hear is, hi, I am such and such, the taser trainer for this police department, and we train them to do this with their taser. And if you don't show me that, then I'm not going to think that this person breached the duty, because I don't know what the duty is, And so that's really what the question is. In the opening statement, And again, they may be getting there, but you're going to lose your audience with bogging them down with too much information. It's actually not a good prosecution strategy to put in a bunch of extraneous information, because it can tend to overwhelm the jury. They'll get confused. They'll say, I don't know what happened, so I can't find him or her guilty beyond a reasonable doubt. But what you have here is you had an opening statement, which I thought very clearly set out, probably with too much argument, but very clearly set out what you were going to show me. You were going to show me that there was a standard with the taser and that she did not follow the standard with the taser. And because she didn't follow the standard with the taser and she did it with a disregard, she is guilty. But up until this point, what is it? 3 days into the trial? 4 days? You haven't.
Yeah, we're day 3 of test.
Day 3. Right around the time for the drone video to show up.
Right. It is a Friday after all. We'll have to see. But no, that's the question is, how many more days of state testimony are we going to have before we get the medical examiner? I mean, you have to get the medical examiner to come to lay foundation for cause of death. You have to do that in a manslaughter conviction. You don't have to belabor it. But you get that, and you got to get your use of force expert to say that she used a taser improperly. And maybe you get the training officer to say, this is a specific training that we do, or whoever does the taser instructor, I should say. This is the specific training we do. Here are the things we say around firing into a vehicle. Here are the things we say about picking the location on the body that you tase if you have the option. And then that's it. There really are 3 critical witnesses other than the officers at the scene at the time of tasing. And I don't know when they're coming in.
Yeah. As defense counsel, this type of thing frustrates me with prosecutors, because I spend a lot of my practice in motions in limine trying to prevent the prosecution from delving into things that are not relevant to the ultimate question of, because I handle murder cases. Who killed this guy? Is my guy the guy who killed this guy? You know, and we don't do the spark of life thing in Maryland. We don't do that, but they try to put the family members on to testify, and the family members weren't there when the murder happened, so they don't know anything about it. So now you have to be the jerk that has to move to exclude the family member. You know what I'm saying? So it's just like, who saw the actual event? Let's look at the video of what happened. Now show me the experts. It should have taken them a day and a half, 2 days for testimony on the event itself. And now you need to hammer the experts. Now, by the time the jury gets to the experts, they're going to be exhausted. And that's not what you want.
And it makes you wonder why the state is taking this roundabout approach. If they feel they have legal merit, why are we burning whole days, entire days doing this?
They do it all the time, though. All the time. That's what I'm saying. I'm not, like I said, 2 different conclusions.
Sure.
But in my practice, in multiple jurisdictions, prosecutors do this type of stuff all the time. They don't look at the critical parts of their cases. Instead, they're like, look at all this good stuff that we have. This is a young guy. This is a police officer. It's really upsetting to watch a young guy die. Let's show you everything. Instead of like looking at what are my elements and what testimony is relevant to the evidence, to the elements. You know, it doesn't surprise me when prosecutors do this type of stuff, because and a lot of times they're allowed to get away with it. They're allowed to get into argument opening. That's why I like the judge, because she stopped them from doing that. But yeah, they love that extraneous stuff. Love it.
And it wouldn't be so bad when the facts are the other way around, if the state wasn't the one, raising every hissy fit in the world, because it's like, well, that's not relevant. It's like, wait a second, what side are you guys on,
Yeah. Well, it would also make a lot more sense in a whodunit. If I've got to prove the person did this, and I have to provide a lot of circumstantial evidence, because you don't have as much physical evidence. So you've got to show, this person was here. I actually did see this person at this scene, 10 minutes before, 5 minutes after, whatever it is. And you start building timelines, you start building logistics. That all makes a lot of sense. In this case, it's all on video. None of it's in dispute. Can we just, you lay the foundation for the videos and then move on?
I feel you there. So often when I'm in these situations and it feels like the answer is obvious, I just want to skip to the end of the page. It's like, do we really have to do all this preliminary stuff? Can't we just skip ahead? We all know the answers to all these questions. So let's just move on,
Yeah.
It also makes me wonder why Miss Potter did not opt for a bench trial.
She probably
Because
didn't have the privilege to do that. Can you? It's not always the defendant's choice. In most jurisdictions, the prosecution has a right to a jury too. So the
oh, is that right? Okay.
I'm not sure about Minnesota, but
I'll check the statute.
Yeah, I would love to
Yeah.
know, because this would be in Maryland in the Freddie Gray
right,
case,
absolutely.
all of the officers opted for bench trials, and because you can't appeal to the passions of a judge for the most part.
Right.
You can only, and they're going to be like, okay, move on. All right, I know that. Okay, so tell
Yeah.
me, show me.
So
the
in Gray, the first officer actually had a jury trial, but it hung. And then after that, every officer went for a bench trial, and he was going to be retried. He was going to go for a bench trial too on his retrial.
Yeah.
But yeah, obviously, and it drove Marilyn Mosby crazy, of course, because there was a lot of passion in that case, and you'd love to have a jury under those circumstances. But as you say, in Maryland, the defendant has an absolute right to demand a bench trial if they want it. But in most jurisdictions, that's not the case. In most
oh, sorry, I was going to say in Minnesota, you can waive on the issue of guilt. The defendant, with the approval of the court, may waive a jury trial on the issue of guilt, provided the defendant does so personally, in writing, or on the record in open court, after being advised by the court of the right to trial by jury, and after having had an opportunity to consult with counsel.
I don't understand. Isn't that just like true in general where you can plead guilty, or am I misunderstanding something?
Right.
No, you can waive your right to a trial by jury on the issue of guilt.
Okay, never mind.
Sorry, I didn't clearly state that.
No, but that doesn't really answer the question. Because, of course, a defendant can always waive his right to a jury, but a prosecutor may himself have a privilege to demand a jury.
Yeah, I'm not seeing.
So like in the Rittenhouse case, Rittenhouse could not have demanded a bench trial.
I'm not seeing.
He would have had to have the prosecutor's consent to have a bench trial.
Well, here, I'll pull it up. I'm not seeing that in the rule yet.
Okay.
As I'm reading it. So here, I'll pull it up for us. The live stream just ended, so that we must not be getting them coming back from the chambers. It didn't sound like they were going to need to make a record anyway. But so here we go. Offense is punishable by incarceration. A defendant has a right to a jury trial for any offense punishable by incarceration. All trials must be in district court.
Mm-hmm.
So the defendant has the right of waiver on the issue of guilt or the aggravated sentence. Let's see. I'm not seeing anything.
That's true in the federal system too, right? You need prosecutors' consent in the federal system too.
I don't know.
I
So
virtually every case I do is state level, so I don't know.
So yeah, I would assume that where it talks about the right to waiver, it would have a proviso that, like, you know, the state must also agree or something. It obviously, it makes total sense that if she doesn't have the option, but I don't know why she wouldn't have opted for a bench trial if she had the option to waive a jury.
I mean, it's just the simple. Well, I think when Kim Potter is your defendant, I think a jury trial is actually beneficial, mainly because the strategy for Kim appears to be from the defense that they're happy to put her on the stand. Mm-hmm. They're happy to raise her character as a good cop, as a good person. They did that in opening argument. I think they're very, very confident that she's going to be sympathetic to a jury, and that they will. And when you combine that with the video of her kind of mental breakdown after firing the shot, I think that the defense thinks that she has a very good chance of winning over at least one juror, or more likely significantly more jurors, and that putting her in front of a bench, you may get a ruling as a matter of law that that the pulling of a taser is sufficient to create that conscious disregard for recklessness.
Right.
If you get a judge getting close on that, then there's that. The other reason I would say that they want a jury trial is something I've been arguing this whole time. I think that had Kim Potter not yelled taser and intended to draw her gun, she has a good argument for a justifiable use of deadly force based on the danger to the other officers at the scene. And so that is a question of law as to whether that's preserved when she opts for less deadly force by choosing the taser. And so a judge might say, yeah, sorry, you can't legally claim that you had a right to use deadly force when you chose less lethal force, but a jury can make that decision without the judge, if that makes sense.
Yeah, that doesn't seem like that could be the right answer, but stranger things have happened in law.
Yeah, I don't know. I don't think I necessarily agree with that, but
you're free to disagree. I'll just remove you. It's fine.
Yeah, no. Get rid of me. I don't know what I'm talking about anyway.
I'm kidding.
No, this is, first of all, this is a very interesting legal case, just to be very clear here, because watching the opening, when they were playing that video, I was like, I don't know, man. Doesn't look like she meant to do it to me. But the question that I really genuinely don't think that she meant to do it. And I don't think that they're even saying that she did. They're saying that intent is not an issue here. It's about recklessness, right? That the mens rea is not intent. It's recklessness.
Well, yeah, but that's still, recklessness still has an intentional component. You have to be intentionally creating an unjustified risk.
Sure.
And then ignoring that risk.
But not intending to kill him.
Right, correct. Yep, right. Not intending the outcome that occurred.
Mm-hmm. So with that being the case, could their argument be that?
I mean, I think you stated it before. I think if they can show that her use, imagine she had actually pulled a taser, if that itself would have been unjustified, right? If she was violating a legal duty there, then you can argue, well, she's violating a legal duty. That can be that component. She's intentionally doing that in her head. That was her intent. It was an unjustified intent. It created this risk. It led to her drawing the gun. I guess that might be the legal argument. I mean, when I look at the facts, I don't see an obviously unjustified use of a taser under these circumstances. And maybe for very technical fact reasons, like maybe the car was in gear and maybe you're not supposed to do that. I don't know.
You saved me there just now. So that was what I'm thinking. What if it's not about an unjustified use of a taser? Or what if it's like, I feel like their argument is almost, and I feel like this is a weaker argument. It's almost like, okay, you tried to use your taser, but you didn't. How could you try to use your taser and reach on the side where your gun is? It's like basically like, we know that you made an accident, but like there's no room for accidents here. It's kind of almost what they're saying. Like, it's just like, you're trained that your taser is on this side. So there's like two separate arguments they're making. It's even if you meant to only pull your taser, it's not justified to use your taser. But
right,
then
that could be one. Yep.
You've had, and I think that's the stronger, more salient argument. But then you've had so much training. Here she is holding her taser on this day, this year, holding her taser. She's been trained this amount of times with her taser. She has the quick draw from one side and not the other, but yet she reached for her gun, right? And so, but we all know it's a mistake, but I guess that ultimately they're trying to argue that like, she's not allowed to make a mistake because of her level of training.
Right.
And
It's
that's the second argument for sure, but it's not a good one in my opinion.
Well, it's not. I mean, even very highly trained people make mistakes, and it's not necessarily criminally culpable. I mean, airline pilots make mistakes. It's
right.
These things happen unless they're intentionally creating an unjustified risk. It's not criminal recklessness. It's only negligence. It doesn't mean the person's not held accountable, but they may be held accountable in a civil context and not in a criminal context.
But they spent so much time on it. I guess it confuses me as to why they spent so much time on that. Sorry.
I mean, because I think it feels wrong to all of us, right? We have a 26-year police officer. It doesn't feel right that she would just make this kind of mistake.
Mm-hmm.
But what the law requires is that there be an intent to create an unjustified risk of death. And that's what I don't see here. And if you don't have that, I don't see the criminal culpability, unless you go to the alternative angle where it was the violation of some legal duty. Even the taser use itself would have been unlawful. Then I think you can get there, but it might be a hard sell on the facts of this case, given that, there was a struggle over a lawful arrest already in play, the danger of the car becoming a weapon itself. Can you convince the jury unanimously beyond a reasonable doubt that, especially when the other officers present are testifying, hey, if I had thought of it, I would have gone for my taser too?
You better hurry up and get to an expert then, because that's the only thing that's going to get you there. Hurry up and get to your experts to say that pulling a taser in this circumstance is not justified.
Yeah, and I'm sure the state will do that, but of course the defense is going to have their own expert, and
Sure.
they already have testimony from the other officer, at least Lucky, right, saying, "Hey, would if you'd been in her position, would you have gone to your taser?" He said, "Yes."
Well, they have the other officer even saying, you know, it's fine
You
that
could
you
have used
shot him.
deadly force. Yeah,
It's fine that you shot him. I was in the car.
right.
I was in the car, and he
And that
testified on
doesn't
this.
justify the shooting, but it does suggest that if deadly force would have been justified, then certainly an intent to use non-deadly force would have been justified.
Right. Natalie, the argument you were talking about the state maybe having, and I think I agree that might be their argument, is it's like a civil argument of the standard that they knew or should have known.
Should have known,
Yes,
right?
that's what I was trying to get to. I just couldn't find the words for it. Thank you.
Right.
But it doesn't really come up in criminal cases except for like something similar to like a strict liability possession type charge
Or negligent homicide. There's negligent homicide in some states. I don't think they have that here.
Yeah, no, and that's why she's charged with the it's like a negligent homicide, but that the second degree manslaughter, it encompasses culpable negligence, which is gross negligence plus recklessness.
Right.
And
I mean, when they
plus the
call it
reckless
what
disregard.
they call negligent homicide in the criminal context, if you look at the actual elements, it's still recklessness. They're using negligence as culpable negligence. It translates to recklessness. It still requires some intent to create an unjustified risk. It's like vehicular homicide. It's drunk driving or driving recklessly, or you're doing something intentional that creates the risk. Absent that, it's just a wrongful death suit.
And any vehicular homicide has recklessness almost not automatically built in. You still have to prove it by facts, but you are consciously operating a vehicle. So then the only thing you have to prove because some people have brought up, this idea of negligent vehicular homicides, but if you're operating a vehicle, you tend to be well aware of the risks. You're intentionally driving that car. So then all we have to show is, did you come to the level of disregarding the risk of driving the car? Like if you're driving the car, but turned around looking the other way, or if you're driving the car with a blindfold on, you're disregarding the risks of driving a vehicle.
Or you're drunk or you're speeding or
Right. And so that's the difference here, or the ultimate question, which we keep getting around to is her drawing of the taser at all a creation of the risky situation, or her attempted draw of the taser, but drawing a gun, does that create the risky scenario? Or does she have to know she has a gun in her hand specifically to create the risk of having the firearm? Does drawing any weapon create the risk, or does drawing the firearm and knowing you drew the firearm create the risk? And that, to me, is a legal question more than a fact question.
I mean, my own reading of Minnesota laws, she had to know she was drawing a gun. If she didn't know she was drawing a gun, it doesn't rise to that level. But the bottom line there is the judge should be making that call. The judge should be deciding, does this qualify as reckless conduct or not? Because the facts there are not in dispute. That's a legal question. That's not a fact question. We can't let the jury decide the law.
Yeah. So it's interesting. I mean, again, it's another day of they're belaboring a really interesting legal case. I want them to get me to the.
Why won't they talk about the things I want to talk about?
It's not what I want to talk about. It's what the court needs to talk about. Get me to the experts. Tell me about the training.
This is a battle of the experts case. And that's why I think it's in my opinion, it is too early for anyone to say how this case has come out, because we haven't heard any testimony on the relevant issue. Like if I'm so open-minded on this, especially based on that video, if the defense puts up an expert that's like from the police department, like how they had, kind of like the reverse of what they had with Chauvin. And it's just like, no, I've been on the police department for X amount of years. I've been doing all the training. And what she did was completely in conformity with our training. Or I'm some outside expert. I have all this training expertise, and vice versa for the prosecution. Just get to the point.
I felt like there were some unspoken adjectives in there.
Look, I will just I'll let you know on this channel, you are free to express yourself in any way you deem necessary.
Right.
So,
I mean, I think a case, a fact pattern that would fit that argument would be, he's being cooperative with the stop, or he's mouthing off, right? But he's doing his stuff. He's providing whatever they're asking for, but he's calling them names, right? He's being rude. And she pulls out her taser and says, "You better stop talking to me like that or I'm going to tase you."
Mm.
Clearly an unjustified use or threat of use of a taser there, right? That would be a clear violation of the standard practice of the training, the procedures, and a breach, I think, of the legal duty she would have as a police officer. But here I see it's so much closer a fact case because of the the violent resistance to lawful arrest and all the other stuff. Apparently he's trying to get back in the car to get away, and then it's a high speed flight in a motor vehicle, and that's dangerous to people too. And it doesn't seem to me like, and of course officers are not required to make perfect decisions, right? They're required to make reasonable decisions under the circumstances. Mistakes are permitted as long as they're reasonable mistakes. It's such on the facts of this case, it seems to me such a close call. It's hard for me to envision guilt beyond a reasonable doubt, as opposed to a case where just going for the taser itself was clearly inappropriate and impermissible, and she did something along those lines.
Well, so if you're the defense expert, the defense wants you to come up and say, we train on this all the time. We train on this a lot, because that's the issue that the prosecution's going to say. We train on taser use all the time. We know the dangers of an accidental draw. It's very clear. And you want the defense expert to come out and acknowledge, yes, we train on it all the time. The reason we train on it all the time is because it's a common mistake. It happens all the time. And in fact, it happens all the time to officers who train all the time. The fortunate thing is most of them don't end up pulling the trigger. Or most of them don't end up firing a fatal shot. But this is why this is such a common occurrence. It's and especially if you've got the training expert who's going to say, if you have an occupied hand when you've got your service hand, right? Her non-dominant hand is is to draw the taser. If you've got an occupied hand, the brain in a high stress situation will short circuit and just go for the other sidearm with the free hand. And that's what we've got here. She's got this, the piece of paper, which I believe is the or not the fake, but the expired insurance from Dante Wright. For whatever reason, she's got that in her hand. And so when she's like, I'm going to tase you. She goes to reach for her taser at that point. She's got a free hand and she just reflexively reaches. If you get an expert to talk about those sort of elements, then you made a compelling case that draw is something that happens frequently. And here are the conditions under which this draw would normally happen. This is what we try to train against because we know the danger, but that's part of carrying, a less lethal option, is that you have this risk that you might grab the lethal option.
Mm-hmm.
But yeah, I don't know. But until we get these guys up on stand to do that,
I think you need the experts. You need the experts. You need to hear what they're going to say. And my only criticism is they're taking too long to get there.
Yeah,
because all the other stuff is not relevant to that issue.
Right. And that's what we've been for 2 days now. The first day was fine.
The drown them in bullshit theory is getting a little tiresome.
Yeah.
And by their witness list, they have days more. I mean, they have days more witnesses stacked up if they want to call them. Good Lord. If
I'm the trial judge at this point, I'm just like, no, you can't call any more witnesses. That's over now.
Well,
you're not allowed.
Give me a prima facie showing of what this witness will testify to. Like, show me that this witness is justified before we call him up to the stand.
But again, just, where everyone's interested in this case because they're interested in this case. It's popular. It's taking the news. These are the types of things that are happening in criminal prosecutions every single day.
Yep.
But I think that I heard Nate say something like this, but this has really been my experience. The cumulative evidence objection is completely toothless, like in its enforcement in the criminal justice system. We defense attorneys object all the time to cumulative evidence that is just multiple people getting on the stand crying, saying the same thing over and over and over again, right? It's just the same stuff. It's very upsetting, and it's hammering this upsetting thing into the jury's head, but it's not telling them anything new. And judges will say, well, the prosecution is entitled to present their case, and you can always have the opportunity to rebut it and face them with cross-examination. And I'm going to warn the prosecution, you're getting a little close to the line, and then just let them keep calling witnesses. This happens to many people that are criminal defendants. So it's not anything unique to Kim Potter or even to Derek Chauvin, because there were lots of objections there to cumulative evidence, that the evidence is cumulative.
Well, I was saying that in the Rittenhouse case, in a similar way, a lot of people were frustrated with the tactics that the state were using, and a lot of people who might be politically minded on the right, but also, you know, having their kind of first exposure to a criminal trial in full, are saying, "Oh, this is going on, this is going on," and I'm saying, yes, this actually goes on in a lot of cases. You have prosecutors acting this way a lot of the time, and not just in these big political headline cases. They're doing it in the drug bust. They're doing this in the assault charges, the domestic assault charges. That's where we're seeing this sort of prosecutorial, in some cases, misconduct going unpunished and unchecked. And those people don't have the benefit of a public trial that is broadcast to a bunch of people. They don't have the benefit of close to $3 million of fundraising. They don't have a high profile attorney like Mark Richards and Sharafsi to defend them. And same thing with Kim Potter. I mean, the reason she's able to mount this defense is I don't know if the police union is paying. People are asking me if the police union is paying for her defense, but if they may be, but even if they weren't, Kim Potter, based on the sort of political environment that this is in, could have fundraised a significant amount of money to mount a defense like this, whereas your average defendant cannot. And this type of stuff, these same types of tactics, are happening in every courthouse across the nation on a pretty much a daily basis. So that's why I'm now like more and more convicted that we need more of what we're doing out there. We need more people doing it. We need more courts opening up. And people always lately have been bringing up, well, what about a kid testifying about trauma that they suffered? It's like, okay, yeah, courts can deal with one-offs. They can limit testimony of minors being broadcast, but let's get open courts. They're supposed to be transparent for a reason.
And yeah, I mean, the judge is doing that in this case.
Yeah.
With the autopsy photos, right? They're not going to broadcast the autopsy photos.
Right. Which is, I mean, you know, there are probably people out there who disagree with that decision, but ultimately, like, we don't necessarily need to see an autopsy photo.
I mean, they don't matter in this case. I mean, not for our purposes, right? It's
No.
I mean, yeah. Do we really need the medical experts? Like, what did he die of? I don't know, being shot.
They
Okay, great.
don't,
No more
they
questions.
don't matter in the trial itself.
Yeah, it's like
I mean, and again, some might be surprised to hear me of all people say this, but you have to understand I'm a criminal defense attorney. So my role would be to defend somebody like Kim Potter. Just, who cares what they do for a living? I defend people that have allegedly killed other people. Okay. That's what I do for a living. And unless the cause of death is an issue, or it's like, oh, he was shot in the back, and so we need to see exactly where he was shot. There are records that can explain to you what happened to the decedent. You do not need to see the decedent's body. It's highly inflammatory and many times prejudices the jury against the defendant unnecessarily. So but many times judges allow it in. So again, it's kind of getting to what you were saying. If you really look at it, criminal justice reform affects everyone. It doesn't matter what your political leanings are. You can be, you know, liberal, conservative, I don't know, whatever, in the middle, whatever. It affects everyone. So these types of trial strategy tactics come down to who your elected prosecutor is. It's very important to pay attention to who that person is, because they're going to dictate how their office is run.
Nobody knows who that is. In my experience, I mean, no normal person knows who their local prosecutor is.
Yeah, and it's so important. It's so important.
The reality is 99.999% of prosecutions are apolitical. I mean, that's the reality. I mean, if you believe like a Kim Potter prosecution is political, and I think there's political elements based on the timing, based on what's going on, and based on the result of, you know, you had the riots from George Floyd, and then you had the riots for Daunte Wright that lasted, I think, 2 to 3 days, and did some damage and had some fallout from it. So is this prosecution partly political? I think there's political elements to it. So if you think that Potter and Rittenhouse and I mean, some people might think the Arbery one was political. I don't think so much on that one. But if you have those political ones, those are the extreme fringes of the minority. The overwhelming amount of prosecutions have no political consideration at all. It's just, we have probable cause of X crime, and this person committing it. That's the prosecution.
And of course, a case could have a powerful political dynamic and still be completely meritorious on the prosecution, right? I mean, those two things can exist too.
Yeah,
that's very true.
I'm curious, Natalie, if you have an opinion on whether or not prosecutors should, as a matter of policy, decline particular categories of cases, not because of, resource reasons, but merely because of disagreement with the underlying law. An example might be, for example, simple possession. It's not whether or not let's assume they have the resources to do it, but they're going to decline to do it because, as a matter of policy, they think it's bad. Do you think that's a good thing for a prosecutor to do, or do you think that's a bad thing for a prosecutor to do?
Oh, I think it's great. I think it's great. And because I'm in the trenches of this.
Fair enough.
The criminal justice system is overrun with stupid cases where it's like, oh, well, it's decriminalized. It's going to be a fine anyway, but let's crowd this guy in the jail, and overflow our jail system, run up our taxes.
Stupid hurts.
It's very expensive. It's very costly. Let's assign them a public defender. Let's spend tax dollars on that. Now court costs for every single time they have to come to court for this stupid decriminalized possession case. Yes, I do. I absolutely do, because at the end of the day, nothing's good. The person's not, the society is not going to say, oh, put this person away forever and ever. And so you've literally prosecuted this person for nothing. You've prosecuted them for something that in other states people are profiting from. It's incongruous. It doesn't make any sense.
Yeah, well, maybe that's on the politicians to be less stupid, but I accept your answer either case. How are you doing, Legal Bites?
I'm doing well. I'm a little tired. I'm spent from this week, but I just sat down on the couch and Mr. Bites put on YouTube, and I saw that Nick was saying that we need more people doing stuff like this. I was like, all right, Nick, I'll come. I'll be there.
Yeah, get to work. What is this?
I'll show up for a little bit.
No, I just think, I think that the way, part of the argument about not broadcasting trials prior to this it's the logistics of it, right? It was expensive to have cameras in every courtroom because cameras needed to be operated and all of that stuff. They really don't anymore. I mean, and there are cameras in every single courtroom already that don't see the jury. I mean, in my small town, when I sit in a courtroom, there is a camera pointed directly at us. At me, at the prosecution table, and then there could be, I think there's a camera on the judge as well from the other side of the room, and so which would also have the witness stand. These things they're already there, and now we have networks that will distribute them. All you have to do is put the feed up, right? It is zero cost for a courtroom to have a feed going into that a YouTube channel could go and grab. It is effectively nothing. So put the broadcast
post-COVID,
and it also might lead to riches because, of course, Judith Scheinland, one of the reasons she became famous was by letting cameras in her family courtrooms. She's like, I loved one of her. I don't know if you ever saw the interview she did on 60 Minutes before she became.
Wait, is this
famous.
Judge Judy?
Yeah, that'd be the one.
Yeah. Okay.
Before she became famous, she had a 60 Minutes interview where it's like, this is the system people pay for, and we should let them see what's happening. And so, hey, it worked out great for her.
She's
of course she's now Justice Judy because reasons.
She's a family court judge. That makes so much more sense about how she rules on every case, which is to completely disregard the law.
25-year family court judge. Now you know.
Yeah.
She just does whatever she wants.
Yeah. You're stupid. I rule against you. Oh yeah. I've seen that in family court, not in my cases, but I've actually seen that waiting for my hearing. So yeah, now my whole life has just made so much more sense. Thank you, Kurt.
I mean, if anything, we're going to run into a problem of overabundance of televised courts, right? I mean, already I find I have to pick and choose the trials that I'm going to cover Like we had Arbery and we had Rittenhouse at the. Oh, not Arbery.
I'm offering my services as a YouTube
Arbery, yeah.
arbitrator.
It was
Right,
I'll
Arbery and
charge
Rittenhouse
$1,000 to arbitrate your case.
Yeah.
Judge on civil. It'll be great.
It would be that would be very entertaining just for the snark. I feel like that would be really good.
Lots of people have asked me to do that, to host like some sort of internet court show. And it's like, I mean, it's feasible to possibly do it. You'd have to get, there's some real questions about what would happen with those rulings, and they'd be subject to federal jurisdiction if in federal lawsuits for all of them. But it's possible. But no, so we had Rittenhouse and we had Arbery, and then we've had Duggar, Smollett, Ghislaine Maxwell, and Potter going on. And the reason that the choice was easy for me is this is the only one with a video feed.
Right.
But if you had video feed on
Maxwell,
on Smollett or Maxwell for sure. I mean,
Yeah.
I think
But
we would have had
there was so much drama coming out of that courtroom too that it seemed like that would have been such an
A lunging
entertaining one
judge.
to watch.
Yeah,
I want to
it
get a
would-
copy of the transcript. I called and asked. It's $4 a page.
Well, oh my
Ooh.
I'm like, that sounds like a price. Anyone want to chip in?
That's
for
a
copy of
Chicago
Juicy's-
price if
anyone
I've
want
ever
to chip
heard
in
one.
for Juicy's transcripts.
For you, my
'Cause I'm like,
friend.
for you must have been Swiss price.
Portion.
The
Yeah.
Very Chicago.
The question is, would we have had a lunging judge if there was a camera? Right? Because there'd be a check on it. His attorney says you lunged at me and hissed or whatever. The whole world sees no lunging, no hiss. That's a whole different story than maybe there was a lunge and a hiss. We have
Yeah.
no idea. We can only
Right.
suppose
the
based on
same-
what our trust of the defense counsel.
And the same thing too, like having Joe Neerman, good logic, go in and actually observe trial himself and then recount what he saw is very different than reading a transcript of some of these witnesses. And he's talked about the dramatic differences because it's like, you get a transcript that says that the witness said no, but then you have Joe coming out and saying that she screamed no. That's a completely different kind of response that you get just by being able to see it yourself as
And
opposed
it makes
to
such a
having
difference.
to read it.
Such a difference having actual lawyers watching this stuff and commenting on it. When you have journalists do it, no offense to journalists, but they generally don't know what they're seeing. They don't know what to look for. They don't know what's important. And they tend to just share some, whatever the common meme of the day is that looks like it's going to get clicks and headlines or whatever for their publication. They're not doing a legal analysis.
Well, there was, even if you just watch the headlines, I wonder if I can find them. Kim Potter trial. I saw headlines about Kim Potter's trial yesterday. Let me see if I can.
It doesn't seem to have been getting as much coverage as the other cases.
No.
Yesterday,
There's so much
Fox.
going on, but just nothing real. You said you saw something yesterday.
Well, here's a Fox News headline from yesterday. Kim Potter trial. Experts sound off on mistaking handgun for stun gun. Now, they're not talking about the trial. They're talking about them interviewing experts, but how that's worded makes it seem like experts testified about it.
Yeah, it does.
Let's see. Today, here's the Daily Mail just from an hour ago. Officer feared Kim Potter would harm herself after Daunte Wright shooting, court hears. Basically, it's true, but it's basically irrelevant to the issue at hand. Has nothing to do with what happened in court today, other than the fact that it did happen, that the Officer Johnson revealed that someone expressed concern for her. So he went and removed the rounds from the sidearm that he gave her. So that's another one from Insider 2 days ago. Daunte Wright.
But again, that's what gets the clicks, right? That's why the media writes about it, because it serves their purpose, but it has no legal relevance.
And it doesn't really hurt Kim either, because it's not like it's saying, "Oh, so she's guilty." It always makes you feel sorry for her.
Yeah.
So they don't care. All they
Right.
care about is what are the salacious, juicy details,
Yeah.
CNN yesterday. Daunte Wright's girlfriend tried to stop his bleeding with a belt as he gasped for air. She testified at ex-officer Kim Potter's manslaughter trial. That is just a salacious detail, right? That has no bearing on this case in any way.
Right. That detail is not relevant to any element that needs to be proved at trial.
Yeah.
But the jury heard it.
And
yeah,
the jury did hear it.
Yeah, and it kind of gives you like, juries, they get instructions on the law, right? But they're just people. And so that's why you have to be so careful with what you allow them to hear. They'll put aside the legal instructions if what they hear is salacious enough.
Yep.
Yep.
But the question will always be: is it salacious enough for the jury, and is it admitted? And that's the one thing that we don't have is we don't have the present impression of the jury. We don't have the ability to see what the jury is doing as this is happening, and that's probably for the best, is not having jurors be public during these, especially multi-day trials. You know.
Yeah.
Because people, I think, again, if you only watch them on TV, you don't realize that you can go into any of these courtrooms. You can actually sit there through voir dire and hear all the jurors' names in Minnesota on every other case. On every other case, you can do that, but only the high-profile cases do they protect it, because they're balancing the interest of this case with the identities of the jurors. But otherwise, jurors are public because they're protected in other ways. The media can't hound the jury for their opinion. They can ask one time. Well,
they can chase them down with their car and run through a stop sign, stoplight.
If the media persists in asking a juror for their opinion after the trial, the juror can bring that, and the media can be held in contempt, or the
Try to run them off the road because they want that interview so bad.
Yeah. Well, guys, I have a bunch of super chats to read. So I would invite all of you to stay if you want, but it's also Friday. And so I will invite you to not stay if you want as well. But if anybody wants to say anything, promote their channel, whatever it is, please take the opportunity to do so. I appreciate
for one,
all
happy
of you
that
being here.
Natalie, the lawyer chick, is part of the crew now. I hope to be seeing a lot more of her. I really enjoyed the discussion we did, whatever it was, 3 months ago or something.
Yeah, that was such a great discussion on civil law. I really enjoyed it. I really did.
So I'm happy to see you part of the community, one of us, and it'll be great. But for tonight, I'll do my own channel, I guess. For tonight at 8:00, I'm being joined by Legal Mindset to do the Texas abortion case with the Whole Women's Health, which just got sent back incidentally to allow for further proceedings. So there was a decision from that case, but we haven't done the oral argument yet. So
you're going to do the OYA audio?
We're going to do the OYA thing. We're going to do the Whole Women's Health versus whoever it was out of Texas, do the oral argument, and then we'll read the opines from the Supreme Court, and we'll try to pontificate about what it might mean for abortion as a whole as we read the tea leaves going into the Mississippi case. Should be fun. 8:00 Central. Join us on Uncivil
I
Law.
always love doing those on your channel, Kurt. Like those are especially so the first time that I did that on Kurt's channel was for the cheerleader First Amendment case, the Snapchat case, right?
BL versus Mahoney. Great case.
Yeah, that one was great. It was going so well all the way up until the rebuttal, when the I don't know what happened in the brain of this attorney, but she
her name was Lisa Black, I think.
Yeah, and she's apparently has a lot of experience in front of the Supreme Court. Very, very professional.
And she imploded.
And it was like a lot of words and sounds and not much punctuation, and it was very confusing. But it was very funny.
Yeah, it was a great moment in our channel history.
So you never know when something like that's going to happen.
Yeah.
Yeah.
So, but Natalie, it's nice to meet you over live stream.
So nice to finally see you face to face.
I know, not just through Twitter DMs. So yeah, I'm excited. I'm excited to have some, to have some collaboration with you too. So I know we've been chatting about that backstage a bit. So for me, I am basically looking at maybe doing some stuff next week. I'm also kind of going on vacation. I'm going to see some family starting this weekend. So I'm very excited about that, to celebrate some Christmas, since I'm overseas. I don't get to see family too often. So I might have a little bit less content on my channel, but I will have at the very least my usual latest in the law once a week. So you guys can come and check that out.
Imagine taking vacations from YouTube. How ridiculous.
Well, I mean, this is what I'm telling myself, and I'm realizing that my family's probably going to be like, "Hey, you live on the other side of the world. Why don't you spend some time with us?"
Like,
so
leave me alone. I've got a stream. That's me. That's me whenever I'm visiting my parents. I'm like, yeah, so where can I set up my streaming equipment? Because this train doesn't stop. I mean, come on.
Yeah, I mean, yeah, that may very well happen. So who knows? Who knows? Stay tuned.
Yes.
So I'm gonna sign off, I guess.
Yeah. Well, again, everybody's channels are in the description. Natalie is new. Make sure new to the channel, not nude. Natalie is new to the channel, and hopefully she'll be back a whole lot more. Probably not after that comment, but please go check out her channel. Check out her stuff. Legal analysis from a criminal defense attorney who is actively practicing on a rather frequent basis. And that's a good thing. We need people who are talking about this stuff with competency, and I very much value the input. So go watch some analysis, and give her channel a subscribe. Follow along.
Thank you so much. I'll just sign off here. Guys, thank you so much for having me. Thank you for inviting me and for leaving this open. I really appreciate that. That's so kind of you. And it was really, really nice to watch some of this Kim Potter trial with some awesome attorneys who are so smart. Oh my goodness, you guys are so smart. Thank you again so much. And everyone have a wonderful Friday and weekend.
Have a good one.
Natalie.
See you, Natalie.
Bye.
Hey, Nick, before you get to super chats, I'll just do a free book plug. It's a
Yeah,
real book,
absolutely.
folks. 200 some pages. You can get yours at lawofselfdefense.com/free book. Clever enough. And we only ask that you pay the cost of getting the book to you. If you come to Castle Rock, Colorado, I'll hand you the book. It won't cost you a penny. But if you want it mailed, we've got to cover the shipping and handling.
Yeah, Colorado's nice.
Yeah.
Well,
we definitely need to have we definitely need to figure out when we're doing a meetup. We
wait,
need to
did you
schedule
say
time and date? And yeah,
did you
April
say
or
Castle
something.
Rock?
Castle Rock.
Wait,
Like,
so you're
like the Supreme Court case.
You're in the worst. You're in the belly of the beast where the decision was made. I hate that case. I hate that case so much. I hate it. It makes me sad every time I think of it. It's one of the cases I don't like that Scalia wrote. And yeah, Castle Rock.
I wasn't here when that occurred or when the
No.
decision was made, but we've been here 4 or 5 years now.
Winnebago versus DeShawnee and Warren versus DC, or trifecta of sadness.
Yeah, Castle Rock versus Gonzalez, guys. I've done a full read through and breakdown of the case on the channel on a live stream. If you ever want to look it up and find out why police have no duty to protect you, even when the law and the protective order it's written on say that they absolutely do, they still don't.
Yeah, the law said shall, and the protective order said shall, and the Supreme Court said nope.
The protective order said shall in caps. In all caps. You got to do it.
By shall we mean may. By may we mean don't.
Shall expend. It's like all resources to affect this too. It was like, good Lord, what a frustrating one. Okay, did either Legal Bites or Kurt, did you want to say anything before I hit super chats?
No, I said my piece. What do you got going on your channel, Legal Bites?
So like I said, I've got latest in the law coming up next week. I might have some other stuff, possibly maybe something actually Christmas related, Christmas/free speech. How do you like that?
If I come out as transgender in the next week, do I get to join the panel?
So
yeah.
anyhow,
Perfect.
But yeah, that's pretty much it. I'm gonna try to balance Christmas vacation with still maintaining YouTube. So yay.
It's always
Pray
a
for that.
fun straddle, so to speak. Dusty Debt says, when I was training for deployment in Iraq in 2009, we were offered the experience to be taken. The way they lit up the troops was to have 2 soldiers sit down side by side, then intertwine arms and attach the probes to the outer boot of each soldier. Taken means tased. That way the arc would go across both bodies. So yeah, in our college campus security officers would they would link arms and they'd probe 3 people across and they'd probe one side of each and then just tase all 3 of them.
Nice.
It's great. What was there was another one over on Odyssey. Oh yeah. Svinstead says Odyssey chat is the best. Just a reminder, guys, you can watch every one of these episodes over on Odyssey. There are no mods. There are basically no rules in the chat.
Don't
so
tell them that. You're just going to encourage them.
Yes. But yeah, it is a great chat over there with all sorts of cruelty. So go over there sometime and have fun. Renal Ryan says, thank you, Legal Bites, for joining the stream. It's always nice to have a real lawyer on. Heart.
Well, you're very welcome. But there also are many other real lawyers that are on this stream, so which I'm very, very thankful for.
Never met one. Let's see. Murder Bit says, any publicly aired trials of interest post Potter? Don't know if they'll be publicly aired yet, but yes, several January trials that have potential, lots of public interest behind them. So we'll be looking at it. Someone mentioned one earlier in the show. I don't remember what it was, but it's the one with the zombies and the sex and all of that stuff and the murder. Do you know what I'm talking about?
No clue.
Zombies, sex, and murder. Can't say I.
It's been a headline in the past week. It's a woman and a man who are whatever. The woman's blonde. God, what the hell?
That's
is it called?
important.
Daybell and Val.
Oh yes, I've been doing Daybell a little bit. She's insane. She's facing charges in every state in the union. I think at this point, her lawyer's insane.
Yeah,
it's all great. It's all a nightmare.
I don't know anything about this.
That's going to trial next year. Chris Chan goes to trial in January. I don't know if that's going to be televised, but God, I hope it is. All right. Jim Fry says, for what it's worth, it may be informative for y'all to watch Wine and Chill's juicy case review. She would not read or display my super chat, pointing out the damage Juicy Smollett did to the cause. Netcat says, blue news tie for Blue Lives Matter. That's not a good idea. Run the Cushion says, Nick, it's pronounced Bubba Wallass. Ryan Keeler says, at what point do we see Alec Baldwin use the Dwight Schrute defense? Technically, nobody saw the bullet leave the gun. Restless Mom says, thank you from Orange County, California. Love all of you. I laugh so hard and get an education I will never get at my useless university. Thank you. Jim Fry says, right after the Juicy Smollett verdict came out, I was first to comment on next Sharpton tweet, may the graft be with you. SCFU says, neckties, fancy noose or tool of white supremacy. Ducky cries Belvin says, Nick or Andrew, can you tell me if Tim Pool has anything under that beanie? No, I can't. Jim Fry says, looking forward to the course, signed up the other day. That's to you, Andrew. British Gridiron Film says, search Marion Miller from Scotland about noose prosecution for transphobia. Same law count Dankula was convicted under. Thankfully, charge dropped.
Yeah, I've seen stuff like that coming out of the UK, and every time it does, it makes me cringe a little.
Yep. The fact that Dankula was found guilty makes it worse. Like it's crazy.
Yeah.
Daniel Erler says, I'm a bit new to the rules of woke Christmas, but would it be inappropriate to get a black Santa Claus ornament to hang from a tree? Yes. Why would you? Big Irish Jim says, for Andrew, is there a real risk of using a modified trigger for CCW, i.e. Glock minus connector plus NY1 trigger spring, similar weight, better reset?
Yeah, we kind of covered that earlier. Folks, just if you imagine for a moment that a prosecutor won't use against you everything that they can use against you, and by the way, they would argue the opposite side if it was in their favor in the next trial, anything that's anything out of the ordinary will be used against you. Or even if it is ordinary, it will be.
And I like what you said the other day. You said you're going to have a hard time convincing a jury that your modification is a more appropriate safety measure than what the manufacturer put on the gun in the first place.
For sure, any safety mechanisms on the gun, don't touch those. And there's no need to. There's so many good concealed carry guns with all different combinations of features. Just define what features are important to you and get the gun that has those and doesn't have the ones you don't like, and you're done. Don't be changing stuff.
Mark G says, where can I get a Ricada Law Glencairn whiskey glass? I don't know. The guy who wrote my outro, My Room Records, is the guy who sent it to me. He says, do you have any other merch? I do. I have a crappy Teespring store. You can find all of my garbage merchandise in the it's right under
That's
the
one way to
screen.
sell it.
Look, I'm not going to misrepresent it. I have some plans for other merch that is better, but for now, that's the merch that I have, and it's low on my priority list, but it's rising up because I know people want some stuff. I'm just bad at making merch. It takes time and skill.
No, it's super fast.
That's the
That's
skill
what
part.
Okay. All right.
Define
That's
Normalcy says City of Chicago has a civil case against Smollett for up to 3 times for the money on the mess.
That'd be nice.
The Man's Reality Podcast says the best way is not to talk to cops or the DA without a lawyer, regardless of the offense. True. Warren Lee says it's clear nature is racist trying to stop the trial. White snowstorm. I agree. Minnesota, one of the more racist states in the winter. Irie says Officer Johnson is Photo Chad's dad. He kind of looked like him. Darren Haviland says, does every witness nod their head yes after the judge says not to? Yes. Yes, they do. Nabor says, I wish he'd asked why he isn't bald like the others. Bitter Snuffleupagus says, move to strike this witness, Your Honor. His name is spelled M-Y-K-L and his non-Anglican version of Michael, Your Honor. Clumsy Clairvoyant says he looks like Chris Watts. Svinstead says, if you mix Ryan Reynolds and Mark Richards, this is what you get, referring to Officer Johnson. Pagan says he said duty. Alexander John says, how often do defense attorneys ask for mistrials?
If they're good all the time.
Yeah, every chance they get. Every chance that they think that there's even a modicum of opportunity to
Unless
get
you're Mark Richards.
Well, we did ask for 2 mistrials, Mr. Uncivil.
Yeah, you did.
We asked for the second one, which was kind of weird. Probably a bad choice.
No, Natalie explained why to me. Why they did it.
What'd she say?
Well, you should watch my interview with her, but no, I'm just kidding.
I didn't really buy her explanation, to be quite honest, but
No, she said so basically, so they made the second one because they wanted to ensure that there was some way of Judge Schrader deciding on a mistrial, because they weren't 100% confident that he would do it, that he would decide on that he would give them a mistrial with prejudice. So this was just one more option to give to Judge Schrader for to not send Kyle to jail, because even if they were going to appeal, that's going to take a long time, and he's still spending time in jail during that whole time. So that was one of their biggest concerns.
Did you ask her that she was amazed the prosecution didn't leap at it with like, thank you very much for this free gift?
Yeah, I mean, that was the big thing, is the risk.
Well, I don't know. That part actually I didn't have a chance to ask her that, but she basically, I mean, I asked her this though. I was like, does adding the motion for a mistrial without prejudice jeopardize the one with prejudice? And she said no. It's just adding another option, because they had already put their motion on the record. Judge Schrader knew that they had requested it. And he wasn't going to be making a decision on that before the jury came back anyway. They knew that. They knew that there was really no chance of convincing him otherwise. So this is just adding another way for them to at least have some kind of a mistrial, even if it wasn't perfect.
I'd mildly disagree that it didn't put the other one at jeopardy, because had Krause accepted the mistrial, that would have mooted the other motion. Yeah. So that, I mean, it doesn't, if they lose it, it doesn't put it in jeopardy. But if the DA would have taken the mistrial without prejudice, it's a do-over. I mean, at that point, a
do-over without the gun claim. So that really hamstrings what the prosecution can do with how they set up. I mean, that was like half of their case was this gun claim.
I'll make it work.
Yeah, it's it was an interesting choice. The Lorax says original flight gangsters, wink, #facts. Henry Dixon says Zulu time is used as a default time so that you don't have to manage time zones and daylight savings time. It's UTC +0, used in aviation frequently. Yeah, well, when we catapult an EMT from Minnesota across a time zone, then I'll accept it. Tall Skinny Geek says many corporate computer systems use UTC, Zulu time, when companies work in intertime zones, so that all the timestamps match. It also helps with daylight savings. Yes. Thank you for the Zulu time explanation. all of the body cams are not in Zulu time, just the one.
Now, the next question is, why did they call it Zulu? Where did that come from? I don't know the answer to that one, actually.
Yeah, I have no idea. Samuel Yoon says, at what point is this so cumulative that defense can agree to the facts and just move on? I'm sure the defense would love to stipulate to many of the facts, but that's just not, the stipulation's a two-way street. Nova, welcome to the channel. News Now Wyoming says, do you think the defense attorneys have spoke to Lucky and Johnson before to know their answers? They probably have interviewed them, I would assume. You can, as an attorney, interview any witness that you want. You cannot tell them how to testify. That's the distinction. Radio Run says, Alec Baldwin wasn't as upset about accidentally shooting someone as Kim Potter. Brandon Lesko says, Officer Johnson, would Dante Wright still be alive if Kimberly Potter had transitioned into a man? Tiffany Ann Marie says, I'm a stay-at-home wife and have accomplished jack shit around the house since I found your streams at the start of Kyle's trial. Thank you. Merry Christmas. Happy to help, Tiffany. News Now Wyoming says, Binger would say her crying here is fake. He did an interview this week I reviewed on my channel, and he again says Kyle was faking emotion on the stand. Oh, if you want to know what I'm covering probably tonight, it is the 1 hour Binger interview. The interview he said he would not give from the commentary.
No, there was an interview. I missed this completely.
Oh, yeah.
Someone sent it to me yesterday.
Where was this interview?
If you guys are interested, I might be interested in having a lawyer panel EFAP tonight at
what time is that?
It'd be 11 p.m. Central.
Oh, dear Lord.
Yeah, but it's Friday.
It's actually pretty good for me.
It's Friday. It's Friday. That's only 10 p.m. your time.
That's I'm a little older than you guys.
You were up with me till like 4 the other night.
I wasn't wearing a tie. That's the difference. When the tie comes off.
Well, no one said you have to wear a tie.
All right. Well, listen, I would be interested, at least in starting with you. I could probably stay for an hour or so. But if you decide to do that, let me know.
I'll send it in the chat.
Okay.
I think that's my plan.
I might if I leave nowish, I might be able to, but it depends. I've got to get ready for this trip. I don't know. Maybe I might drop in. Drop in.
Let's see. Captain Cook says defense is presenting a hell of a case. Nancy Duggan says, I forgot to feed my dogs because of your stream. You need to apologize. Frag Out Design Studios says, really wish folks could understand what is happening. This is a normal reaction, cop or not. Look up buck fever. If she didn't react, I'd be suspicious. I think that's to Potter's reaction to shooting someone. Z. Michael Gelke says it's not a coincidence at all. An experienced officer would have taken him behind the car, kicked his feet wide while bending him over, and this wouldn't have happened. Yeah, the officer should have closed the door. I think that was one of the things we said. The arresting officer, who is not Kim Potter, and unfortunately, what he does isn't really, that has no impact on what she had to do as a result of that. I mean, it's kind of some level of cause, but she's not liable for his actions. She's only liable for the actions she takes in response to his. A penny for your podcast said, started watching Natalie's videos a few months ago. Great addition to the watch party. A dude in the basement says, cop knows you don't talk to cops. Greg McCormick says, Biden is asleep at Bob Dole's funeral. Eyes closed, nap time, shameful. Mandalore Wise says, damn, Potter's obviously in shock / delirious in the video. Sergeant clearing his gun if read later. Rogue 51 says, whenever video evidence is presented at trial, there should be a requirement that it be shown in full and without interruption. Maybe. Zechariah Kitzman says, what is the relevance about his firearm? Well, he took her firearm to preserve it for evidence. He gave her his firearm, which I don't know if that's policy, but that's kind of weird. If it's not policy, that's weird to me, but I think it's just in case something happens and she needs to draw a firearm or whatever, she's got one. But then he disarmed he took out the rounds from his firearm eventually when there were questions of self-harm. First Last says, no, the state is going to argue that he wasn't able to put it in gear because he was being held until she yelled taser. Black Tiger says, can they be trying to show that her actions caused the officer to put the car into gear when she warned about the taser, as in he had the gear shift and put into gear as a result of the confusion? They could try to show that, but the video doesn't show it, so I don't know how good that would be. Ryan Clark says, is there any possibility that the passenger put the car in gear? Well, to put a car in gear from park, you have to hit the brake. So it would have to be a team effort at that point. So in theory, yes, she could have put the car in gear as he was stomping on the brake and then subsequently stomping on the gas. Jeff says, watch the dash cam video. Brake lights off in park until he gets back in the car. Reverse lights come on before he takes off. News Now Wyoming says, just rewatch Johnson's body cam before the shot. It was in park at the time of the shot. Yes. Jimmy the agent, or Jimmy the gent.
But the reverse lights came on?
Because you have to shift past reverse from park to drive.
Yeah, so he was in the process of trying to shift gears. So yeah.
That's what they're saying, is that after the shot, right before he takes off, it shifts from park to drive, and you can tell the moment that he shifts. That's all they're saying.
So that would mean that it wasn't just some neuro impulse from the.
Yeah, that's not going to happen.
Yeah, the reason there's a guy. The context of this discussion is there was a guy in the chat arguing that it was in dispute whether or not the car was in park at the time of the shooting. Because if the car is in drive at the time of the shooting,
potentially.
And she's got the taser, or even if the gun is potentially reckless.
Yeah.
But if it's in park, he's not actually driving the vehicle, so he can't have that neural response, which would perhaps make him unable to take his foot off a pedal.
Right.
Yeah. So that's the chat is just responding to the guy in the chat.
I mean, the fact that he's trying to go through gear and is helpful, but I'm not sure even if that wasn't true, that we can't get to where she needs to be, because he's in the process of doing that. Like even if you assume he is in park and he hasn't completed that process yet, I don't think you can get to, well, I can't tase him at this point, because he's going to shift like a tenth of a second from now. So yeah. I don't think it makes a difference in my mind.
I would argue even if it was in drive when she tased him, it doesn't. I don't think it makes any difference. I mean, you have a general policy against that, but if the risk, the danger that you're going to incur exists regardless of whether you tase him, this guy's going to flee the scene at high speed. You have that danger anyway. Plus, at that moment, you have two cops hanging outside the car.
Yep.
Under that circumstance, I would argue that taser, generally you don't want to do it when someone's operating a vehicle, but there are circumstances where it's justified, and this would be one of those.
Seems like it to me.
Well, we learned from the prosecution's pseudo testimony the other day that if he were to drive off, they would be able to pursue him at reasonable speeds. That because he would just go the speed limit,
and he'll drive at reasonable speeds and in a reasonable way, I'm sure.
Yep, that's what I do when fleeing the police, is I drive the speed limit and respect traffic signals.
I mean, there have been some pretty interesting low speed pursuits, so it does happen.
Jimmy the Gent 1977 says, why didn't the officers have Mr. Wright turn off his vehicle at the beginning of the traffic stop? Isn't that standard procedure? No. I've never been, sorry. I've had a few traffic stops in my day, and I've never been asked to turn off my vehicle unless I'm asked to leave my vehicle.
I always do. I don't think I've ever been asked, but by the time the cop gets up to my windows, my car keys are on the dash in front of me, because I don't want him to be worried that I might be thinking about taking off.
And I've never even thought about it that way. I've been pulled over for speeding several times, and I just, I put the car in park and hands up, and that's it. But it's certainly not standard procedure to have someone do it. Not in Minnesota anyway. Britt Cormier. Yeah. The only time I had to turn my car off, a cop has brought me to his car twice. It was both speeding charges. The one, he wanted to show me that he had to drive 130 miles an hour to catch up to me, because I was going like.
I have a good story I have to tell you sometime about one time when I was stopped by the police officer as I was. It's a good story, actually.
Yeah.
I don't want to tell it on air. It's so embarrassing, though.
So I passed a cop going 85 and a 70. Is what he clocked me at. I was doing like 98. I was driving through Kansas, and
I may have been on the interstate, I may have been on foot, and I may have been carrying at the time. But this is part of the story.
But yeah, so the cop pulls me over. Like, I've got my wife and kid in the car, and he's like, "I just wanted to bring you back while I ran your stuff." And we had a nice conversation. He didn't give me a ticket. But yeah, when he said I had to drive 130 to catch up to you, I was like, well, now you're just showing off. That must have been fun. And then the other time I was in college, and they pulled me and my friend over for no reason, except that there were a lot of parties that night, and he brought me back to the cop car to run my license. And I think he was just trying to see if I'd been drinking. And at the time, I didn't actually even drink. I did not consume alcohol at all at that time in my life. So I was just in there with him. So it was weird. Britt Cormeyer says, if you look at the patrol's dash cam, you'll see it was not in gear. You see the reverse lights come on as the gear shift goes park to drive before he takes off. S. Asp says, Timothy Engel was a friend of mine and partner. His problem was being too forthcoming with the police before asking for a lawyer. Wait, is that Engel is that the case that you're talking about? Andrew, you were talking about Engel, right?
Engel. Oh, the decision, the security guard who had the gun in hand when he was struggling with someone. Yeah, I mean, I don't have any real familiarity with the case other than having read the Supreme Court decision.
Well, S. Asp in the chat says Engel was his friend and partner. So kind of neat.
Well, I mean, it could have gone worse. The gun discharged and he paralyzed that guy. And I think they got him with just like, I don't know, some reckless gun handling charge.
Prairie Dog 57, thank you for the donation. Shayakita says, greetings from an even colder place than Minnesota, but with less snow. Just had some nice Talisker yesterday, but vodka is my groove. Rip zombie Kurt. S. Asp says, Engel didn't read Bronca's book and made himself easy to convict. Big Irish Jim says, if Kyle Kareth was interfering with a custodial arrangement, is that a crime that negates his claim to self-defense? No. No, it does not. That would not be the negating factor. If Kyle Kareth's crime is, if his self-defense claim is negated, it's because of what Andrew says. It's because he was unreasonable at the time he pulled the trigger, that he was no longer in danger. That's the big thing. Just for reference, I covered this the other night. There have been 2 civil suits, one from his widow, from Chad Reed's widow, and one from Chad Reed's mother. Neither of them alleged that was the pickup agreement, and neither of them alleged that he was actually interfering with the custodial agreement at the time. Those are things that you would want to include in the facts section. The closest that we get is that the ex-wife had a pattern of not producing the child at the time of the pickup. But the evidence seems to indicate that was not the pickup location, nor the pickup time, that he went there to go looking for his kid, which is a lot of people had said, oh, he had a right to be there to pick up his kid because that was the place. That is not in either of the civil suits, does not appear to be a fact in this case. B.A. Krim says, how does the jury not hear the conversation of the sidebar when they're in the same room? They're that far away. Yeah, and they're talking quietly into the microphones, the headsets that are probably very sensitive, is my guess. Scott Allred says, why is it that defense attorneys seem to always be the ones trying to behave properly when it's the state's burden to prove guilt? Oh, there are plenty of improper defense attorneys. Yeah. However, you get a little bit of leeway because your client has all the rights. So you get to, I mean, you can't act unethically, but you get I would say there's a little bit of deference to defense attorneys.
And we're not seeing a normal cross-section of cases here. I mean, these are very unusual cases on lots of dimensions, especially the ones brought where there's appears to be very little legal merit on the part of the prosecution. They have to overreach to try to get anything done. Normally, that's not the case.
Lamb Chop has an answer to the Zulu question. Letter suffixes for nautical standard time zones. Nautical standard time zones, Z was the 0 zone. So Z would be Zulu in the
phonetic alphabet.
Right. A to M to the east, N to Y to the west. So there we go. Thank you for that. Very cool. Roger Stone says Earl Grey sounds kind of like Matt Foley. Charlie says, you guys got some nice commentary, but I really appreciate Andrew when he's on. The guy sounds educated to the teeth. Any life tips for an Aussie?
Life tips?
Life tips for an Australian.
No. If you knew my life,
Australia?
you would not be asking that question. I give use of force law tips, but I don't know anything about Australian use of force law.
I'm with Uncivil. Learn to swim and avoid the jellyfish and swim as far away as possible. SN Pagey, welcome to lawyer status. Ducky Chris Belvin says, Nick and Andrew, does Tim Pool have hair? I think he has some. Let's see. Beaker Spawn Tech says, I've noticed when the state has bad facts and sympathetic witnesses, they tend to drone on and on with bad facts. Is this a bad tactic, boring the jury? I mean,
What else are they going to spend their time doing? I mean,
I legitimately think in a case like this, where you've got one question that needs to be answered and you keep bringing person after person after person, it's to convince the jury that there's more to the case than there is.
Right.
I mean, and it'll be the defense's job to say, this is, we've heard testimony for days and days and days. All of this boils down to one simple question. At the time she pulled the trigger, was it okay to pull the trigger? That's it. That's all you have to answer. Here's the legal standards about it. You don't have to worry about the accident afterward. You don't have to worry about all this nonsense, officer after officer testifying. You've seen endless video, not much video about the incident. Why don't they want to show you that? I don't know. Zachariah Kitzman says, question, can't the defense argue the statement taser, taser, taser removes reckless from the other officers because it's a warning to get out of the way? You can argue whatever you want. Sure. Blaine 20 says, just the chat. Fisk the Lomback says, wouldn't the brake pedal have to be depressed to shift out of park, then release, then the gas pressed? Yes. The Sherry 1955, welcome to paralegal status. Chris Friday says, recross so hollow points are government issued. Yeah, they should have, I think they should have just stated that on recross. Do you have an option? Maybe to law enforcement out there, do you even have an option with what round to load your gun when you're on duty? I figure hollow points are just, that was the issued round, but maybe I'm wrong on that.
That was my impression.
It varies a little bit from, so there are some departments, very small departments, where officers, for example, are expected to purchase their own service pistols, where they may have some discretion in the use of what ammo they put into the gun. But in any, post-certified environment like we have here, the officers will be told, this is your service pistol, this is the ammo you carry, this is the belt, this is the holster. That's it.
Yeah.
And if there's some exceptional reason why you need something different, then you'd have to argue that with your department and justify it and document it and get accredited in the use of that different equipment and so forth.
Adrian Wright in the chat says, according to Nick and his cronies, the case is over. She's innocent. No, that's actually not what any of us have said. We are waiting for the case to start on the main issue here. I'm willing to be convinced that she was reckless. I don't see it. I need the state to show me where her recklessness lies. And they're not going to do it by showing me officers testifying about an accident that happened a block and a half away from the shooting. You're going to have to get me an expert to say this use of the taser was wrong. You're going to have to get me an expert to say that or her use of the taser would have been wrong. An expert to say that, no, she's been sufficiently trained to know the difference between a taser and a gun. And when she picked up that gun, the feel of the gun or whatever was significantly different from the taser, that she would have known. And that her profession that this was a taser was a pretext to shooting the guy or whatever it is. You're going to have to show me that. And the state isn't doing it. That's the problem we've got.
Yeah, I get that a lot when I comment on these cases. It's like, well, Andrew supports this person or that person in the case. Folks, these are not like my friends or family. It doesn't mean anything personally to me if they get convicted or acquitted. I'm just, as a lawyer, I'm looking, I know the state has to prove guilt beyond a reasonable doubt. The crime charged has certain specific elements. I'm looking for the state to, not necessarily prove that the first witness, but advance that argument over the course of their case in chief. And when I don't see that, when instead I see a lot of emoting and a lot of days of irrelevant testimony, I begin to wonder, why are they not actually advancing their legal argument? Why are they doing all this other stuff? Is it because they don't have a legal argument?
Mm-hmm.
So,
yeah. Well, and you and I on opposite ends of the issue have each gotten that feedback on Kareth and Reed, right? Like, it's like we care what happens to Kyle Kareth. It's irrelevant to me. I don't think his case is some massive statement on Second Amendment rights or self-defense or anything like that. It would likely hold no precedental value in any way. It's just this is how we see the facts and law at the time. And if they change, please show me the change. Like if Kyle Kareth is this awful guy, and I think he's got some problems with his behavior, but if he's an awful guy who deserves to go to prison, put him in prison. He killed a guy. So if that killing is unjustified, then I don't want him out of prison. If the killing is justified, I do. That's it. That's all I care about.
Right.
Let's see. The Hot Dog Wizard says, why did they not charge Dante Wright for resisting arrest and all the other crimes that he did while fleeing? Well, because he's dead. He's dead, Jim. Do you get away with crimes by being dead? Oh, yes.
Yeah.
You do. You cannot be adjudged guilty after deceased.
It's the ultimate jeopardy.
I can speak to this. I had a client who had pled guilty, but pre-sentencing ended up taking his own life. And it was, I don't think it was related to his guilty verdict specifically. And his sentence was likely to be at most 4 days in jail or something like that.
Oh, no.
But, and served at his own, like on weekends at his own leisure. It was very, and because it was a drug possession charge. So he was going to have it automatically sealed by the state and not be a felony that remains on his record once his probation was over. So a year later, it was going to go away. So it was actually, not a huge deal, but he did end up taking his life between those. Yeah, it was really rough between those hearings. And so I had to file his death certificate notice from the newspaper to the court and get the charges dropped. To inform the court that there was no longer a need for the trial. And so he had actually pled guilty, but it actually vacated the judgment in a weird way. Cause I guess he still had rights he could have exercised. So yes, you do get away with crimes by being dead. Brian Miller says, I'm hearing Binger questions. Q Revere says, agreed with law of self-defense. Decision to risk leaning shows significant threat perceived. So that's when you were talking about Officer Johnson risking leaning on the girl in the car, I think.
Yeah.
You said, can you expand on why you said that was a risky move?
Well, you don't know how hostile or aggressive. I mean, we've seen her testify, so she looks completely harmless. But in the moment, you don't know if you're going to get stabbed in the back and cut because she's protecting her boyfriend from a life sentence. Maybe they got 100 kilos of cocaine in the trunk of the car. I mean, who knows?
Yeah.
You're in a completely exposed. If she wants to be violent and is determined to do that, and has even, a 2-inch blade at hand, you're in a lot of trouble in that position.
Yeah. Well, and from looking at her on the stand, that girl was rail thin. I mean, I would be surprised if she was over 110 pounds.
And maybe Johnson made that assessment. The moment he opened up the door, saw her, just assessed her as not threat. That could be. I mean, you'd have to ask him.
But what I'm saying is, from the body cam footage that we saw in the short amount of time, when I first saw her, she did not, when she took the stand, I did not know that was the girlfriend, because from the body cam footage, she does not look tiny like she looked on the stand. And at the accident, when she comes out, she is wearing kind of a baggier sweatshirt and stuff like that. So he may not have known that she was little at all. And like you said, you never know if someone's got a knife.
Right. Hey, little people kill people too.
Yes. Well, Rosenbaum tried.
Yeah.
I knew it. I knew that was coming. I'm like in my head, 3, 2, 1.
We are the Munchkin Guild chasing Kyle Rittenhouse. Eagle Eye, welcome to Lawyer Status. I will get you and take your
don't
gun.
do that tonight, please. Jesus.
Razor 390 says, when playing Call of Duty Warzone, do you get into cars of fleeing opposing team members? Major? Yes. Rob Huddleston says, prosecution is trying to say they were getting control until she said taser. When she said taser, the other cops let go and put the car into gear. And he put the car into gear. Yeah, I mean, but again, her saying taser is not a negligent homicide act. That's not
it needs to be a reasonably foreseeable risk, not just any theoretical risk that in hindsight happened. She would have to, when she says taser, 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 she knows that's going to lead to the series of consequences of them releasing him and him putting the car in gear and stepping on the gas. I think that's a stretch.
Eagle Eye says if you go back to the dash cam and the body cam from earlier, it clearly shows the car starting and being shifted to drive. John Pfeiffer, welcome to Paralegal. Jonathan Duger says Earl Grey is teabagging the hell out of the prosecution. DCV Titan says, do you think the prosecution will jump on Potter for saying I made the same mistake again before saying she shot right? Did she say again? I made the same mistake again?
I don't remember hearing that.
I don't remember hearing that either.
I just remember her saying I grabbed the wrong effing gun. But
Yeah.
if she said I made the same mistake again, maybe.
I think people are hearing gun and interpreting it as again.
Yeah, that might be it. But because from the record we have, she's never drawn her firearm. She's never even drawn her never discharged her firearm or taser in the line of duty. She may have drawn them, but she's never discharged them. So Rob says, does the state know they don't have a case, or are they that disillusioned? They're trying to make a case. They're trying to use a novel argument. Well, perhaps a novel argument about negligence law to raise a criminal liability. Arball says, I'm sitting at an airport in North Dakota and my flight to Minneapolis got canceled. RIP. Thomas Cosenza says, when are we going to find out if the officer plays Grand Theft Auto? Patrick Allen says, since he entered the car against training, does that make him liable since he created the dangerous situation that escalated Potter's response? I don't think he said he wasn't trained.
He didn't say it was against training. He says training doesn't cover that.
Yeah, he said that we're not
Two different
trained,
things.
not trained on entering the vehicle.
Right.
Where is it? YouTube just updated the super chat scroll bar.
Oh, I hate that.
Yep. I'm getting there. Come on. Where is it?
Here's a question from somebody asking, what would have happened to Rittenhouse had he been in a state with harder to prove self-defense laws? Most states have essentially the same self-defense laws, folks. They don't vary much, except for whether or not it's a state that imposes a legal duty to retreat. There's only 11 of those. Most of the self-defense law in the U.S. is pretty consistent from state to state. How it's applied by prosecutors and their judgment and discretion can vary tremendously, but the black letter law is pretty similar.
Well, the Rittenhouse had such a strong case because he also retreated, even in the absence of duty.
Yeah.
You have to remember that the first shots against Rosenbaum are while he's still moving backwards and he had been running away for a significant time. The other shots, he had been running away, fell down, was no longer would easily be, I shouldn't say easily, but would reasonably be considered unable to further retreat at the time you fall. So,
I mean, even the duty to retreat states, it's only a duty if you can do so consistent with safety. If it's impossible because you've been knocked down or it would increase your jeopardy, you don't have the legal duty.
Yeah, I think in Minnesota the term is if your back is against a wall, and the Minnesota Supreme Court says if you're on the ground, your back is against a wall. That's just how it goes. Pancake Turd says, I wasn't simping for the judge until she giggled and played with her hair after Earl asked about leaving early. # spit on me, mommy judge.
Oh, no.
Good God. Susan Swenson, welcome to Super Lawyer status. Thank you. Happy to have you. Gunner says, I do not take Imperial credits, only giggles. Joseph Baca says, watching your streams has opened my eyes to how slimy and vindictive prosecutors are. They think and act as if the rules don't apply to them. Some prosecutors.
Not all of them.
These are highly selective, politically charged cases that are high profile. You have a lot of motivation for prosecutors to be bad actors based on the circumstances. Most prosecutions are apolitical. Most prosecutions are just they have probable cause and their job is to bring charges when they do. That's it.
Keep in mind that there's a reason why Emily D. Baker was so upset at Ettinger and Krause, because she felt that they were misrepresenting prosecutors across the country and misrepresenting her time as a prosecutor before.
Yep. And same with Nate the lawyer.
Yes.
These are people who each of them spent significant time as prosecutors, and each of them had a lot of problems with how things were being done in that case, and have expressed some problems with how things are being done in this case too. News Now Wyoming says Binger did an interview on the Miranda Rights podcast on Spotify, the New York Bar Association. You should check it out on stream tonight, full of BS. Yes, that's what is the plan. Mr. Archer says, according to the prosecution, the defense's challenging cause of death, it was the arguments at the end of the day yesterday. It is apparently not agreed. I did not hear that in the arguments yesterday.
No, again, the state, in arguing against this motion for a mistrial, request for a mistrial, the state was saying, we've heard the defense in chambers argue the issue of cause of death. But I've not heard the defense argue that, and I would be cautious about relying on the state's representation of what the defense is saying in chambers.
Yes, and I think if you're going to go with what they said, what you can probably safely infer is not whether the cause of death was the bullet, but rather the cause of death was Kim Potter's actions or Dante Wright's actions. Basically, not quite contributory negligence, but that Dante Wright created the situation that led to his death, not Kim Potter.
They certainly said that, right? If only
Yeah.
he had complied, if only he'd allowed himself to be arrested, there would have been no use of force.
Yeah. So a couple follow-ups from the same person on the same issue says, check out the arguments again at the end of yesterday. Prosecution claimed the defense is challenging cause of death and had to present it to judge. Prosecution claimed during final arguments that the defense is challenging cause of death. Maybe this is why the focus on ammo/car. No, I don't think that anybody is challenging the specific cause of death being, I mean, the prosecution has to prove that the cause of death is the bullet fired by Kim Potter or some other cause. But I don't think that that's an issue that they're fighting against at this point. Mandalore Wise says, how many of these Binger prosecutors do we need before we have all prosecutors are idiots as a stereotype? JK the Slagger says, everything in that taser manual that's not how I shot taser is all CYA. Shields them from liability for deaths from the taser not working, etc. Bogey says, the man who attempted to murder my sister was found guilty today on all counts. Have some cash in celebration of the justice system working. Oh, good news, Bogey. I'm glad to hear justice was done there. I'm glad your sister, that was an attempt and not success. Hiker John says, if the car was in gear the whole time, then why was it not moving the whole time? Correct. Fusion Evo says, but the car took off because he let go of the shifter. Freedom Fighter says, Instagram already disabled Kyle's Instagram. So that's Instagram for you. BMAX says, my experience on the streets of Minnesota is that tasers are useless 8 months of the year. I would never deploy taser without a cover officer due to fail rate.
And by the way, that's why I know Taser sells devices for civilian use. I have never been comfortable recommending them. In fact, I recommend against them because as a civilian, you're unlikely to have a second person standing next to you with a gun to back up that taser when it doesn't work. And they don't work a high percentage of the time, folks.
Well, and police officers, tasers they're testing and maintaining their equipment, if not daily, then weekly. And likely you are not testing and maintaining your taser for functionality daily or weekly as a civilian. You're likely letting it sit. I mean, you might throw it on the charger or whatever, and then you throw it in your purse or belt or whatever you're doing, but you're not testing the actual functionality. You're not doing spark tests. You're not, and if you do a spark test and it fails, do you even know? These are some other issues that you've got.
I mean, when they're perfectly maintained, they don't work a high percentage of the time. And then if you've got inadequate maintenance, it's only worse.
Nitro Arm says the ECM onboard computer can tell you if the car was in gear or not. The car being in gear, again, this is not a fact in dispute at this point. The prosecution isn't even making the claim that the car was in gear. It was just the one guy in chat. The one guy in chat trying for any argument to find that Kim Potter is guilty. The person has determined Kim Potter guilty for the past several days and have been throwing out inane arguments. I just chose to engage it because I thought it'd be funny. Now I regret it. Patrick Todd says, are you going to cover the Daniel Perry self-defense shooting in Austin? He's the guy who shot the BLM protester who pointed an AK at him. I would cover it. I had not heard of it. So that's interesting. Gunner says, imagine giving cops tranquilizer guns, but they will have you step on a scale thrown like a ghost trap so that they can get the correct tranquilizer dose. Ronan Medic says, Bronca, I spent a lot of my 20s and 30s working as executive and diplomatic close protection overseas. Am I justified in my terror that a DA will jump all over that if I have to use deadly force?
A DA will use anything he thinks will be helpful to his argument. So there's nothing you can do about it. I mean, that's your experience.
Natalie Lawyer Chick responded. She wasn't on stream at the time, but she answered about her defense-friendly comment about the judge. She said, lol, the judge is defense-friendly compared to some that I've dealt with, and she clearly likes one of those defense attorneys more than the others. Judge is simping for Earl. Nathan Hewitt says, Nick and Andrew, do you think Judge Wu carries a judge? I think is it a Taurus judge?
Taurus judge. I would hope not.
Yeah, I heard they're actually terrible for self-defense.
Taurus are not of the highest quality.
They're funny though, because they shoot the shotgun round. Like, that's comedic.
It's a gimmick gun. I mean, if people have them and love them, that's fine. It's awesome. More power to you. I'm a Second Amendment absolutist. If you're thinking about using one for personal protection, I think there's better options out there.
You would you carry a breech loading 50 caliber pistol with 50 caliber BMG pistol?
Have you fired a 50 caliber BMG?
No.
All right. When you do, you have. That's in a full length rifle.
One of my viewers has a breech loading 50 caliber BMG pistol.
That's insane.
Yeah,
that's insane. It's hard.
He is insane. I mean, so that's true.
I will say Smith & Wesson has a 500 caliber, a 50 caliber revolver that they came out with some years ago.
Ooh.
And it's surprisingly pleasant to shoot because it's so big and heavy that the mass absorbs much of the recoil. But because it's so big and heavy, it would be very inconvenient to try to carry.
Well, that's kind of what I like about my 1911 versus my wife has a SIG P238, which is a little 380.
Yeah,
but
very small. Yeah.
It weighs like 1/5 of my of the 1911, and so even though it's a 380 versus a 45, it kicks a lot more than the 45 does.
Well, my wife has the Glock version of that 380. And it's better. They make the same size gun in a 9, and that's a really unpleasant gun to shoot. But she likes a 380 a lot. I mean, really, it's a face gun, right? So
shoot him in the face. Is that what you're saying? Yeah. My wife is she's petite. She's like 5'2", small hands. It fits nice in her hand, but it does kick a little bit. JMD Reed says, great to see Natalie here. She has some great content. Garrett says, I don't know why, but YouTube gave me this free super chat. Hope it gives you some of its original value. Make law of self-defense say some bad words. It's comedy gold. Sport Nugget says, if I'm on a jury, I'm looking to be told what a reasonable officer would have consciously done to avoid this outcome. I've yet to see that at all. R. Bailey says, ask yourself this question. If tasers did not exist, would Potter have been justified simply shooting right? I think so at this point, based on what I've seen. I'm, happy to see some mitigation, but Wanton Samurai says, Judge said, look at these photographs. Nickelback fan confirmed. Mathiadon says, does Potter have a case to union funds for defense or have access to union funds? I don't know.
I don't know either.
Not applicable says crying female could be genuine. No way to know. Deleotech. Turk says, super chat for not charging chat $500 an hour. Jonathan Bailey says, Nick, does the police union pay her legal costs? Donna Deal, thank you for the donation. Pete Hill says, Andrew, I paid for a second book because I believe in your message. Just got the books yesterday.
Glad to hear
STFU says, I bought 3 copies of Andrew's book for CCW family. Kyle Bogue says, I had the same thing with the 1990 Mercury Sable, same as a Ford Escort. Cruise control went nuts in the middle of Champlin. Driving down city streets doing 50 miles an hour, was 18 at the time, panicking, scary AF. Yeah, you're like, oh, my brakes are going to give out and I'm going to die. That'll be great. News Now My Wyoming says, I currently carry a SIG P365. I used to own 25 different models, rip boating accident, and I have never had such good grouping in my shots. Jeremiah Maddox says, any negative thoughts on a pistol red dot? I'm carrying P365 XL with SIG Romeo red dot sight.
So I carry a red dot on my 320. It's just, it works better for me than iron sights at my age, 56 years of age. I don't see the front sight as clearly as I used to. The dot works great. I will say that I don't know, but I've been told that the SIG Romeo sights are not all of equal durability. So I don't know enough to tell you which ones are. When I get my 365, I'll certainly put a red dot sight on it, probably a Holosun 507 rather than the SIG sight. But we'll see. But I like the dots. The thing is, the dots are they do take commitment to practice with them. They're much less intuitive in rapid use than iron sights.
Joe Taylor says, I just close my eyes when I shoot, actually. So I don't, who even needs sight?
Very smart.
Joe Taylor says, just looked on their site and they have non-permit plans that include constitutional carry. Well, there you go. Perfect. STFU says, whoa, Nick, your third-party female filming sex encounter situation sounds exactly like what the Ghislaine Maxwell prosecution is accusing her of doing. No, not quite. That she was a recruiter, I think, is the main claim. She was inducing the act, whereas this person is saying a third-party friend or would be involved to as a witness. Again, that person's sex life is much more interesting than most people's, I think. XSSFD 132 says, do you have any recommendations for New York residents with the basic banning of CCW insurance? Do you have a carry permit in New York? Those are hard to come by.
Upstate New York, you can get them, not in the city. I mean, my recommendation would be to do what I did, which was move out of New York.
There you go. Chris Bro, aka Mr. Platinum, says, why wouldn't they move Mr. Wright to the rear of the vehicle before making the arrest? It's a good question. Why they, or even just close the door. I mean,
that was Nate's big point, was that they should have closed the door, because it makes it a lot harder for him to get back in and turn on the car and do exactly what he
there's
did.
Zero good reason not to close the door. There's lots of good reasons to close the door. He can't access the inside for weapons and whatever, and exactly what this happened. So it was a poor tactical decision by Lucky, but arguably not the responsibility of Potter.
Right. And he was actually, he did appear to be clear of the door too. Like Floyd, Floyd was a different car, but they didn't close his door while they were trying to cuff him, but he was standing in the doorway.
Mhm.
This is one where they probably could have done that, but maybe who knows? Maybe he thought taking a hand off of, he had the cuffs in one hand and the other hand on him. Maybe he thought taking a hand off was too risky. We'll never know. Me Flowers says, might he have survived if no drive away and immediate medical attention? Unlikely from the shot.
No, that he was dead the moment the gun went off.
Yeah.
I mean, not dead yet, but mortally wounded.
Like, we're talking, I said minutes earlier, but you're likely talking less than a minute until he's dead.
It's however much oxygenated blood he has in his system when the shot went off. That's it.
The Raging Majority says, my dad used to carry a baseball bat in his car instead of a firearm. Could he have been charged if he told someone to back off from his car while brandishing the bat? Yeah, you could be charged for that. You might be justified in doing it, but you could be charged, sure. Alpha Geek to you says, for the defense, training is done to mitigate liability. Thinking cannot prevent accidents. Polar Bear Diego says, Nate, show me the way to MAGA country, my brother. Evie Warner says, can I hire Nate the lawyer to be a singing telegram to perform MAGA country? John Andrews says, Andrew, any thoughts on revolvers for self-defense? I know you said you keep your gun boring. Nothing says boring like a Smith & Wesson Model 10.
Yeah, there's nothing. I mean, the revolvers are fine guns. I mean, people defended themselves. Police carried them forever, right? Until the semi-automatics came along and things began to change in the 70s and 80s. Plenty of people have been killed dead by revolvers. No question about that. The only
Ask
limits
Alec
are
Baldwin, am I right?
Yep. The only real issues to think about are, it's very limited ammo capacity and very, very slow to reload. And they're not as immune to malfunctions as many people think.
Big Irish Jim says, repeat, I asked before court resumed if Kyle Carruth was interfering with custodial transfer. Okay, we covered that one. No is the answer. It would not negate self-defense. Mac Medic at 892 says, your thoughts on restoring firearms rights to people convicted of felonies who have served their time?
I mean, first of all, I think the blanket felony gun ban is ridiculous. I think if anything, it should only apply to people who've been convicted of violent felonies. Plenty of felonies are not violent felonies, but you face the same gun ban. And in terms of violent felonies, my position is if the person is so dangerous that you don't want them to have a gun, they shouldn't be out in public. Because once they're out in public, it's impossible for you to keep that person from getting a gun.
Yes, I agree. I mean, maybe you have them during probation or whatever, because they're being monitored and have to report in. I don't know. But once they've served their time and the sentence is over, which right now means the end of probation, then, or probation and parole, then yeah, I actually am not opposed to people having guns. Again, I agree with you. If they shouldn't have their constitutional right, then take it away by putting them in prison.
Hey, I'm going to head out.
Yeah.
But this has been wonderful. Thank you so much for having me on.
Of course. Catch you later.
And yeah,
Have a good trip.
So thank you. So
Where are you going
Monday
to, by the way?
California, mostly California.
Oh, you're going to California. Where are you now?
I am overseas. I am in Europe.
Oh, I did not know that.
Yep. Yeah, that's why for me it's really late. That's why like I see in the chat sometimes people are like, "Oh, she looks high." No, I'm just sleepy, guys.
Well, a decade ago, I lived 2 years in the Netherlands, and I loved it. It was a great experience.
Yeah. No, it's wonderful. But I'm excited to see some family. So it's going to be great. So anyway, I might pop into the live stream, Nick, next week. So from time to time, but no guarantees that I can do a full day. Since,
Well, anytime
I
that
only
you
see my
share with
family
us,
so often.
yeah, anytime that you share with us would be a welcome addition, but certainly, obviously, spend as much time with your family as you can stomach. All right.
All right. See
you
ya.
later. Yep. Bye. Kathy Zapp says many totally innocent people accept a plea to get out from under the abusive, onerous, and absolutely outrageous treatment they receive pre-trial by the prosecution in the court. Abe Eckstein says a neighbor of mine got into a fight with a coworker. Oh, wait, I read that one. Let's see. Brian Neal says, can you be arrested for watching questionable hentai porn in the United States? You can be arrested for it. Whether or not they'd be able to sustain a conviction is a completely different task. The question of can you be arrested for, the answer is always yes.
Yeah.
It's everything that happens after that. Remember, lots of justified, for example, I would generally say that people who are pulled over and get offered a field test, depending on your state, may not want to take those field tests, even if they have not been drinking a single drop. But you have to realize you'll be arrested for that. You may be completely sober, dry, you never had a drink of liquor in your life, but you're tired or whatever, and they think that you seem drunk, and so they ask you if you want to do the field test, and you say, no, you know what, officer, I'm not going to do that. Then they go, okay, well, they're going to arrest you and take you into the station and make you either do a blood or an intoxilizer or urinalysis or something like that. So the arrest is not the issue. The issue is always, will you be guilty after, and how much inconvenience are you willing to accept in your life?
People put way too much concern into the whole arrest thing. It's one of the most common questions I get. Hey, if I'm involved in a use of force event, what can I say to not get arrested? It's like, Jesus. I mean, first of all, you never talk your way out of an arrest. If they've decided to arrest you, you're getting arrested.
Yep.
That's it. And anything you try to say to avoid arrest is much more likely to sink you on the conviction side.
And similar with searches, if a cop is intent on searching you or your vehicle, they will search it whether they have the legal authority to do so or not. Right. It is not worth you levying a brilliant Fourth Amendment argument to the cop. I mean, that worked in Breaking Bad, and it was a great scene because it was a great question on the Fourth Amendment and searching a stationary mobile home. However, in general, you're not going to be arguing your way out of a search. Now, that's why I suggest to people, again, refuse consent to the search. If they have the cause, they'll get the warrant if necessary, or they'll have a warrant exception. They'll do the search, or they won't, and they'll do the search, and then you might get off of any potential crimes. But
and people need to keep in mind that, like the general population, fully half of police officers are less than average intelligence for police officers. So you may just have run into somebody who doesn't understand what they're allowed to do and not do, and they're going to do it anyway. It doesn't mean they're right, but are you going to fight them on the side of the road over it?
Are you going to get shot over it? That's where I always go with this stuff. You know, every minute of that encounter and the escalation of that encounter ends up with you closer to being Kim Pottered. That's not a current medical term, but it will be. Sarah Marie says, so nothing gets done to shady prosecutors that lie and twist things beyond all recognition. There's no monitoring to make sure the job is done right. No, there is, but nothing gets done if the defendant gets off. That's the main thing. A lot of bad prosecution leads to a defendant having a mistrial and going away. But once the defendant's gone, their concern in the prosecutor typically disappears because they don't, they're more concerned with them going to prison forever. Once they're out of that, they're happy to be out of that system. Trisky says, this defense attorney looks like a baby binger with no stash. Oh, that was the prosecutor. Circle of Snakes says, lawyer looks like a scuffed Chris Hayes. Catherine H says, what is he trying to get at? All of this has been gone over with the other police witnesses. Why is he droning on and on about information that's already known? Warren Lee says, at Nate the lawyer in MAGA voice, the Smollett verdict was a magnificent. Razor 390 says, the state attorney looks like the kid that wears an improperly sized suit, but his grandma still calls him the most handsomest boy and gives him a cheek pinch and a forehead kiss. Goofyfoot says, ask him if he puts the lotion on his skin. Hola Kyle says, do they need a volunteer to teach the judge about plowing? No, stop. Harry Bolognese says, twisting up a fat doob, enjoying the stream. Aurora says, thanks for covering and informing people about how the court works. The Buzz CJC says, this DA deserves the resting Tucker face they're getting from witness. Azutone says, can you object to a witness when they're called? Yes, you can object to a witness. But you probably should have objected prior to trial.
Right. Because you got the list. I mean, that's why that information is exchanged beforehand.
But if by some miracle you learn something new about a witness that would disqualify them in some way, like that morning they got convicted of fraud or something, and they walk into court right after that to be a witness. I mean, in theory, yeah, you could object. Stephen Cannon says, is the prosecution trying to stretch this into Christmas for a hurried guilty or compromised verdict? Goodness, I hope not. Doug Murray says, Nick, would you please explain just how much of an expert would you consider yourself to be in bird law? I know a thing or two about bird law. Evan Bushong says, as Richards, Your Honor, I object to the witness's bow tie. Would like it stricken from the record. Healthy Palapa says, thank you for the entertainment. Dave says, will the state bring up the fact that Kim's grandfather, Old Man Potter, once stole 10 grand from George Bailey, which caused him to leap off a bridge? B.A. Krim says, the BCA investigator's body language is telling me he's uncomfortable being there testifying, looking down, smirking, etc. James Knoll says, who is this guy and what is his relevance? Good question for every witness, just about.
Yep.
Michael Flanagan says, how does this time wasting not infuriate the jury? Angel of Sin says, swap the judges from Rittenhouse and Potter. What happens differently?
I'm sorry, what was that?
Swap Schrader for the Judge Chu. So what happens differently?
It's impossible to answer because everyone's behavior changes then.
Right. Yeah. Correct. Remember that Schrader was extremely permissive with evidence. I mean, extremely permissive. So these objections would maybe have fallen on more deaf ears, for example. But he would have talked a little bit faster. We would have more jeopardy in court.
Fewer pauses.
News Now Wyoming says, last year I witnessed a car accident. Cop tried to take my dash cam. I told him to get bent, and I argued against the search warrant. Cam records 200 hours, including audio, and it could provide too much incriminating evidence. I won. Hey, good work. Admiral Nelson says, so Andrew, what you're saying is that I should carry a 3D printed gun.
No, I didn't say that. Do whatever you like, I guess.
John Murphy says, please thank your family for providing us viewers your time and talent. I've really enjoyed your content. Cheers. Hey, thank you. Nick Candle, message retracted. Nicholas Cruiser says, do not visit Judge Chu's Super Zonga page or Binger's Bing Bing Wahoo MySpace page. General Sorty says, if I were a juror, I'd be so bored by the state's questioning. I'd want nothing to do with this case outside of the court. James Knoll says, what was the point of the last witness? I genuinely don't know what the BCA guy's purpose was. They didn't use him to introduce evidence, which is what you'd think you would do with a BCA investigator, but okay. Trisky73 says, fast facts. She must not use Firefox. James Knoll says, is the state trying to prove that the officer didn't have the right to use lethal force? Please help me understand. I mean, they want to do that, but they also want to prove that she didn't have the right to use any force. That's their first degree charge. General Sorty says, prosecutors wasting so much time. Minnesota going to have to raise its tax rates again to pay them. Ordcestis says, good to see Natalie join LawTube. Welcome. News Now Wyoming says, I don't agree with Natalie a lot on a serious legal conclusions, but I absolutely hate spark of life arguments. DG McBride says prosecutors have unlimited resources. They are not constrained by budgetary limitations or time constraints, as defense counsel often are. Pride or Honesty says, I would not want a bench trial in a politically motivated case. Too much pressure on just one person to stay fair. Mr. Tibbs says, Natalie, do you believe that Kim Potter is criminally at fault? Also, Natalie, an officer chief witness today, said the gun would be justified just today. So she would have been justified using the gun too. Well, to be clear, someone testifying that she would be justified doesn't actually make it justified. But if they testify they believed that she used it properly, then her belief is more likely to be reasonable, if that makes sense. Hunter says, ever think that this might be a situation where she was trained to pull a firearm but tried to pull a taser instead? Well,
it could
says,
be.
She says taser, though. I mean, like, she seems that she is wanting to pull a taser.
Right. I mean, the brain does weird things under stress, right? So
right.
To the extent she's had scenario training, and some departments do scenario training, she might have been in a scenario that replicated this circumstance, right? There's a suspect struggling to get back in a car. Your partner's halfway in the vehicle. You have to stop him. Under that circumstance, go for the gun. Now she's thinking in her head, I'm going to go for the taser because I don't want to kill this kid. But then she ends up doing what her brain was previously programmed to do.
That would be fascinating evidence if the instructor testified that they had that module and they could show that she trained with that module. I mean, at that point,
game over, really.
Yeah. Coltrane says, we're all human and deep down we all have primal lizard brain that still plays into our choices, especially during stress. Correct. Ron Green says she was behind a desk for 25 years, administrative in the police department, only a street cop for a little over a year. Mike Fenn says, unrelated, but prayers for Indiana, Illinois, Kentucky, and Tennessee. Monster storms expected tonight. Michael Kupka says, are tasers considered weapons in Minnesota as they are considered deadly weapons in many other states? So if a taser is justified use of a deadly weapon, that also cover a gun. They're weapons. They're not, I don't think they're considered deadly force. They would be considered less lethal.
Yeah, we've spoken to this before. It's like many less lethal weapons, they're capable of lethal use. I mean, anything, a plastic shopping bag is capable of lethal use. In their normal use as trained, they ought not result in death. So they're treated as less than lethal weapons.
Plastic shopping bags are only lethal in the hands of a man named Guido. SSM 930, thank you for the donation. Snuggle Struggle says that any expert would admit that accidents happen. All you can do is mitigate risk by repetition and muscle memory, but never remove. Humans are fallible. Even Tesla's self-driving whips are broadsiding buildings at 60 miles per hour. Zechariah Kitzman says, we train with taser once a year, firearms multiple times. Kim probably made mistake from muscle memory. Still right to fire her. Bad mistake, but more understandable than the perception. And again, I don't think they even fired her. I think they asked her to resign type thing. And 26 years, she probably got her pension. I don't know that for sure, but
I would think so.
It's like, so that's the type of outcome you want. Look, I'm not even sure they would have had to ask, frankly. Once this is all said and done and she goes through the trial, she probably would have resigned anyway because the trauma and the negative
But you can't
emotion.
stay. I mean, you can't stay on the department.
Right. News Now Wyoming says, I want to know if their hands-on training, they spend hours every year making a decision to pull the gun or the taser. They should, but do they? It's like an hour.
Right.
I think the taser training's like 3 hours annually, and it's 1 hour of practical and 2 hours of videos and paper.
Yeah. I mean, really the defense should have like a demonstrative exhibit they use at closing where they say, all right, the state wants you to believe she's been trained on this every year for 26 years. This is how many hours are in 26 years. And this is how many hours she spent actually being trained on a taser. And it would be an infinitesimal portion.
Jonathan Duger says, even the most trained group of people blow up 7 kids and an aid worker with a drone strike. Yep, that happened. Terry Bell says, a perfect expert for defense would be John Black or whatever his name was from the Defense in Rittenhouse.
He could do the timing between the various events in the video.
Do it very, very sardonic too. No, you see what we have here is a different in time. that's sliced out frame by frame. And when you break the frames down, now you have to understand that some videos played at 24 frames per second. I wanted that guy to testify about the use of force. I reached out to him, but I haven't heard back. I would love to talk to that guy just in general. I think he's got a lot of experience.
So I don't know him personally. I never worked on a case involving him, but I've had other lawyers whose opinions I respect tell me that he's really good at his job.
Yeah,
it was see it in that trial.
He was hamstrung
Yeah.
by the defense.
Yep. I
It
think
was
so.
weird. Intermediary Joe says, could there be a self-defense jury instruction? I mean, I think defense of others is going to be on there. Whether, I don't know if they're going to get a deadly force jury instruction for defense of others, but they should probably get a defense of others jury instruction. They've got the facts for at least defense of others, if not both. Roger Smallman says they are going for her shouting taser made other cops lose the perp, losing control of him, causing the accident and death. The gun is a herring. Jeffrey Grajic says Dante Wright caused all of this. He had no regard for anyone else's safety, especially the girl in the car with him. 2012 Jameson says there can be political non-prosecutions. There are.
Oh, for sure.
Yep. Intermediary Joe says, is there any chance the judge will issue a self-defense jury instruction? Just answered that. News Now Wyoming says, ask Natalie about the littering case in Middleton's court. Andrew, she's not here. Andrew Rohn says, I'm wondering if the prosecution knows they don't have a case, but they are going to bring every witness they can to testify, take more time, redirect as much as possible, drive costs up for Potter. Factory Speed says, can you explain the Sixth Amendment and the right to a public trial versus having cameras in the courtroom, please? Well, your Sixth Amendment right to an attorney and the right to confront your accusers isn't necessarily a public trial, but the right to a public trial is something we kind of at least infer from the Constitution. The difference between having a public trial and having cameras is the difference between being in public and having your public activity broadcast.
Right.
You can be in the park, you can be in any city park you want, but having your city park activities broadcast to the world might be a step farther. I think it should happen in court, but there is a distinction. Tim Herrera says, for one page of juicy transcripts, he sent $4. Daniel Arendt says, Bilbo Baggins style lunge and hiss. 2012 Jameson says, I have no problem offending journalists. Mike Fenn says, Andrew got my books yesterday. Cryptic
By the
says,
way, someone asked in the comments, here's the book, folks. Real book, not an ebook or a PDF or something. lawofselfdefense.com/free book. Or if you want, go to Amazon. They'll sell it to you for $25 plus shipping and handling. So we only ask for the shipping and handling.
Cryptic says, will you cover amateur corn star Zeminski trial? If Zeminski's trial is covered, is broadcast, yeah, I would love to. Same with Dominic Black. I think it would be a nice closeout to the Rittenhouse series. Alex says, Natalie said she knew the prosecution wouldn't take the second mistrial and the judge was out until jury was back. Not sure how she was so confident. Yeah,
it's an opinion, you know.
Plebeian says Scots law is very different from English common law. Cassandra Fuji says, how do we know why the car just took off? I don't know that I guess in theory we don't know why the car took off, but I think the strongest inference is that the driver stepped on the pedal after putting the car into drive.
Yeah, I mean, we're making an inference from his resisting arrest and fighting to get back into the vehicle, presumably not so he could just be arrested.
Right. Silo 101 says, have you played Halo? Sergeant Johnson is looking pale. Travis Allen says, can I have your foot pics? Asking for a friend. LMC Jr. says, Andrew, any chance of Washington State getting CCW safe anytime soon?
I don't have any idea what Washington State politicians would be inclined to do. Again, like New York, I would move.
Ginver says, Zulu as the phonetic alphabet standing for the time at 0 degrees longitude. Stephen Carpenter says, Potter knew there was a restraining order and a gun charge. Not much of a stretch to believe Potter may have thought she was stopping a kidnapping. Yes, they discussed that. We have to ID the female because we don't know if she's the OFP.
Right.
Mac Medic says, thoughts on restoring firearm rights to those who have served their sentence sometime after, especially since mentioning police have no duty to protect. We covered that a little bit ago too. Bryant McCracken, we're getting to the end here, says, do you believe time will come where attorneys will rely on these sorts of LawTube legal analyses to supplement traditional consulting? It's already here.
It happens to me. I mean, there's plenty of cases where, I could have expected to have been retained as a consultant, but by the time the trial starts, I'm publicly commenting on it. They'd be insane to pay me money for what they can get every night for free off my blog. I mean, but that's fine. I'd rather be doing this, to be honest, because when I do if I'm consulting on a case, I can't publicly talk about the case, or at least I won't, even if I were permitted to. I would never ask a client to allow me to publicly comment on their case. And then I'm helping that client, hopefully a great deal at considerable expense to the client. But I'm only helping one person. When I can comment like this on a stream to, I don't know, how many people are watching this today?
We're currently at 6,800, but we were at, I think we passed 13,000 earlier.
Okay. So that's 13,000 people today who are learning something about the law and use of force of law in particular, that maybe I can help them from getting in trouble in the first place. So it's just much more efficient in terms of my core mission, which is to try to keep law-abiding, well-intentioned people out of prison.
Yes. Let's see, but we also saw it happen in the Rittenhouse case. I mean, that it did happen. They have talked about, or Wisco talked about how, I don't know where they saw it, but we saw some of that crowdsourced commentary coming in wherever they got it from. Slinks, thanks for the sticker. Eric Chieftain says, I was stopped in Florida for speeding as a tourist from Norway. Officer wrote on the ticket, speed 78, actually 80. Limit was 40 because I was leaving the U.S. 2 days later. Got a $210 ticket. Lame. Terrence.
No points, though.
True. Terrence Folderson says, probably already been asked, but why won't Gage face charges for aggravated battery? Seems logical, especially since he admitted it under oath, because the prosecution's not interested in prosecuting him.
Right.
And as you'll find out if you watch tonight, Binger still thinks Kyle is guilty. He thinks Kyle's the bad guy in this situation. Let's see. Sean Haruki says, hey, Nick, if you got time, can you look into Totally Not Mark's situation? Over 150 of his videos were taken down a single day by Toei Animation due to copyright. Thanks. I did see something about that. I'll see if I can look into it. Beta Dan says, will you cover the Chris Chan trial if it's televised? Yes. Scott Allred says, hashtag Kyle's Law. Now, you have a proposition for Kyle's Law related to...
I do. People can read about it. And I don't claim any ownership over this, by the way. There's other people doing similar efforts. But if people go to lawselfdefense.com/Kyle's Law, they can see my proposal. I've also embedded there the actual bill from an Oklahoma state senator who's apparently filing a Senate bill in the state of Oklahoma to do something similar. It's not quite what I propose, but similar enough. And it's embedded there and you can see it. I'm not a politician, folks, and I'm not someone who drives legislation. I just wanted a place for people to kind of go to and find a definition of what Kyle's Law might look like. And hopefully other people who are in the political game will take that idea and run with it.
Malik Foxon says Zulu time equals Z time, which is short for Zero Meridian. Thank you. Dusty Def says, my uncle got a 500 Smith & Wesson 3-inch as concealed carry. I bought him the 700 grain cartridges as an extra gag.
What was the gun? Oh, 500 Smith & Wesson.
Yeah.
It's a big hand cannon for sure.
Oh, okay. Forever Cuber says Nate's point on police tactics seemed to warrant some further discussion. No, had the police walked him to the back and closed the door, Dante wouldn't have had the opportunity to escape. I mean, they're fine for discussion for training purposes, but they're irrelevant to the case because the question is not what the police should have done leading up to Kim Potter pulling the trigger. It's, did Kim Potter do the right thing in the moment she pulled the trigger?
Right.
So if she was affecting the arrest rather than Officer Lucky, then her actions affecting the arrest would have been a little more relevant. But right now we ask, does she let this guy go because Officer Lucky didn't bring him to the back of the car? No. They don't have a duty to bring him to the back of the car. Doesn't get a get out of arrest free card because they didn't bring him to the back of the car. They just should have, because it would have been a better practice.
Yes.
Agent Orange says Judge ASMR wants to be teabagged. Stop it. Robin Sage says legal bites. His eyes are glazing over with the gun talk. Renal Ryan says, Andrew, would you recommend a scope or red dot sight for my minigun? Also looking for a reliable shoulder strap. Crusader says, one time someone tried to mug me, so I pulled out my 5.57 and shot them. I only had $20. My face when I realized it would have been cheaper to give them my wallet.
There's a lot of truth to that.
Big Irish Jim says, "Forgive me for being both impatient and ill-informed. Keep up the good work, all of you." No, you're fine, buddy. Jacob says, "This trial is so boring. I would rather work at work than watch these cases." Dave Ewing says, "Andrew, thoughts on a CCW gun mounted camera that would record anything the gun sees?"
Again, I get a lot of gun questions, but I don't claim to be a gun expert. I will tell you on my carry gun, other than the dot, which is for sighting the gun, I don't hang anything off it. I don't even hang a light off it. I don't want anything on the gun that might interfere with its reliable functioning. So I would not recommend a camera.
And a
But of course, it's your gun, so do whatever you like.
A prosecutor would point to that as some indication that you sickly enjoyed pointing your gun at people and recording it
Yeah,
for your
could be.
later enjoyment of, you could watch your murder over and over. Like,
And you're not recording anything unless you're pointing the gun at it first, right?
Right.
That's another problem. So
Yep.
it's not like a body camera on a cop where you're recording events leading up to the gun pointing.
yeah, there was some prototype glasses or proposed prototype glasses that had a camera that tracked your irises. And then it had a camera on the front looking out, and then it had AI that would see and determine where you were looking from the camera watching your eyes, and actually shift the camera, and it had a little box that tracked where your eyes were focused. That would, I mean, but again, you're adding a lot of stuff to any sort of situation that you're in that you don't need to do. Bill in SD says, "Thoughts on James Duane's right to remain innocent or his video Don't Talk to the Police, worth it or question mark?" Is the Don't Talk to the Police that really famous one?
Yes, right.
That's
and
a great video.
I did a very lengthy debunking of that in the context of use of force. I think his advice is generally solid, and
Yeah.
he's not speaking specifically in a use of force context. But I think, well, what can I say? I mean, his video has 1 million views. I'd be surprised if mine had 10,000. Maybe his has millions of views now. But I did disagree with some of the points he was purporting to make in the context of a use of force event. And I've reached out to him and asked to talk to him about it, but I guess he's not interested.
Yeah, the interesting thing is with a use of force instance, I mean, you should do it with an attorney present, but you're going to end up talking to the police. And a lot of times, if you're lawfully using force, you're the one reporting it to the police.
Right. I mean, that's a question I always have when people say that. Say nothing to the police. I'm like, well, are you going to call 911? Because if you do that, guess who you're talking to?
When I talk about what people should do after a self-defense shooting, which is just a very basic overview of it, it involves, like, you're going to call the police and report that you very carefully say, I had to defend myself. I need assistance. Here we go. Here's where I am. Here's what I look like. That's about it. I mean, you don't say much else until you get an attorney, but if you don't report the fact that you shot someone, that becomes a big problem for you later on. So,
and you have to presume these days you're being recorded and they're going to find you. So just walking away may not be a solution. And people need to keep in mind too, there's different police interactions. It's not just one interaction. At the very least, there's going to be 911, and then there's going to be the responding officers in uniform who show up, and then there's going to be detectives. And those are 3 different things. Some of those you really, by definition, 911, you're not going to call 911 and be silent. You're going to say something, right?
Right.
On the other hand, the other end of the extreme, if a detective wants to talk to you and you don't have a lawyer present, don't say a goddamn word to a detective. I mean, that's just a professional interrogator who does not have your interests at heart.
Right. And in all of those cases, like, you report it to 911, when the officer comes, you exercise your right to remain silent. You say, I want my attorney. I'm exercising my right to remain silent. And we can talk at that time. And then that's it. That's all you need to say until you have your attorney. But you will end up, again, you'll likely be arrested, and at the time you are arrested, you will talk to police. Just the question is whether you have your attorney present for that. Once you're arrested, your rights shift a little bit. You don't have to say anything in particular, but they can bring you in for interrogation when you are arrested. You are not free to go. So,
and there are circumstances in which your silence can be used against you, folks, especially before you've asserted your rights and before you're being questioned as a suspect. By the way, believe it or not, as brief as we think the things you should say to police are, we spend about 45 minutes of our full day law self-defense advanced class just on interacting with the police in the aftermath of a use of force event. Again, you can learn more about that course coming up Saturday, January 8th at lawselfdefense.com/advanced.
No Sir San says, what if you don't have an attorney at that time? How do you get one? You assert your right to an attorney, and the state will have to provide one before they can ask you questions if you can't get one. But typically what they'll do is give you a phone book.
Yeah. The white pages.
Yeah. New dislike button says, I personally think cops should be allowed to go straight up to get into straight up fist fights if the situation calls for it.
They are.
New show Cops UFC edition. There is a video of a cop getting in a fist fight, which is great.
A cop using his fist is just another use of force that
Right.
he's allowed to do under appropriate circumstances. He can punch you in the face if you're fighting him and he's making a law. Believe me, it happens all the time.
Jide says, perhaps point out that the jury in closing that the duration of the trial dwarfs the time spent on training Potter and tasers over her entire career.
Could be.
That would be a great argument. Actually, that would be. We've spent 170 hours in this courtroom.
Right. And
Officer
since
Potter,
2002, when she first got a taser, she spent fewer hours in that in training.
she spent what 2002 to what 2021.
20 years. Yep.
You got 20 years at best, 60 hours. Like, let's see. Terry Bell says John Black's use of force and how people think expert testimony is what I was talking about. Think it fits perfectly. Topher Studios says, I want to go to vet school, but the loans terrify me. Did you take out loans for law school, and are you still paying? Thoughts, tips. I had a partial scholarship, I had partial family help, and I have partial student loans. So kind of all of the above. And yes, I am still paying on student loans. Student loans are, well, they're suspended during COVID, so it's great. You don't have to do anything anymore. Everything's suspended during COVID. Which is just government's just on shutdown, but everybody's still working. But thoughts and tips are again, go to vet school if you want to be a vet. You can make a lot of money being a vet. You can probably make more money being a vet than a lawyer if you, pretty reliably. But Mr.
Vet
Tibbs
school is a lot harder to get into.
Vet school is harder to get into than dentist school. Mr. Tibbs says, any updates on Dominic Black? Any motion to dismiss file? Not that I know of. I think they're continued till January 10th. So we should see something by then. Spenskaren says, Andrew, are you familiar with Georgia mom with twins from 2013? I'm closely related and interested in your take on the impact of that on gun legislation.
Well, I don't do gun law, folks. I mean, my expertise is use of force law, which is quite different. And I'm not familiar with a mother with twins in Georgia.
Okay. Crusader says, hey, Andrew, remember way back when you asked Nick how many kids he had and he smugly told you 5 and you loudly yelled, F? That was hilarious. Well, Bill in SD says, thank you both for the perspective. Cheapest not law advice I ever paid for. Loknav Livvok says, eye tracker can't verify that your mind registered the thing your eyes passed over. It would give the prosecution more ways to waste time like today. Yeah, I wouldn't suggest wearing anything like that. Neuropsychic final question says, should you notify an officer that you have a weapon in your vehicle when pulled over? Some states require you to do that. Although I don't know that they actually can require you to do that, because that sounds a lot like compelled speech to me. The ways a lot of people suggest doing it is, if you're legally carrying, is to just show them your concealed carry card along with hand them that with your license and registration or whatever. Personally, I think it depends on how you are with cops.
Yeah. So, I mean, not that I'm pulled over often, but when I am pulled over, I'm almost invariably armed. I carry a gun every day, and I've never lived in a duty to report state, so I've never had that issue. But I don't volunteer the fact that I have a gun on me. My car's off, my keys are on the dash, my driver's license, my registration, and insurance are on the dash when the cop gets up to the window. So everything's clearly visible. My hands are in plain sight. The only time I could imagine telling him is, one, if he were to ask explicitly, which I haven't had happen, or if he asked me to get out of the car. If he asked me to get out of the car, then I'm going to tell him, officer, I'm carrying concealed, I have a permit. How would you like me to proceed?
Yeah. And oftentimes, if they're going to ask you to get out of the car, they're going to ask you, do you have anything on you I need to know about?
Right.
You have a knife? You have a gun? Where is it? But I'm hesitant to volunteer that information because I don't see what introducing the knowledge of a gun into the situation does to help me or help the officer. But I'm law abiding in general. So that makes a big difference too. If you're not law abiding, that you might not want to, you might have different ideas, but I just don't think it helps. But that's it. That's the show. So thank you. You hung out the whole time. That was awesome.
I did. It was awesome. Yeah, it was great.
Were you able to tweet during the thing and everything?
I was able to do my normal thing. So that was great. Now I have to do a write-up for the end of day analysis. So that'll take a couple hours, but that's fine. Especially since court ended early. Works out just great.
Well, thank you. If you hang out for just a minute, we'll play the outro and then
Okay.
I'll say goodbye. But if you have to go, you can too.
Nope, I'm not in a rush.
To the chat, thanks for watching today, guys. And I will have a show late tonight at 11 p.m. Central Time. Probably be going over that Binger interview. Should be a gas. So if you want to come out, I'll see you then. Otherwise, catch you later, guys. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes madder, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an Ardbeg, a Balmore, a Lafroig, the spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter, as we hear law-splaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plentiful, from Dante to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea post on Twitter, as we hear law-splaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the